get my message? Okay. Oh, really? Okay, I think everybody's here. So this is 23 CF 475 State versus Josie Dikeman.
Matthew Torbenson and Emily Rood appear for the state. Also present at State's Council table is Investigative Sergeant Rich Amundson.
Morning, Your Honor. Chris Acker and David Bowles appear for Ms. Dikeman. Also present is paralegal Emily Sanchez. Mr. Bowles just needs a couple minutes before getting started.
Yeah, jury's not even up yet.
Okay.
Just so you know, but I did have a. Oh, they might. Anyway, now they are. I do have a question, and it's something that you said, Mr. Torbenson, during the motion to motion dismiss. You mentioned lesser includeds.
Yes.
And I just trying to be thinking in advance. Is the state thinking that you're going to be requesting a lesser included, or you don't know yet?
We are, and I drafted instructions for Your Honor with the language with all the lessers already. I think we would be asking for lessers on count 1 and count 3. On count 1, we would ask that it go all the way down to second-degree reckless homicide. On count 3, it doesn't change the substantive instruction on repeated acts. It changes the question on the bottom. It would say, did at least one act cause death? You must agree on that. If they answer that no, then it would be, did at least one act result in great bodily harm? You have to agree on that one. That would be the lesser included. It only adds a question.
Okay. Would you mind sending that?
I can send it to everybody.
To everybody. And it occurred to me, I don't know, somewhere in 2 in the morning, maybe when I woke up and thought about it. I said, "Oh wait, they're going to be asking for lesser includeds." Should have asked you right there and then and there. That doesn't surprise me. I don't know what the defense thinks.
Judge, obviously there has to be grounds for or a factual basis to support conviction on the lesser includeds before the state makes that request. I mean, just off the top of my head, I don't know that the state can assert a factual basis for second-degree intentional at this point. As to count 3, I'd note that the lesser includeds is already kind of baked into the question of whether or not was this repeat child abuse and did it cause death. If that question is answered yes first and then no later, that's effectively a lesser included already. The other concern I would have is just examining this to make sure that with the various overlap of all of the possible lesser includeds that we're not getting into double jeopardy territory and having or permitting convictions on 2 counts where the elements overlap.
Judge, to be clear, I'm not asking for second-degree intentional. It'll go first-degree intentional, first-degree reckless, second-degree reckless is how I've drafted it. And that avoids any elements overlapping issues. They're different elements.
Why don't you just share it with us and we'll take a look and we'll go from there.
Will do.
Okay, I believe the jury's here. Are there any other issues we need to talk about this morning, Mr. Torbenson?
No.
Mr. Zacher?
Oh, yeah.
And just to be, I'm not trying to be rude, Attorney Rood or Attorney Bowles. I've just been addressing those two at the start. All right, and it's my understanding today we're going to be starting with the doctor.
Yeah, and I think it's appropriate if the court wants to briefly instruct the jury that because of the doctor's scheduling, we're going to break Ms. Dikeman's testimony, call him first, and Ms. Dikeman will resume her testimony after that.
Okay. I think that is appropriate. It's Dr. Rogue, right? Which doctor?
Dr. Christensen.
Dr. Christensen. I'm sorry. I don't know why I had that in the wrong person in mind. Okay. So we will we can bring the jury in. We'll start early. Okay, thank you, everyone. You may be seated. Before we begin today, first of all, thank you again for being here so much on time, and we're able to start a little bit earlier. The other thing is Dr. Christensen is going to be testifying this morning. The reason is there's a bit of a scheduling issue, so we'll be taking a break from Ms. Dikeman's examination and going into Dr. Christensen. The intention is we'll go back to Ms. Dikeman as soon as we're done with the doctor this morning. All right, with that, let's begin.
Your Honor, the defense calls Dr. Eric Christensen.
Yeah. It's right here.
Please raise your right hand. Do you solemnly swear the testimony given this matter shall be the truth, the whole truth, and nothing but the truth? Yes.
Oh, thank you. Go ahead. You might want to settle.
Thank you. Good morning, Doctor.
Good morning.
Would you please state and spell your name for the jury in court order?
My name is Eric Christensen. It's E-R-I-K. Last name C-H-R-I-S-T-E-N-S-E-N.
Doctor, what is your occupation?
I am a forensic pathologist.
And are you board certified in forensic pathology?
I am, yes.
What is your current position?
I am currently a full-time, well, actually part-time consultant in forensic pathology, where I am involved in the review of both criminal and civil cases involving deaths to assist the attorneys that hire me. Sometimes there are other people that hire me as well. I've been doing this as my only occupation for the last couple of years since retiring as the chief medical examiner for the state of Utah.
And Doctor, I'm approaching you with a document labeled Exhibit 311. Hand that to you?
Yes.
What is that document? Is that a fairly current copy of your curriculum vitae?
It's a couple years old, and it's missing the first 2 pages. But other than that, it's yes.
Thank you. Could you briefly describe your duties in your former role as chief medical examiner?
I was responsible for the administration of a statewide medical examiner system. Our office was responsible for the investigation of all sudden, unexpected, or non-natural deaths within the state of Utah. That annually was somewhere in the neighborhood of 3,500 deaths a year. I supervised the work of 10 other forensic pathologists, as well as full-time investigative staff and autopsy assistant staff, and then various other people, clerical staff and epidemiologists and others.
And I know you don't have an exact number, but could you describe how many autopsies you've performed during your career?
Somewhere over 7,000.
And have you previously testified in court as an expert witness?
I have, yes.
And does your work include investigating deaths involving children?
It does.
And does your work also include reviewing toxicology results?
Yes, that's a routine part of forensic pathology work.
In preparing for your opinions on this case, Doctor, what materials did you review?
I reviewed medical records for Alex Xavier, both his birth records, outpatient pediatric records, hospitalization records related to his broken leg, and then events surrounding his death. I reviewed the information from the La Crosse County Sheriff's Office, a number of reports, and then the autopsy findings from Mayo Clinic and their associated documents.
And that would include toxicology findings?
Yes.
And are these the types of materials that forensic pathologists normally rely on in forming opinions?
Yes.
Now, doctor, it is sometimes the case that a second autopsy may be conducted. Was that a realistic possibility in this case?
Not to my experience. Certainly by the time I was involved in the case, it was not an option.
And can you explain to the jury, you got into this a little bit, but what a forensic pathologist does?
Sure. So forensic pathology is a specialty of medicine, a subspecialty of pathology itself. Pathology is a specialty like surgery or internal medicine or pediatrics. And pathology is involved specifically with the understanding and elucidation of causes of disease, and forensic pathology is the application of general pathology skills to the investigation of sudden, unexpected, or violent deaths to evaluate them for trauma, with the ultimate aim of determining the cause of death for that individual, as well as what we call the manner of death, which is a description of the circumstances in which the death occurred. And that manner of death is a vital record function. It's something that we record on the death certificate by checking a box. It was either a natural death, it was an accident, it was a suicide, whatever it might have been.
And is your role to decide who is legally responsible for a death?
No.
And what does it mean when a death is classified as undetermined?
So undetermined is one of 5 choices for manner of death that we as pathologists have when we complete a death certificate. As I said, death can be determined to be natural, accident, suicide, homicide, and then the 5th option is undetermined. And undetermined is a manner that we use in cases where there is insufficient evidence to make a determination between 2 other manners. Most common example we see is probably an individual who has a history of substance use disorder, who is known to abuse, say, for example, opiates. But that person also has a history of depression and maybe even prior suicide attempts, and then that person is found dead of an overdose of opiates. In the absence of something like a note or something else to definitively help us know, was this just part of their usual drug use, or was this something they did on purpose at this time, we will certify many of those types of deaths as undetermined.
And the undetermined classification, that's used when medical evidence does not allow doctors to rule out multiple causes. Is that a fair
Yes.
statement, as you've indicated? Were you able to determine one definite cause of death in this case?
No.
What is your opinion regarding the cause of death?
I think this death is most appropriately certified as undetermined cause. That doesn't mean there's no idea what it is. Certainly there are many things that it is not. But ultimately, I think this comes down to a question of, the impact of trauma and the impact of drugs. And there's not sufficient information to sort those 2 out.
And were you able to rule out drug intoxication as a cause of death?
I'm sorry, could you repeat that?
Were you able to rule out drug intoxication as a cause of death?
No.
And what do you believe was the most likely medical mechanism of death?
But mechanistically, the findings are most consistent with this child having died of respiratory failure. There are findings of pulmonary edema, which does take some time to develop. There are also some changes of cerebral edema and other indicators that the death occurred over a period of time, was not an instantaneous event, and that's most consistent with a death from respiratory failure.
And so you would agree with Dr. Quinton that his autopsy findings demonstrate a gradual dying process?
Yes.
And were the findings in this case consistent with injury caused by lack of oxygen to the brain?
That was the ultimate cause of the brain injury, yes.
And would you agree with Dr. Quinton that there is no evidence of lethal traumatic head injury?
I would agree with that, yes.
And did the autopsy show any evidence that Alex Xavier had been strangled?
No.
Did the autopsy demonstrate evidence that shows Alex Xavier had been asphyxiated or smothered?
No.
And let's talk about blood loss. Can severe blood loss deprive the brain of oxygen?
Oh, absolutely, yes.
And approximately how much blood loss is typically required to cause death?
That really varies depending on which source you read. The trauma literature provides some guidance, the pathology literature also some, but generally speaking, the number that's discussed is somewhere between a third and a half of all of your blood volume, which that varies by age. Children obviously have much less total blood than adults do. Obese people have more blood than skinny people. All of those, there are a number of factors that go into how much blood you have, but if you lose between a third and a half of your blood volume, that certainly can lead to your death.
And approximately how much internal bleeding was found in this case?
The measured amount of blood was about 100 milliliters. And in a child of this size, his total blood volume would be expected to be somewhere around, somewhere over 1.5 liters, so 1,500 milliliters or more.
And was the measured amount significantly less than would normally be associated with death from blood loss?
Yes.
And now, is it possible that some internal bleeding may not always be fully measurable?
That's absolutely the case. So when someone is injured, for example, I mean, we're all familiar with bruises. If you have a bruise, there's bleeding into that tissue that makes that bruise visible. But there's not any way to measure how much blood that is. And the same thing happens internally. In addition to blood that may fill up in cavities that we can actually collect and measure, you can also have blood within the soft tissues. In this case, Dr. Quint described hemorrhage within what's called the mesentery, which is the supportive structures for the intestines and around the head of the pancreas and a few other places within the back of the abdomen. You can't also, just like you can't really quantitate how much blood is in a bruise, there's not a way to quantitate how much is in that space, but you know that it's no more than what the volume of that tissue itself would be.
And so even considering the possibility that there was, in fact, some unmeasurable blood loss, was there evidence suggesting that blood loss was severe enough to cause death in this case?
I don't believe so, no.
Now, can a drug overdose cause death by reducing oxygen to the brain?
Yes, that's probably the most common mechanism.
And can you explain to the jury how that happens?
Sure. Any number of drugs can do this, but alprazolam, which is a question in this case, also is certainly known to do it. Anything that causes your breathing to slow or stop can lead to respiratory failure. So opiates particularly are known to do that, to even stop your breathing. But alprazolam and the other medications in its class are also known to slow your respirations. And if you normally breathe 12 to 15 times a minute, but the drug has slowed your breathing to 3 to 4 times a minute, that's just not going to be enough to get you all the oxygen you need. It's enough to keep you alive for even an extended period of time before you would actually die from that, but it's not going to be ultimately enough to keep your brain alive or to keep your heart happy with. Those are both probably the two organs in your body that require the most oxygen.
And can overdose on alprazolam, also known as Xanax, can that slow or suppress breathing?
Yes.
Okay. And this would all be consistent with Dr. Quinton's description of this as a gradual process. Is that fair?
It would, yes.
And can alprazolam lead to hypoxic or anoxic brain injury?
Yes.
Can it also dull the senses?
Yes, it can make you, typical symptoms, especially an overdose, would be, drowsiness, lethargy, confusion, slurred speech, all the way up to coma and death.
And how about with regard to pain?
It's not a pain medication per se. It's not like an opiate. It's blocking pain receptors in your body, but because it alters your thinking, it can dull your response to pain, yes.
Okay. So let's move on to the injury findings. Alex Xavier had significant injuries, is that fair?
He had a number of significant injuries, yes.
And were those injuries consistent with blunt force trauma?
They are. Mm-hmm.
And does inflicted trauma necessarily mean the injuries were intentionally inflicted?
Can you ask that again?
Well, let me ask it a different way, but are you familiar with the ways that blunt liver injuries can occur?
Yes.
And can those types of injuries occur without somebody intentionally trying to kill a child?
Yes. So blunt injuries by their nature are nonspecific, with, a few exceptions. I mean, if, someone is stomped on with a boot with a particular pattern, that may leave a pattern that tells me it was that kind of boot. Or if someone is hit with an implement that leaves a specific type of pattern, then I might be able to say it's consistent with some rod-like implement or something sort of generally in that class of things. But for the most part, blunt injuries simply signify the interaction of a body with a blunt object. That can either be because the object is being moved against the person, or it can be because the person fell into whatever object it was. But the injury itself doesn't really tell you much about what caused it, short of a pattern that would reflect an implement, a specific implement.
And the injury patterns that you observed, would those be specific to one single cause?
No.
And would they be specific, strike that, can forensic pathology determine the exact time an injury occurred?
No. Really, the best we can do is broad swaths of time. So an injury can have characteristics of being an acute injury, meaning it happened, anywhere from minutes ago or seconds ago, all the way up to, even a day, would be, the sort of earliest, broadest category of what we can see based on those types of findings. As we start to see the body responding to that injury, meaning inflammatory cells come in and other things where the body's trying to clean up what has happened, that tells you that it didn't just happen, that it's been some number of hours or days since that happened. And then as the injuries then further heal, you start to see scar tissue and other things, and you know that those have been going on for days. But there's nothing you can look at pathologically that allows you to determine it was 3 hours ago or 5 hours ago or 12 hours ago. The best you can say with findings that suggest it just happened, that it's probably somewhere in the last 24 hours.
And so you indicated the time frame for the possibility of injuries that were seen in the autopsy would be 24 hours?
More or less. And all of the timing related to those things is subject to, the addition of other information. So for example, it doesn't necessarily apply in this case, but if there was video evidence that showed an injury occurred 26 hours before this, it could still be consistent with that.
Now, could any of these injuries be consistent with rough play between children?
Yes. Mm-hmm.
And could you describe those injuries?
Sure. I mean, any injury, really could involve any of the injuries this child has. Bruises, injuries related to the liver. It would depend on the nature of the play, obviously. A routine kind of play is not going to do that, but if somebody gets shoved over, knocked over, stepped on, other things certainly could lead to really any of these injuries. It's unlikely that that type of play would account for all of the injuries.
And if there was testimony establishing that the child's father had access to the child the prior evening between approximately 5:30 and 7:30, would the autopsy findings be consistent with injuries occurring during that time period?
Yes.
And could those injuries be consistent with being struck with an open hand?
They could be. Some could be, not all of them.
And others would require a different mechanism?
Yes.
Okay. And is it likely that multiple events contributed to the injuries?
Yes, I mean, just the distribution of the injuries on this child, from head to extremities and torso, and all the different places are not consistent with all of this resulting from a single blow, if you will, or single impact. Just by their distribution, that it required multiple specific discrete impacts to cause those injuries.
And does that require a prolonged time period?
No. I mean, it could be. You can't say that it's not. I mean, within the time frame of 24 hours, they all would look more or less the same pathologically. You can't really distinguish them that way, but just from the physical act of causing the injuries, certainly it could be quick or it could be protracted. There's not a way to know from looking at them.
And do these injuries as a whole prove that homicidal violence occurred?
No. I mean, it's back to that whole question of specificity. Blunt injuries are blunt injuries. If they are accidental in nature, which you can't tell by looking, or inflicted trauma, you can't distinguish that just from looking at them.
And did you find injuries that would typically did you find injuries that would typically be associated with an intentional homicide?
Objection, that calls for a comment on the mental state of the person. That's a question for the jury.
Well, I think he has experience with determining the severity of injuries and whether they're consistent with an intent to actually cause death. That certainly is within his
Not his
expertise.
job, he just testified to that.
So this is, I believe the question's about, there's the different use of intentional act versus non-intentional act in medical. Is that correct? Is that what you're asking about? Not the element, but the medical?
I guess the point I'm getting at is did the injuries demonstrate that the person who caused them intended the child to die?
Yeah, I'll allow him to ask that question.
So blunt injuries, again, are nonspecific generally, and cases that I see where the cause of death is distinctly or definitely results from violent actions, violent blunt force applied by another individual. I would expect to see more trauma in the head, more trauma in other locations than what I see present in this case.
And doctor, do the autopsy findings instead suggest another possible cause of death that was more likely?
Yes.
Specifically, would that be consistent with anoxic brain injury caused by alprazolam intoxication?
Yes.
And doctor, you talked a little bit about this, but I don't know if we got into all of the details. What is alprazolam?
Alprazolam is a benzodiazepine medication. It's used to treat anxiety by itself, used to treat anxiety associated with depression, and it's part of a class of other similar medications. It's one of the more common ones that's prescribed for that indication, and it has sedating effects.
Okay. And can you elaborate on those effects that alprazolam can have in an overdose situation?
Sure. Like I mentioned before, lethargy, inability, incoordination, stumbling, slurred speech is described, and then, on that spectrum, as person becomes more and more affected by it, can lead to coma and even death.
And you've indicated it can suppress breathing, and that would reduce oxygen flow to the brain.
It can, yes.
And can that lead to death?
Can that lead to anoxic brain injury?
Well, let me ask you, did the toxicology testing show alprazolam in Alex Xavier's system?
It showed, yes, alprazolam was present at a high level in his blood.
And what was the level of alprazolam in Alex Xavier's system?
The measured number was 250 nanograms per milliliter.
And you said the measured level, that was measured from a sample of blood taken during the autopsy?
It was a sample taken at autopsy of what was described as what's called cavity blood. So it was not blood that they were able to get from a vessel itself. And when you take blood from a cavity, it's obviously still blood, but you don't know necessarily what else it might be mixed with. Was there, fluid present in the pleural cavity before the blood leaked into there that you collected? And so it's not reliable as a means of determining specifically whether the level that you get. You just don't. There's not reference ranges for cavity blood. You don't really know what that number means in cavity blood, except that the substance is present in the system. But you don't know how that level would compare to a sample taken from a blood vessel.
And so in other words, we can't take that result and conclude automatically that that was representative of the level that was found in Alex Xavier's circulating blood.
That's correct.
Okay. Is it possible, however, that the level that you found was the level that was in Alex Xavier's circulating blood?
That's certainly possible.
and you indicated 250 nanograms per milliliter. What is the number of, or what is the level that is considered potentially fatal in adults?
So in adults, the typical range for toxicity starts somewhere around 100. Deaths have been reported at levels as low as 140 in adults. In children, we don't really have good reference ranges because it's, one, not a drug that children take very frequently. I mean, certainly I'm sure there are children that are prescribed it, but it's not something that there's a lot of data about, and especially not in a postmortem setting. And so we don't know necessarily what it means in children, but it's the level that is measured in him would be certainly very high for an adult and would be sufficient to explain that adult's death.
And doctor, can children be even more vulnerable to those effects?
It depends on the medication, but yes, is the short answer.
And is alprazolam overdose a reasonable explanation for Alexavier's injuries?
Yes, for his anoxic brain injury, yes. It certainly could be caused by that.
And can an overdose be accidental?
Yes.
Now, we talked about some of the symptoms of alprazolam. And you indicated it can cause lethargy, is that fair?
Yes.
Could it cause a person to be unusually difficult to wake up?
Yes.
And can it reduce responsiveness to pain or stimulation?
Yes.
And if there was testimony that law enforcement officers were present in the home between 7 and 7:30 and observed Alexavier they had very difficult time arousing him, would that be consistent potentially with alprazolam intoxication?
It would, yes.
And in failing to wake in response to a flashlight, that would be consistent?
It certainly could be caused by alprazolam, yes.
And would slurred speech before falling into a deep sleep also be consistent?
Yes.
And did you find any evidence, well, let me ask, would a history of a child waking up at night and getting into things also be important contextual information?
Yes.
Okay. And did you find any evidence that alprazolam had been forcibly administered?
No.
And what might you expect to see if that were the case?
So, in a forced administration, the assumption is that the person doesn't want to take it and they're resisting. And if you've had a situation like that, you might expect to see injuries around the person's mouth and other things of that nature, but there's no indication of that.
And let's talk a little bit about something different, about CPR. You're familiar with CPR, is that
yes.
right? And if there was testimony that Alexavier had either white foam or black liquid emitting from his mouth immediately after first responders began to move him to the floor and perform CPR, what would you make of that?
I mean, it would not really be unexpected. The most significant finding of those two that you mentioned is certainly the presence of a white foam is consistent with respiratory failure, but the presence of black fluid coming from the mouth doesn't really mean anything to me.
As an expert who looks at these things, would that prove that someone had not previously attempted CPR on Alexavier?
No, it would not.
And the black fluid, would that necessarily be blood?
No. I've had many cases over the years where a person had blackish material either on their face or coming from their mouth. The investigators at the scene had said, oh, we think this is blood. And, when looked at and tested, was not blood. After you eat something and it sits in your stomach for a while, a lot of things can give that appearance.
One moment. And doctor, there were bruises found on Alexavier in the autopsy, is that fair?
The other were, yes.
And bruises, do those immediately appear after an injury is suffered?
Not necessarily, no.
And could they be not visible after an injury and then appear later?
Yes.
And there was discussion also about a potential lethargy seen in Alex Xavier, difficulty in waking him when the law enforcement came through the house. Could that also be consistent with a concussion or mild TBI?
Possibly, yes.
And that can cause loss of consciousness?
It can. I mean, that's part of, how traumatic brain injuries can be defined as the length of unconsciousness associated with a concussive injury in particular. So.
Thank you, Doctor. I have nothing further.
Thank you.
Ross?
Morning, Doctor.
Good morning.
Doctor, you are retired from your job as a pathologist in Utah, correct?
I'm retired from my work for the state, yes.
Correct. And in your work for the state, whenever you performed an autopsy, you would have to author a report relative to that autopsy, isn't that right?
That's correct.
It's mandated as part of your work as a forensic pathologist that whenever you're performing an autopsy and conducting work, that you document all of your findings and conclusions,
Objection,
isn't
this
that
is
right?
irrelevant.
It's very relevant.
Overruled.
Correct?
So it varies from depending on where you are, but most states require that if you conduct an autopsy that you reduce the findings from your autopsy to a written report, yes. And that
You didn't author a report in this case, did you?
No, but I didn't conduct the autopsy.
As a defense expert, you have the ability to author a report, correct?
I do many times.
And oftentimes you are asked to write a formal report with your findings and conclusions, isn't that right?
Not required by the statute, and this is relevant.
Well, you didn't author a formal report. Go ahead.
You didn't author a report with your findings and conclusions, correct?
I did not in this
Did you
case.
provide any written statements regarding your findings and conclusions to the defense?
No,
You did not?
no.
Okay. So you provided no information to the defense in writing that the state could have and examine. Is that fair?
Yes,
Okay. All of the information that you provided to them, you provided verbally?
correct.
Okay. How much did it cost for your consultation on this case?
I don't know. I mean, I bill for my time and experience basically at a rate of $500 an hour.
Doctor, you know when you walk into this courtroom that I'm going to ask you questions relative to how much you pay, correct?
Yes.
Okay. And you came into court today knowing that I was going to ask these questions, and you are saying that you didn't figure out the amount, knowing that I was going to ask you these questions today. Is that right?
Well, I didn't know that you would specifically ask that total amount question, but I can give you a ballpark. I mean, it's...
Every time you testify as a defense expert, you're asked these questions.
No, not
No?
every time, no.
Okay. The majority of the time you testify as a defense expert, you are asked these questions.
Sometimes I am, sometimes I'm not.
Okay. And you said $500 an hour. How many hours did you put into this case?
I started working on this case in 2023. I would guess at this point I have put in somewhere around 20 hours.
20 hours?
Yes,
At $500 an hour.
yes,
On top of that, $500 an hour for 20 hours, you get paid separate and distinctly for your testimony today. Isn't that correct?
I don't get paid for my testimony. I get paid to appear and testify. What I say is not what I'm being paid for.
Thank you for clarifying that. You get paid to appear and testify, and that's at a different rate than that $500 an hour for 20 hours. Isn't that right?
No, it's the same rate.
The same rate. So the longer you spend on the stand, the more money you make today.
No, for court appearances, I mean, I still bill at the same hourly rate, but I bill it in half-day increments. So if I'm
Half-day
here for
increments?
half a day, then it's $2,000. If I'm here for a full day, it's $4,000.
So half day is $2,000, full day is $4,000. That's different than what you originally said. You said you originally would bill it out at $500 an hour. That's not what you just answered, though, is it?
Not exactly, no.
Not exactly, no. It's important in your profession to be accurate, correct?
I would say so, yes.
You're used to answering questions from attorneys based on your profession, correct?
Correct.
And I just asked you a pretty clear question, and you got the answer wrong. Isn't that right?
If you can interpret it that way, yes.
How do you interpret it?
My rate is, I answered the question related to how I bill. And
Don't bill $500 an hour for testimony. You bill half day or full day. I asked you how you bill for testimony, and you originally said $500 an hour,
Asked and
correct?
answered, he's
That's
battering the
correct.
witness at this point. Objection, asked and answered, he's
Sustain. Move on.
So you gave all the answers to the defense verbally, not in any written fashion. We covered that, correct?
Yes.
Ask an answer.
I was laying foundation for the next question.
Go ahead.
Now, this child suffered multiple blunt force impacts all over his body.
Yes.
Multiple to the head.
Yes.
Multiple to the side of the eye on different planes, isn't that right?
Yes.
Multiple that were revealed once his hair was shaved, correct?
Yes.
Multiple different portions of the head, correct?
Yes.
Each one of the bruises that are documented by Dr. Quinton in his autopsy is a separate and distinct blow to the head to Alex Xavier Pedron, isn't that right?
Yes.
An assaultive blow, correct?
I don't know. Can't tell from looking at them.
You can look at the fact that there's so many blows on different planes and different sides of his head that you can say it's not an accident, right?
Not necessarily. I mean, certainly the cumulative total of them suggests that they are inflicted. I will agree with that, yes.
Okay.
But any specific injury, you can't say that.
When you're practicing medicine, you're applying the differential diagnostic process, isn't that right?
Yes.
And explain to the jury, no, I'll tell you, the differential diagnostic process is looking at the child as a whole or the patient as a whole and their entire conditions correctly,
Yes.
and making a diagnosis as to what makes sense based on the entire clinical picture you're seeing, right?
Yes.
So we don't just look at one bruise on the head or one bruise on the other side of the head or the injuries to the organs. It's important to look at all of the injuries, the entire constellation of injuries on this child's body as a whole.
Yes, that is true.
And the entire physical injuries on this child's body, the constellation of injuries as a whole, demonstrate that this child was violently assaulted. Isn't that right?
Not word I would use. I mean, there's no question that his injuries in total are consistent with inflicted abuse, that he was abused.
Inflicted child abuse. Correct? He's a
He's
child.
yes.
All right. This is inflicted abuse of a child, right?
Mhm.
And we can also reasonably conclude that the medication, the Xanax that's in his system, he ingested, however you want to say he took it, that happened after the abuse, right?
Objection.
Actually, I don't think we can say that. We don't know either, within a 24-hour window, we can say when the injuries happened, but we have no idea when the medication was administered, either to him or he did it himself. We don't know.
You would agree that this is a very high level of Xanax in his system.
Well, it's a high level in his cavity blood that we don't know what it means with respect to his system.
You just testified under direct examination that this level in an adult could be toxic to an adult and maybe cause the death of an adult.
Yes, if it's a blood level. Yes.
And you also testified under direct examination that it's wholly possible that the result from the cavity blood may be the actual result that was in his system. You said that when they asked you the question.
Yes, they may.
It may be, right?
Yes.
Okay. Now, if this child ingests that level of this drug, it's going to make him symptomatic really quick. Isn't that right?
I don't know.
You don't know.
I would expect, so you can't infer from a given level in someone's blood how much of a dose they took. You know that you can say that a given level would require more than, say, one pill. But beyond that, you can't say, and because we don't really have good data about what these levels mean in children, there's not a good way to say what this specific level means with how much he ingested. With respect to your specific question of how soon he would be symptomatic, that would be a function certainly of how much he ingested, but I don't know how much he ingested, but it certainly could be quick.
Well, when people take medication, they don't take it so it can take effect 14 hours later, correct?
Oh, no, I would not expect it to take that kind of time.
Take it so it can take effect rather quickly.
Yes.
And Xanax is a pill that, Xanax or lorazepam is a pill that someone takes so that it can take effect within an hour or so. Isn't that right, in general?
Generally speaking, yes.
So you'd expect the effects of that pill to take place within at least an hour. Isn't that right?
I would expect so.
Now, you testified that, and going back to the injuries, and my question related to the injuries of this child, it doesn't make sense that someone beats a child after the child's unconscious from a pill, correct? That just defies logic.
That's correct.
That makes no sense whatsoever.
From a practical standpoint, I mean, that's a common sense opinion.
Yeah, so when we look at again, the entire clinical picture of this child as a whole, we can safely say that this child was physically abused and then was given Xanax afterwards or took Xanax on his own afterwards, which is your conclusion. Is that correct?
That certainly would be an explanation, yes.
Now, it's important when we're looking at how this child got Xanax in the child's system that we consider the fact that he was abused, right?
I mean, it's part of the whole context, yes.
We can't ignore that, right? Because that's not the practice of medicine.
No.
We have to look at those injuries and the abuse, right?
Yes.
We have to look at the severity of those injuries and the abuse, right?
Yes.
Those injuries are going to be symptomatic, aren't they?
I would expect there would be some symptoms, yes.
For example, a rib fracture. He has a fractured 10th posterior rib. That's a painful thing,
I would expect so.
even when he breathes, right?
Yes.
He's going to feel that pain.
I would expect so, yes.
Okay. You were asked questions relative to when he was observed by law enforcement and he was described as lethargic and things of that nature when law enforcement was on scene. Did you actually watch that body cam?
I did.
You did watch that body cam?
Yes.
Okay. You had the police reports relative to the statements of witnesses afterwards, correct?
Yes.
And you were aware that he was described as being awake and alert after that, correct?
Correct.
That would be inconsistent with him having olazepam in his system at that point, isn't that right?
Can you repeat that?
Yes. Him being described, Xavier being described as awake and alert for hours and hours after law enforcement came to the residence would be inconsistent with him having olazepam or Xanax in his system at that point in time when law enforcement came.
This is mischaracterizing the evidence.
I believe part of it is. There is a phrase that at some point he was awake and alert. Go ahead.
So sorry, can you repeat it again?
Let's just go over the time frame.
Sure.
You're aware that this defendant described that Xavier was awake watching TV with her until 3 o'clock in the morning.
Yes.
Okay. You're aware that this defendant described that she tried to put Xavier to sleep around midnight and he wouldn't go to sleep, so she turned the TV back on.
Yes.
You're aware of those facts?
Yes.
You're aware that this defendant's mother stopped by the house after 9 p.m. to pick up 2 older children and described Xavier as laughing and playing with the other children.
Objection, hearsay.
It goes to his opinion.
Overruled. Go ahead.
You're aware of that information, correct?
Yes.
You're aware that there's a phone call between this defendant and Laura Lee, her friend, at 10:30 at night where they both describe Xavier saying the same thing, that he wanted to get up in the middle of the night and get into some trouble, right?
Yes.
You're aware of all that information.
Yes.
And all that information flies in the face of this child having olazepam or Xanax in his system at 7 o'clock when law enforcement's on scene. Isn't that right? They opened the door to this. They absolutely talked about it.
Yep. Overruled.
So it doesn't, you know, I guess what I would say is it doesn't exclude the possibility that he took Xanax, but it certainly would require for him to be dead of it to have taken it again.
It would
After
require
that
what? I'm
time.
sorry, I missed that.
It would require him, if his initial lethargy and other things were caused by Xanax, and then he seemed to be up and moving around, and then is ultimately dead from Xanax, would require him to have taken more Xanax.
Taken more.
Yes.
Yes. And his sleepiness from 5 to 7 p.m. could be from the melatonin he took. Isn't that right?
Potentially.
You're aware that he had melatonin in his system, correct?
Yes.
One of the other toxicology findings in this case was caffeine. There was caffeine, presumptive positive for caffeine in his
Yes.
system, correct?
Yes.
You're aware that Xavier, one of the things or claims made was that Xavier would get up in the middle of the night, right?
Yes.
And he would look for things to eat or drink, correct?
Yeah. Correct.
And having caffeine in his system would be consistent with ingesting, for example, a Red Bull in the middle of the night.
It certainly would be. Mm-hmm.
And Red Bull has caffeine in it, quite a large amount,
It
actually.
does. It does.
I want to talk to you a little bit about the liver laceration. That would also be a very painful injury, isn't that right?
The liver itself, you don't have a lot of good discrete pain receptors within your internal organs. So from a pain standpoint, you wouldn't necessarily be able to say, oh, my liver has been injured, but certainly the bleeding that would be associated with that, blood within the abdominal cavity is generally, in most people, described as a painful thing.
Described as painful, correct?
Correct.
And he has not only a lacerated liver, but he has damage to other organs as well, isn't that correct?
He has some hemorrhage around his pancreas, he has hemorrhage around his initial part of his small intestine, and in the wall of his small intestine, yes.
There's been studies to demonstrate the type of forces necessary to cause liver lacerations or internal organ lacerations to children, isn't that right?
I believe there are. If I've seen them, it's been a while, but
It's something that would be important for you to know when you testify here as an expert regarding a liver laceration in a child, correct?
certainly it requires a fair amount of force to lacerate a liver.
A fair amount of force, right? We
Yes.
don't see children just coming into the hospitals on a daily or weekly basis with lacerated livers from minor trauma.
No.
It requires something rather significant.
Yes.
One of the ways that children suffer liver lacerations is when they ride their bikes and they come to an abrupt stop and their handlebars go directly into their stomach.
Correct.
That's the type of force it causes, where the handlebars go into the stomach and they tumble over their bikes, right?
Yes.
A real blow of something that's pushing the organs against the back spine, correct?
Correct.
That's the type of force we're talking about here.
That's an example of it, yes.
Yes, of what we need to cause these injuries.
Yes, and I mean, those types of injuries, bicycle handlebar injuries, certainly can be much more severe than what is present in this case, but the mechanism is accurate.
When we talk about the possibility of Xavier getting up and taking this medication after he suffered this beating, we have to take into account first that he's got a broken leg, correct?
Yes, I mean, it's healing, he's in a cast, but yes.
He's got limited mobility.
I don't know specifically what his mobility was.
Are you aware from the records that you reviewed, the law enforcement records, that he wasn't supposed to walk at all on that leg?
I seem to recall that now that you said that, but I don't remember specifically.
Did you review the scene photographs in this case?
I did.
Are you aware that he was supposed to use a walker if he was walking on his own?
I don't recall specifically whether he was supposed to or not.
Are you aware of where the walker was located by law enforcement when they conducted the scene
I do
investigation?
not recall, no.
Do you know that it was folded away and he wasn't even using it?
No.
There's no facts not in evidence.
I asked him if he is aware of it.
That's speculative. That's
All right. Overruled. Go ahead.
Not aware.
And just so it's clear, being aware or not aware does not mean the facts are in evidence. It just, he's not aware of it.
Xavier had bruising on his hands, correct?
Some, yes. Mm-hmm.
That's an additional area where he was assaulted.
Well-
Speculation.
Yeah, I don't know.
He says, I don't know, overruled.
An additional area where there's blunt force injuries noted on his body.
Could you repeat that?
An additional area where he has blunt force injuries on his body,
He does have blunt injuries, yes.
on his hands.
Yes.
The pill bottle that was located on scene, that had child safety locks on it, isn't that right?
That's my understanding, yes.
Okay. What do you recall about all the pill bottles that were located in the bag where that pill bottle is purported to have come from?
As far as purported to come from, I don't know. I mean, it was my belief, or my understanding is that the bottle found next to him was for prednisone, which was not tested for and not identified, whether he took any of that or not. But beyond that, I don't know.
You don't believe he was tested for prednisone on toxicology?
No,
Really?
really.
You sure about that?
Nearly 100%, yes.
That they didn't look for prednisone in Xavier's autopsy?
That's not a routine part of any forensic pathology tox testing that I'm aware of.
In this case, they had concern for prednisone, and you're saying that when they tested Xavier's toxicology, they did not look first for prednisone. As you sit there under oath, that's what you're telling this jury?
That's my recollection, yes.
That's your recollection? Yeah, I'm asking if we can just take a brief break. I want to get the autopsy toxicology report.
If you find it, go ahead. What's that?
It's important to get facts right when you're testifying under oath, right?
Yes.
Okay. And as you sit there right now, you're telling us that in a case where it was originally believed that this may be a prednisone overdose, nobody tested for prednisone. That's what you're telling us.
That's my belief, yes.
That's your belief. And it'd be important for you, before you take the stand, to review all the documentation and make sure that you have a mastery of the facts, correct?
Yes.
And if you got that wrong, that would be a big mistake on your part.
I don't know about big, but yeah, it would depend on the relevance of the finding.
Well, that was one of the original concerns for the cause of death in this case, isn't it? Prednisone.
Well, it was found next to him, and so yes, they would be concerned that he took it. I'm not aware of any cases of death by overdose from prednisone.
If you're looking for the autopsy report, it's Exhibit 27.
27. Blows to the head can cause swelling of the brain, correct?
Could you say blows to the head can cause swelling of the brain? By themselves, generally no, but
If there's multiple?
if there's what?
Multiple blows to the head?
It would depend on what they do, but generally speaking, no.
Doctor, you may be right on the prednisone. I thought there was a screen for it. So I'll come back to that issue. When we're talking about the investigation of the scene in this particular case, the rest of the pill bottles that were contained inside that bag all had the caps on them, is that correct?
Yes,
They all had the exact prescribed medication that matched the label inside, isn't that correct?
that's my understanding, yes.
And that's a factor for you to take into account too when you're looking at how the medication got inside of Alex Xavier, isn't that right?
Yes.
They all had the child locks engaged, isn't that right?
It's my understanding, yes.
And it's important to take into consideration the developmental capabilities of Alex Xavier, isn't that right?
Yes.
And child locks would be a safety mechanism on that container that would keep a child of Alex Xavier's age from getting into that.
That would be why it's, oh, sorry.
What was your question again?
A child safety lock that is engaged on a pill bottle would be something that would keep a 6-year-old child from getting into that medication.
Yeah, overruled, go ahead.
So that would certainly be the intent of its design. Whether there's no 6-year-old that can get into it, I can't answer.
It would require a child to both push down and turn, correct?
The usual mechanism, yes.
You're aware of where the bag was found?
I don't recall.
You don't recall where the bag was found?
No.
It's found next to his body. Does that help you recall?
No.
It'd be fair to say that based on the description of how Alex Xavier was acting that evening, that he took in that lorazepam or Xanax sometime after 2 or 3 o'clock in the morning, isn't that right?
Fiction, speculation.
Given his earlier testimony, I'll allow the question be asked. Go ahead.
That would be expected, yes.
That'd be expected. It happened after that time frame.
Yes.
And you're aware that this defendant and only this defendant was home with Alex Xavier for the last 14 hours of his life.
Yes.
That's asked and answered and mischaracterizes the evidence.
It wasn't asked and answered, and you just said yes.
Doesn't matter what his answer is, it doesn't mischaracterize the evidence. Go ahead.
Yes, she was the only one home for that time frame, correct?
Yes.
Only adult home.
Correct.
That's-
Thank you, Judge.
okay. Can I just correct something? You said 14 hours, but I believe you had said there was evidence of somebody being there at 9:30? Somebody picking up?
Sure.
Yeah,
I'll
so it's
clarify
not
that.
14 hours, 12 hours. I mean, I'm just trying to, that there was an objection on the basis of the factual mischaracterization. I just don't want it to be mischaracterized. What was the actual?
Cyber.
What?
We get cyber.
Yep.
You're aware that the first responders described Alexavier's body still a little bit warm to the touch. Is that fair?
Yes.
Okay. That demonstrates that he would have died relatively recently to when they responded, within an hour or so?
I don't think it tells us that at all. I mean, the cooling of the body is a very wishy-washy, it's not a very precise way of determining how long someone's been dead.
There's a lot of factors that go into it, like the temperature of the room, correct?
Correct.
The size of the body,
Yes.
and the age of the individual, things of that nature, right?
There are a number of things that influence that, yes.
It's been studied, but it's not precise.
No, definitely not precise.
When I gave the 14-hour range, I'm going to clarify a little bit more. We know that an adult stopped by to pick up 2 adult children, is that correct?
Yes.
And that adult was the defendant's mother, is that right?
Yes.
And when that adult, the defendant's mother, stopped by to pick up the 2 older children, the defendant was there with her mother that time frame, correct, according to the
Yes.
reports?
Yes.
They were engaging with one another,
That's my understanding, yes.
and she picked up those 2 children and left, correct?
Correct.
There is no evidence whatsoever that that other adult was in any way, shape, or form left alone with Alexavier.
That's my understanding, yes.
Okay. And after that adult, the defendant's mother picks up the 2 older children, it's this defendant and this defendant alone is the only adult in the home.
Correct.
And that's after roughly 9:30 p.m., correct?
Yes.
And that goes until 9:25 a.m. when first responders are on scene, is that right?
Correct.
Thank you, Doctor, that's all I have.
All right. Redirect?
Yes, thank you. Doctor, do we know when exactly Alexavier died?
No.
And Alexavier, when he was discovered in the morning, he was in a state of rigor mortis, is that correct?
Yes.
And what does that tell you?
I mean, it's another thing like cooling of the body. There are certain changes that happen in the body post-mortem. The body will cool off, the body becomes stiff, and blood, settles into the lowest portions of the body. All of those things happen in a sort of gradual, progressive way over time. When a person first dies, there's no evidence of stiffening, there's no visible evidence of lividity or that pooling of the blood, and they're going to feel essentially as warm as they did. Most of the studies on postmortem cooling say that there's at least a plateau period initially where the body will remain at its normal temperature for a period of time, an hour or more. But the stiffening of the body happens in a progressive way, usually is present within an hour or 2, becomes more developed, and stays then fully developed after a period of about 12 hours until the body starts to decompose. But the presence of that, we just don't know how long. I mean, it doesn't tell us enough nothing really informative as far as how long they've been dead, other than, if the presence of rigor mortis suggests they didn't just die. So it's probably been an hour or more. But again, other findings, if there was video that said, he was doing this, 45 minutes before, it certainly could be consistent with that, but could be really anywhere beyond that time frame.
Now, the government's lawyer made a big deal about how Dr. Quinton ordered testing for prednisone. You remember that?
Yes.
And in fact, was that the case? Did they test for prednisone?
I don't believe so, no.
And is that something they could have tested for?
I'm not aware of a lab that offers that testing specifically. I'm sure there are research labs somewhere that can look at that question, but it's not. In the setting of postmortem toxicology, most anything that can be used to lead to, cause, or contribute to someone's death has been looked at in terms of the ability to test for it. Like I said before, I haven't seen a case of someone dying of a prednisone overdose, and I'm not aware of a lab that specifically includes that as part of any of their routine screens.
That could have been a possibility. Is that your testimony?
It's possible that testing could be done, but I don't know where that would be.
Now, there was some discussion of child locks. Are child locks 100% child-proof?
I'm not a product expert, don't know. I would guess not, but given the resourcefulness of children, but I don't know.
And you testified that we don't know when the alprazolam was ingested. Is that fair?
No, and we also don't know if it came from a bottle.
And we don't know if it was ingested multiple times, perhaps?
We don't. I mean, what we have is a single level in a blood sample that's not terribly helpful in terms of interpretation. We know that he has Xanax in his system, but that one level, even if it was a good, femoral blood sample, we don't know whether that represents one ingestion, multiple ingestions over time. There's not a way to know that from that single level. That's just a snapshot of what's going on in his blood at the time of his death.
And does the evidence support that there could have been initially a lower dose administered and then a later higher dose that was ingested?
That's possible.
And is it also possible that the child suffered a concussion and the effects of that, and then later ingested alprazolam? Is that
also possible, yes.
Now, there was some discussion about the types of forces and mechanisms that can lead to the liver laceration. Do you recall those questions?
Yes.
Would it be something that could be caused by a strong and angry man who can inflict those injuries?
Certainly that's possible.
And there was also some questions about whether you're getting paid to perform your job. Is it normal for people to get paid for their time?
Yes.
And doctor, are all of your opinions held to a reasonable degree of medical certainty?
Yes. And to me, what that means is, that within my understanding of the science and the medicine behind the things I've testified to, that these are reasonable conclusions.
And so your opinion remains that this was an undetermined death?
Yes.
Doctor, just to be clear, a forensic pathologist, you are not to opine on who did something, right?
Yeah, I don't know who did it.
That's for the jury to determine, correct?
Correct.
So when you're asked to speculate on whether an adult man could do it, an adult woman could do it too, right?
Possible.
Right?
Yes.
That's not for you to decide, is it?
I mean, I don't have any way to know that. I can tell you that the injuries are consistent with an adult having caused them, but which adult, I don't know.
That's all I have. Thanks.
Amen. All right. Thank you, doctor. I'm not sure. Oh, yeah, you do have an.
Okay.
Move admission of Exhibit 311.
Down. Thank you. Any objection?
No, that's the CB.
That's the CV, yeah.
Yeah, no objection.
Okay, we received.
We'll get a complete.
Let's take a little break, and then we'll go into next testimony. So it's about 5:02. All right, we'll see you then. About 5-2.
5-2, okay, thank you.
seated.
That one text marked, Emily?
She just, you wanted us to stop marking it.
This one?
Thank you for not doing it.
What number is that?
We'll see. 312.
212?
312.
Okay, looks like everyone is present. Can we bring the jury in?
Judge, I do want to have a discussion on the record about
Okay.
what counsel had mentioned yesterday about opening the door to an impeachment topic. I'll say that I've had the opportunity to review the police report. It's from 2019, and the question that I posed to Ms. Dikeman was whether or not she had ever received medication from Ted Colkind. Her response was no. The police report from 2019, of which Ms. Dikeman was not prosecuted or convicted of any count, is from Deputy Pam Bedhauser, indicating that Ms. Dikeman had talked to Ted about possibly buying some of his pain medication. There was an apparent meeting time discussed, but no evidence that there was actually a transaction. And my understanding is that that's what Mr. Colkind would say as well. I don't know that that's opening the door, and I would ask the court to prohibit cross-examination on that topic.
Counsel?
I think the report is very different. I think she actually admits to buying pills from him, oxycodone pills that she originally had an addiction to in 2011 to 2013, pills that she said when she was on the stand she graduated from drug treatment court and has never used again since then, or not used without a valid prescription. And her very specific statement, I believe in the reports, is that she admits to buying oxycodone pills from Ted Colkind.
obviously I'm letting you take a look at the report.
Judge, this is all that we have, and I'll put it in the record here if you want. But it's a follow-up report from Deputy Bedhauser, who I'm not sure if she's still with the Sheriff's Department or not, from September 9th of 2019. It's a single paragraph where she says she made contact with Josie that indicated that Ted had previously offered her some medications. She showed Deputy Bedhauser a conversation between she and Ted from July 15th in which she inquired about having some of the medications. Ted replied, "Sure, no problem." When she asked him how much money she had to give him for them, he said $1 million, and then it included a time to exchange the pills, but there's no indication that that exchange actually took place.
That's in the report that it says,
Yes.
it says no indication.
No, it does not. It does not. Oh, well. Yeah, she indicated recontact with Ted Colkind, returned to Ted's residence, gave his oxycodone and OxyContin medication back to him, along with Jeep keys, asked if he had previously provided Josie with some of his prescription medications. Mr. Colkind told her that he did not remember and did not remember their text conversation, said that when she mentioned how he joked about the price of the medication being $1 million, Mr. Colkind was just kidding about that.
All right. I don't think, if that's the response, he's not saying that he actually exchanged it. And obviously $1 million was a joke. I think the state would think that is true.
I think his reference to it costing $1 million for the drug transaction is a joke. I agree with that. I don't think he's saying that the rest of that didn't happen or that the whole thing was a joke. And when she's being interviewed, she very clearly is telling law enforcement she's seeking this medication from him. She's asking, can I have your OxyContin? That's drug-seeking behavior of a prescription medication that is not her prescription, which goes directly against what she testified to on the stand.
She testified that she did not take. She has not taken?
She has not received medication from Ted Colkind. She's admitted that she's received medication from her mother. We've acknowledged that. But specific to Mr. Colkind, no.
All right. I don't believe it's opened the door. We'll go from there. Okay.
Judge, if I get further clarification from that sergeant that says she actually admitted to the transaction.
And it's not in any report?
Yes.
From a 2019 situation? No. We're moving on. Okay, let's bring the jury in.
Judge, just for the record, I want to note that there's no evidence that there was an actual drug transaction with the text messages they introduced with regards to Mr. Pedrin. And this is the exact...
The jury coming in.
Jury coming in. You do it later.
Could you pull my legal pad from yesterday? I was using it. Thank you.
All right. Everybody may be seated. We're going to continue with the testimony of Ms. Dikeman. Ms. Dikeman, why don't we have you come up and we'll have you re-sworn and have you take the stand.
testimony given this matter shall be the truth, the whole truth, and nothing but the truth.
Go ahead.
Josie, I want to start back in the days leading up to Alex's death. Were there ever times when you reached out to Derek's mom for help controlling him?
Yes.
Why did you do that?
Because I was scared to call the police, so I thought I could call his mom.
All right, I'm approaching you with what's been marked as Exhibit 312. So this does this appear to be a Facebook exchange between you and Mrs. McCormick?
Yes.
And for the record, the top entry is dated UTC February 1st of 2023, 9:17 and 4 seconds UTC, which would be about 3:17 a.m. on the 1st. Is that correct?
Yes.
Josie, did you ask Ms. McCormick if she was awake?
I did.
And did you tell her why you needed her help?
Yes.
What did you tell her? Sorry.
I said, sorry, he's been drinking a lot and I'm not sure what to do.
Offer 312.
Any objection?
No.
Received.
Josie, was that the same day that you sent Derek the text where you said that you were too scared to even go to sleep?
Yes.
Was Derek's behavior out of control at that point?
Yes.
Was his mom ever able to calm him down or have him behave normally in the house?
No.
Did Derek's behavior continue to be violent and erratic from the date of that Facebook exchange on February 1st up until Alex's death 10 days later?
Yes, it did.
Bless you. Did Derek ever leave bruises on your arms?
Yes.
What generally would cause those bruises that you're aware of, Josie?
I feel like I always had bruises on my arms from him grabbing me.
Okay, so he demonstrated that on me yesterday. Would he grab you by the arms or by the biceps?
Yes.
What would he do when he grabbed you by the arms or the biceps?
He would pin me to the wall or pin me down to the bed.
And I'm not going to redisplay the photograph, but do you remember the photo of Alex's arm with the bruises on it?
Yes.
Do you have any idea how Alex would have gotten those bruises on his arm?
He would grab him by the arms, drag him around.
Okay. So, Josie, in some of those videos that we saw earlier, is it fair to say that you would yell at him too?
At Derek?
Yes.
Yes.
Is that something you're proud of?
No.
Were there points in time in your relationship where you felt like you had the strength to speak up against him?
There was points where I didn't. There was points where I tried talking, and then there was points where I escalated and I would yell.
Was that ever a good excuse for Derek to hit you?
No.
Would the kids sometimes see this arguing between the two of you?
They've seen it a lot.
Josie, are you claiming in any respect that you always behaved perfectly towards Derek?
I didn't.
Now, since you've been arrested and charged, where are Brantley and Araya living?
Brantley and Araya are with Derek.
Do you have any idea what Derek or members of his family are saying to Brantley and Araya?
I have a lot of ideas.
You don't, since you're not there, do you know?
No.
I want to talk a little bit about that video of Brantley that was shown at the beginning of this case where he came in and said Dad hit me on the head, and he goes like this. Do you remember that?
Yes,
Were you telling Brantley to make that up?
absolutely not.
What do you remember? Did Brantley come in and report this to you?
Yes, Brantley had accidentally knocked the TV down in the room. They were jumping on the bed, watching TV. And Derek hit him over the head.
Was that an example of Derek telling the kids what to say to the authorities when he said that mom's lying?
Yes, he always said that.
Did you see that video of Derek questioning Brantley in the bathroom?
I did.
How did Brantley look to you in that video?
He looked scared.
You recognize that look on your little boy when he was making those statements?
Yes,
And was that normal for Derek to do, to question the kids, to get them to say what he wanted them to say?
I seen it a lot with Brantley and Alex, where he would hold the phone over their face and record them and tell them what to say.
So he'd stand over them with his telephone and record them saying what he wanted them to say?
Yes.
Josie, I want to talk to you a little bit about your interactions with Alex, and I'm going to play a relatively mundane experience from after Alex broke his leg. Would you ever take Alex with you shopping when you went to Walmart or grocery stores or anything?
Yes, a lot.
Is that because you did the majority of the shopping for the house?
I did.
And if we can get the Elmo up, please. Judge, these will be going on Defense Exhibit 203. The video is labeled 48, Josie Entrance 12723, 1247.AVI. This is a material that was provided to us in criminal discovery. The video this one is, I believe, 27 seconds. Offer the exhibit and move to publish.
Objection.
Received, publish.
Okay. Josie, did you have a chance to see that video from January 27th at Walmart?
Yes, I did.
Was that you pushing the two kids in the grocery cart?
Yes.
Who were the kids in the grocery cart?
Alex and Araya.
And it looked like they had a bag of food open. Is that right?
Yes.
What food was that?
Pringles or snacks. I don't know.
Like Ritz crackers, maybe?
Maybe, yeah.
Why would you have gotten a bag of food out for Alex?
Because it keeps shopping, makes them hungry. It keeps them occupied.
Okay. Was that something that you did pretty commonly for the kids when you took them to the store for shopping?
Yes.
And it looked like Alex and Araya were smiling in that video. Is that right?
Yes.
Were they generally happy to go shopping with you?
Yes, and sometimes they would help me because all the colors and all the activity overwhelms my brain at the store, and I'd make it a game to where I'd look up items that I was getting on my phone and they would help point it out, and after they helped me at the store, they'd get a treat.
Okay. Was that pretty regular for you?
Yes.
So Alex is riding in the cart. Why is Alex riding in the cart?
He had a broken leg.
How'd you get him into the cart?
I carried him. Or no, he had his walker.
Okay. And you helped lift him into the cart?
Yes.
I'm going to go to the second video here at the checkout line. For the record, Judge, the video is labeled 49 Josie transaction 12723 1300.avi, which I would stipulate means 1 o'clock p.m. We'll be adding this to 203. Offer the exhibit, move to publish.
Objection.
Okay, receive, publish.
Were you able to see that video, Josie?
Yes,
And before we go any further, were you able to see the Ritz Cracker logo on the bag when it was in the?
yes,
So, looks like it's checkout time, and looks like you were struggling a little bit with the scanner at the checkout line.
yes,
And I noticed that you bought some Red Bull. Is that correct?
yes,
Did you and Derek drink a lot of Red Bull?
I did.
But what's happening with the sucker? It looks like Araya comes over and has a sucker in her hand.
Yeah, she ran and got a sucker, and I made her go back and get one for Alex.
Is that why there were two suckers?
Yes.
Do we actually see Alex get his sucker?
Yeah, she went and gave it to him, and then he handed it back to me to open it, and I told him to wait until we get to the van.
Why did you insist that Alex get a sucker as well as Araya?
Because whatever she got, whatever one kid got, they all got.
Looked like the kids were happy and playing at the checkout line. Is
Yes,
that a normal experience for you with Alex and Araya?
yes,
Josie, I want to talk to you a little bit about the forensic interviews, and I'm going to ask you if you agree with some of what was said. What was your reaction to Brantley claiming that he hit Alex?
that was something that they did, they all did, they seen Derek do.
Did you kick Alex?
No, I did not.
Did you ever joke with the kids about discipline that you would do if they misbehaved?
I mean, when several times I'd ask them, to settle down or quit roughhousing or stop jumping on the couch, or I'd say, do you want your butt spanked? But I'd never do it, and that's why they kept roughhousing and didn't listen, because they knew I'd never do it.
Did you say it in a joking tone?
Yes.
Josie, I can't believe I have to ask you this, but did you keep poisonous water in the drain of your shower?
No.
You aware of any poisonous water at home?
No.
Did you have a secret door in Zayden's room that contained diamonds, guns, and a paddle to hit the kids with?
No.
Was there any, other than maybe the cubby hole upstairs, was there any ever any secret door?
No, and that was never Zayden's room.
Was there ever any diamonds?
No.
Was there ever any paddle?
No.
How about guns?
No, I don't like guns.
Josie, did you make Alex pick up dog poop on his broken leg?
Never.
And
No.
did you ever make him pick up dog poop on his broken leg?
No.
Let's clear the air right now on Wayne Colkind. Did he stay overnight for a period of time at your home?
Yes, there was a really bad winter. It was really, really cold out, and he was sleeping outside, and it was a couple days that he stayed in our basement.
A couple days, meaning 2?
Yes.
Was that close in time to the time frame that Alex died?
It was before, way before.
Did Wayne have a dog?
Yes.
What happened with the dog's poop?
I made him pick it up. I told him if he had the dog there, he had to clean up after it, because I didn't want the kids stepping in it.
Did he clean the dog poop up?
Yes.
Did the dog ever poop inside?
No.
Now, did Brantley have an active imagination?
He did. A very active imagination.
Did you guys tell each other stories or come up with silly stories to tell each other?
Yes, him and Alex and Araya.
Was it common for him to come up with stories that involve things like poison and diamonds and other things that you know to be untrue?
Yes.
Sting.
Let's talk a little bit about Major. We've heard a little bit about this, all right, bless you. But just describe your relationship generally with Mark.
We did not get along.
Did you have to go to court with Mark?
Several times. There was constant custody battles.
At some point before Alex died, were you given sole custody of Major?
Yes, I was.
And was that a source of anger or resentment between you and Mark?
It was not. It was because Major came to my house with a phone from Mark.
Well, we can't go into that. But was Mark upset with you because of you getting custody of Major?
He was very upset with me.
Who took Major after Alex died?
Right after I found Alex on the floor, my mom was on the way to drop off Major to his dad's when I had called her, and after that, he kept Major. He didn't drop him back off.
So he went to Mark's family effectively?
Yes, and Mark was having supervised visits at the time, but he didn't bring him back because he seen all the ambulance and everything at the house.
So when Major said that he saw you kicking Alex, did that happen?
No.
Did you ever see Major doing any of the things to Alex that he attributed to you?
Yes, Major was very mean to Alex.
Can you explain that a little bit?
Major had very violent issues, and I was taking him to counseling for that.
I'm gonna object to this.
Overruled.
Did you ever see him kicking Alex?
I did.
How about choking?
I have seen him choke Alex.
Was that something that you felt was appropriate when Major was doing that?
Absolutely not. I was trying to get him help.
Is that why you took him to see the Mr. Ryland?
Yes, and Major was very upset with me for that.
So, Josie, I'm going to ask you, do you claim at all to be the perfect parent to these kids before your arrest?
I was not the perfect parent, but I tried to show them love.
Do you claim to be the perfect partner to Derek during these?
No, I wasn't.
Do you agree that you struggled to keep up with keeping the house tidy?
Absolutely, I did.
Do you agree that you and Derek struggled with the kids' attendance?
Yes,
Are you willing to acknowledge your own flaws as a parent and a partner as you sit here today?
absolutely.
Do you make any excuses for them?
No,
Leading up to your arrest on May 19th, were you aware at that time that you were a suspect in Alex's death?
I knew I was. I had been told I was.
Who told you that?
Detectives and CPS?
Did Derek talk about it as well?
Yes.
How did you react, Josie, when you were arrested for Alex's death?
I was in shock. I didn't understand
What didn't you understand?
why I was being arrested for something I didn't do.
Were you trying to forget elements of those days leading up to Alex's death at all?
I was not trying to.
Was it something that you felt comfortable thinking about, remembering Alex's death?
No, my brain is, with all the trauma I've taught it has trained itself to shut down and, in trauma events, block out the trauma to protect itself.
Have you had some time since this whole matter started 3 years ago to begin putting the pieces together?
Yes,
When did you learn the official cause of death for Alex?
when I was arrested in a jail cell.
And before that point, did you know the full extent of Alex's Xanax levels or his injuries?
I did not.
Do you believe that Alex had a good life?
Not with his father.
the Kouri sentencing is on the screen, but I'll play the audio of the other trial as we wait for the court to start from this other trial that we're. So, as I said, so to reiterate, when this trial right here, when it finally comes, when the sentencing group comes and is ready, I will pause the other trial, right? So we'll listen to the audio of the other trial, but watch the visual of this until they actually come and get ready. Okay.
You hit, harmed, choked, or physically assaulted Alex in any way on February 10th before he died?
No,
Was this something that you ever did to him?
no,
You feel like you would have even been physically capable of doing this in that time frame?
no, and my heart would never do that. I loved him with all my heart.
Who was the only person that you noticed hurting Alex on February 10th?
His father, Derek Pedron.
Who was the only person on February 10th that you saw in possession of Xanax?
His father, Derek Pedron.
Did you ever give Xanax or something you believed to be Xanax to Alex?
No,
Did you kill Alex, Josie?
no.
How do you feel about Alex right now?
I miss him every single day, and I love him with all my heart.
That's all the questions I have.
Ross?
I'm going to start with where counsel left off. You found out about the cause of death for Alex the day that you were charged, correct?
Yes,
You had the criminal complaint that told you all the injuries that Alex had.
yes,
You also had the toxicology results, correct?
I believe so.
Who's the first person that you called from the jail after you were arrested?
My children.
The first person that you called was Derek Pedron, isn't that right?
Yes, my children were with him.
And the first person that you called after finding out all this information was Derek Pedron, and you told him you loved him, didn't you?
I did.
You told him you loved him multiple times on that call, isn't that right?
Yes,
At the end of that call, you actually asked him, why aren't you saying you loved me back, right?
I don't recall.
You wanted him to say that he loved you too, right?
I don't remember the exact words.
You told him on that call, you got what you wanted, I'm charged, right?
Yes, because
No, it's a yes or no answer. They can clarify with you, okay?
yes,
Now, when you said you got what you wanted, never once on this jail phone call did you say, Derek, you're the one that did this.
Objection, comment on silence. Represented.
It's on a jail phone call and it's before.
Okay. Overruled.
no, I did not.
Never once did you say, Derek, you got me into this trouble, right?
No,
Never once did you say, Derek, you caused abuse to Alex on the evening of February 10th, right?
no,
Never once did you say, Derek, you're the one that brought Xanax into this house. You never said that either, did you?
no,
This is after you had all the information and you are sitting in jail knowing that you've been charged with these offenses. You call Derek Pedron, first person you reach out to.
my kids were on the phone.
And you asked Derek if he's going to allow you to talk to the children after he knew that you had been charged, right?
My kids were on the phone, yes.
The kids were on the phone because Derek said he would allow you to talk to the children. Isn't that right?
He didn't clarify if I could continue to talk to my children.
He allowed you on those phone calls to talk to your children, correct? You talked to your children.
Yes. That was the last time.
And you couldn't talk to your children anymore because of other court proceedings, right? It wasn't Derek preventing the contact.
He said I manipulated them on that phone call because I
You
asked if
manipulated
they
them?
were safe, yes.
Now, you prepared for your testimony with your attorneys, is that right?
I seen my attorneys, yes.
They prepared you for testifying in court, correct?
I practiced, yes.
You practiced. Attorney Zacher always has a very nice binder with all of his questions in an order in which he's going to ask them, isn't that right?
Yes,
And you knew the order because he went over those questions with you before you came into this courtroom, isn't that right?
I did not know the order.
He used that binder when he asked you the questions when you were practicing, right?
Yes.
And how many times did you practice with Attorney Zacher? Was it one time? Was it more than one time? Many times?
It was every week,
It was every week.
yes.
Every week since 2023, since you've been charged, you've been practicing with Attorneys Act for the moment that we saw yesterday and today.
Not, I wouldn't say every week since when?
Since he's been on the case.
No.
You practiced quite a few times.
Yeah, multiple times. Yeah, I was scared.
Second, I'd like to hear from counsel for the state and from those who wish to present a victim impact statement. Third, I'd like to hear from defense counsel and those that defendant desires to present information regarding the appropriate sentence. And finally, the court will give Ms. Richins an opportunity to speak if she so chooses. Any objections, Mr. Blower?
No, Your Honor, I have one other housekeeping matter, if I may.
Please.
Your Honor, the defendant previously waived the jury as it relates to the domestic violence finding. I cannot recall, or finding the record, whether or not the court has actually made that finding.
I can't recall whether there was a stipulation about their status as stipulation around their status.
That's the issue.
Right.
Your Honor. And I think that
It doesn't impact the decisions today, it just impacts the record for any future offense that might be committed by this person.
that is correct.
Right.
Well, Your Honor, one thing, it will affect the analysis as it relates to a continuous protection.
Oh, understood. No, I understand your position. Yeah.
Your Honor, I do believe we put that on the record during the jury instruction conference.
Okay.
We discussed specifically the cohabitant issue, and you got us to make a statement on the record.
Okay, very good. So, I think there's a stipulation among counsel that the record includes a stipulation of fact recorded for the record that Eric Richins and Kouri Richins were cohabitants under Utah law at all relevant times. Anything further, Mr. Blair?
No, Your Honor.
Ms. Nestor, Ms. Lewis, any objection to how the court intends to proceed?
Yes.
Okay. Fair warning to everyone inside the courtroom. As with the time when the verdict was read, everybody in the courtroom deserves our respect while they are in the courtroom. So, there can be no outward reactions to what's said today. This is an emotionally charged situation, reasonably so. But the bottom line is no outward reactions. If you feel overcome with emotion, please look down. Keep your hands folded in your lap. Moreover, to those that might be coming to the podium to make statements today, please make sure you're addressing me, the court, not other people in the courtroom. You're of course allowed to reference other people in the courtroom, but speak to me. All right. Let's talk about setting the restitution here. What makes sense from the state's perspective?
Your Honor, the restitution amounts that the state is seeking are well known in the record, or the defendant or are well known in the record. So we can proceed in very short order. I don't know if there's going to be much dispute on the amounts.
Okay. From the defense team, what makes sense, Ms. Nestor?
We need an opportunity to brief these issues and do a little bit of research. We were surprised by some of the requests that came
The
from us.
recruitment issues?
Yes.
Fair enough.
So we need to look into that. I know that I'm going to be out of town the first 2 weeks of June. I'm going to be out of the country, so if we could do it before or after, that would be helpful.
After would work far better for me.
Okay, same. So, other than that.
Ricky, what would you recommend? Is there an afternoon on which we don't have a ton of stuff set on a Friday afternoon? Nestor, the afternoon of July 10th.
Ms. Lewis will be out of town, and that is the week we are doing the preliminary hearing in my case in Utah County.
Understood. Well, maybe July 31, like you said.
July 31 works.
That work for the state?
What time, Your Honor?
That'll work, Your Honor.
All right. We'll say 1:30 p.m. on July 31. Ms. Nestor, would you like to appear in person or by web extension?
In person, Your Honor.
All right. We'll set a restitution hearing to include discussion of the state's arguments regarding recoupment as made in their sentencing memorandum on July 31, 1:30 p.m. in person. Okay, anything further on that, Mr. Blood?
No, Your Honor.
Ms. Nestor?
No, sir.
All right. Mr. Bloodworth, the state's request for a continuous protective order. I looked hard at this. Let me relate some of my concerns and then have you respond to them, and then we can go from there. I looked at this, cases cited by the state, I looked at the statute, considered the absurdity doctrine. It seems to me that the legislature has adopted a policy where a convicted person's First Amendment rights are reasonably restricted in domestic violence cases to prevent the survivor of domestic violence from being re-victimized by contact, either direct or indirect, by the convicted perpetrator. And it seems that the legislature has recognized that a survivor of domestic violence can be re-victimized by the perpetrator contacting their family members or other household members. The statute contemplates that. But here, or in a situation like this, where the Domestic Violence Act does not have a survivor, rather it has a decedent, it seems from the face of the statute and other statutes involving criminal actions causing death that the legislature has reverted to the First Amendment being the baseline, and also that there are other remedies available to the family members of that decedent, such as stalking injunctions, if they are receiving contact that constitutes a course of conduct that would cause an objectively reasonable person to suffer emotional distress. Moreover, the juvenile court has tremendous authority to determine whether and how much, if any, contact a parent in this situation should have with the children of the decedent. I'm not sure that I have the authority to enter a continuous protective order in this case. I acknowledge this may not be what the legislature intended, that maybe they didn't see around this corner when passing the statute, and I appreciate the state's position that maybe they should take a hard look at it, but the act says what it says today. Respond to that for me.
Your Honor, the state questions the court's kind of read of the act, and when the court relates members of the victims, any harm to members of the victim's family relating back to the harm to the victim, causing the victim harm. I think the plain read of the statute is, and it's 78 Bravo -7 -804 3D 5.
Necessary to fully protect the victim and members of the victim's family.
Correct. The plain read of that sentence, Your Honor, does not say that the protection for the members of the victim's family does not, it does not relate back. It is a separate clause. It does not relate back to protection of the victim. And I think within the scheme of the statute, the legislature envisions protection for the victim, separately protection for the victim's family as an option of this court. And I think that's kind of consistent. This statute's odd. I think it's subsection B, which has a preamble on legislative intent.
Right.
And I think consistent with that preamble on legislative intent is the legislature's grant of this court, any court, authority to protect the victim's family under the statute as well because of the unique nature of domestic violent crimes.
An argument the state didn't make, maybe because it just doesn't believe in it, but it seems that a strict reading of the statute would say, I'm required to enter the continuous protective order and set a hearing, and then let defendant make the argument that.
Your Honor, procedurally, I think that's right, because of the threshold inquiry of whether or not the victim, decedent in this case, reasonably apprehends a harm.
Right. Practically, though.
But practically, I don't know that, I mean, it seems to me as the state brief that that is evident, that a decedent cannot reasonably apprehend harm.
Okay. Let me hear from the defense counsel for a moment.
Yes.
Your Honor, we agree with the court's original statements. We think this request for a continuous protective order is outside the purview of the statute. It's outside this court's authority. We believe it violates her First Amendment right. If these communications are not threatening, this would basically mean she could never send her sons a birthday card, a Christmas card, any type of communication.
Well, pause there for a minute. Let's take the 3 boys out of it, because there's a whole separate set of concerns there,
Right.
given that her parental rights have not been terminated.
Right.
And I don't have authority to do it.
Correct.
Juvenile court does.
Right.
But if we would talk just for the moment about the adult family members of Eric Richins,
Well,
it would mean that she could never reach out to them.
right. Well, and that could create problems if they're the guardians of her children and there's an issue if she is given any type of parental input to major life decisions, to medical care, to anything like that she would not be able to communicate would be problematic. She has no intention of communicating with them outside of matters that have to do directly with the children. I also think this, well, you said you're setting the boys aside, so my other arguments, I'll deal with them. But as far as I can see, there's another courtroom where this could happen. There's another venue under which this could happen, and this is not the appropriate place to do it.
All right, Mr. Bloodworth, any additional thoughts regarding the state's request for a continuous protective order?
No, Your Honor.
All right. All right, in full transparency, I don't like the result, but under this court's reading of Utah Code 78B 7804, subsection 3, the court determines as a matter of law that it cannot issue a continuous protective order in this case because it is evident that the victim of the domestic violence charges, in this case for which Ms. Richins was convicted, cannot possibly have a reasonable fear of future harm or abuse. It very well may be that this is not the result the legislature intended, and I would encourage the legislature to take a hard look at 78B 7804 subsection 3 to fill this gap explicitly. But they haven't done it yet. They know how to do it, and the court is not persuaded that this result is so far outside of what they could have possibly intended, given the overlay of the First Amendment, that the absurdity doctrine requires a different result. And so while the court hopes the legislature will make a legislative change that would provide protections for the members of the family of a decedent in an aggravated murder case like this. They haven't done it yet. The court simply, in my view, does not have the authority to issue a continuous protective order in this case. In so ruling, the court expresses no opinion whatsoever, one way or the other, as to whether Eric Richins' family members might qualify for issuance of a stalking injunction in the future, and expresses no opinion one way or the other as to whether the juvenile court will put in place restrictions regarding Ms. Richins' communications with her 3 boys. Anything further on that, Mr. Blower?
No, Your Honor.
Ms. Nestor?
No, Your Honor.
Okay, Ms. Nestor, may I ask you a couple of questions regarding the pre-sentence investigation report?
Yes, sir.
Have you had a chance to review it?
We have, Your Honor.
Have you had a chance to review it with Ms. Richins?
We have, Your Honor.
Okay. Are there any inaccuracies in the PSR that we need to address?
We submit there are inaccuracies. They're all related to the factual recitations, which this court presided over the trial and is very familiar with. We have confidence the court remembers what happened at trial and remembers what was presented, and we would submit.
Okay. For the purpose of today's hearing, to the extent there are any factual inaccuracies in the pre-sentence investigation report regarding the factual background of this case, the court determines that those factual inaccuracies are not relevant to the court's sentencing decision and do not affect the court's decision regarding the appropriate sentence one way or the other. Anything further on that, Ms. Nestor?
No, Your Honor.
Okay. Mr. Bloodworth, how would you like to proceed?
Your Honor, the state is prepared to present.
Please.
Your Honor, on Valentine's Day 2022, Kouri Darden Richins tried and failed to murder her husband and the father of her 3 young children, Eric Richins. Over the next 17 days, she did not think, what have I done? Rather, she thought, how can I do better? And then she murdered Eric in the presence of their children, using poison and for money. Such a person should never again lurk among the rest of us. Her children should never worry that they may one day encounter her. For these reasons, the reasons set forth in the state's sentencing memorandum, and the boundless reasons the court has learned from presiding over this case, the pending criminal case, and the multiple associated civil cases, the state requests that the court impose a sentence of life in prison without parole on count 1, 5 years to life in prison consecutive to any other sentence on count 2, 1 to 15 years in prison consecutive to any other sentence on counts 3 and 4, and 1 to 5 years in prison consecutive to any other sentence on count 5. Furthermore, the state requests that the court order the defendant to pay restitution to Auto Owners Insurance Company in the amount of $1,017,018 and True Stage Insurance Company in the amount of $352,562. The state requests that the court order the defendant to pay recoupment to Summit County in the amount of $1,391,943. Kouri Darden Richins earned this sentence. Her children deserve it. Only this court can order it. The court's time this morning is best spent hearing from a few of Kouri Darden Richins' victims. Fathers are not meant to bury sons. Gene Richins will present his victim impact statement first. Losing a sibling is losing a piece of yourself. Katie Richins Benson, Clint Benson, and Dr. Amy Richins will then present their victim impact statements. There are no greater victims in this case than Eric's 3 young boys. The defendant took both of their parents from them. Jessica Black, who is Weston's counselor, Christina Greening, who is Ashton's counselor, and Sarah Barber, who is Carter's counselor, will then present the boys' victim impact statements. Your Honor, Gene Richins.
Good morning, sir.
Good morning.
Please take your time.
Thank you. Thank you. Your Honor, my name is Gene Richins. I'm Eric's father. No parent should ever have to bury their child. It's a loss that changes you forever. Eric was taken from us way too soon. And his loss has left a permanent hole in our family that will never be filled, ever. Eric was first and foremost an incredible father. To his 3 boys, Carter, Ashton, and Wes, his sons were his world, and he was theirs also. They didn't just see him as a dad, they saw him as their best friend, their coach, their mentor, their protector. He was present in every part of their lives. Whether it was soccer, baseball, basketball, or any activity that they were involved in. Eric was there coaching, encouraging, and supporting not only his own boys, but every child on the team. Eric didn't just coach sports. He built confidence. He built character and friendships. He gave his time freely because he cared deeply about helping young people grow into strong, kind, and capable individuals. The impact Eric had on these children and families continues even now. On the soccer team that he coached, before every game, the players gathered and called out a cheer. For many teams, it might be something ordinary. But for Eric's team, even 4 years after his death, they still break the huddle with the words, 1, 2, 3, Eric. That simple cheer speaks volumes about a man he was and the lasting imprint that he left upon young lives in this community. He was a light to his sons, to the boys he coached, and to our entire community. A light that was taken far too soon. Eric was only 39 years old. As his father, I miss him every day. I miss our conversations. I miss watching him grow into a man I was so proud of. One of the greatest joys of my life was seeing the kind of father he had become. Eric was patient, loving, dedicated, and fully present in his boys' lives. Watching him raise his sons with such care and devotion was incredibly meaningful to me. Eric was also an amazing brother to 2 sisters, a loving uncle, nephew, cousin, and loyal friend. He was a trusted business partner, a valued colleague, and a respected member of our community. He was generous with his time, his energy, and kindness. He treated people with respect, showed gratitude even for the smallest acts of kindness, and gave freely of himself, because that's simply who he was. He worked hard to provide a beautiful life for his family. He gave them a home many would consider a dream. He ensured their needs were met, supported them, cared for them, and treated his wife with love every day. Yet despite everything he gave, his life was taken from him, not by a stranger, but by a person he should have been able to trust the very most in his life. He was betrayed in the most imaginable way possible. His life was taken through calculated, intentional actions motivated by the greed, control, and desire for a different life with someone else. Eric's boys lost a father. I lost my son. His sisters lost their brother. Our family lost a man who represented the very best of what a person can be. The ripple effects of this loss extend far beyond our immediate family. His friends lost someone they trusted and admired. The children he coached lost a mentor, a role model. Our community lost someone who genuinely cared and gave back without expecting anything in return. Eric will never see his boys graduate, get married, or become fathers themselves. He will never, again, stand on the sidelines cheering them on. He will never offer guidance, encouragement, or love in any way that only a father can. That opportunity was stolen from him and from all of us. Because of the calculated and intentional nature of this crime, I respectfully ask the court to impose a sentence of life without the possibility of parole. This sentence is important to Eric's 3 sons never have to live with the fear that the person responsible for taking their father could ever harm them again, and to ensure she can never harm anyone else ever again. Despite our immense grief, I want to acknowledge and thank those who have worked tirelessly to bring justice for my son. Eric was always grateful for others showed kindness and dedication, and I know he would want to express sincere appreciation to those who gave their time, effort, and professionalism to seek the truth in this case. We are deeply thankful to the prosecution team, Margaret, Brad, Lindsay, Fred, Joe, Wendy, Patricia, and the entire staff who supported them for their commitment and their perseverance. We also want to recognize and thank Todd for his dedication and relentless efforts in helping us ensure justice has been served. We are also grateful to Grace Wardis for serving as a spokesperson and an advocate for our family throughout this process. We thank the Summit County Sheriff's Office, Lieutenant Hemingway, Detective O'Driscoll, Detective Hopper, Officer Woody, Officer Gibson, and all the law enforcement personnel who worked on this investigation. We thank the bailiffs who ensured the safety and the order of this courtroom. We thank you, Your Honor, for your patience, professionalism, and stewardship of this process. We extend our heartfelt gratitude to each juror, including the alternates, for their sacrifice and their time, for seriously taking the responsibility, who carried out to ensure justice was served. Nothing can bring Eric back. Nothing can restore what has been taken from his sons, from our family, and from this community. But accountability matters here. Justice matters. Eric mattered. His life, his love mattered, his example mattered. He will always be remembered as a devoted father, a loving son, a supportive brother, a loyal friend, and a man who made lives of those around him better. We miss him every day and will continue to honor his memory by living with the same kindness and dedication that he showed to everyone fortunate to know him. Thank you, Your Honor.
Thank you. Katie, good morning.
So as you know, I'm Katie, and I'm Eric's sister. To begin, there are a multitude of people who deserve credit and appreciation. Law enforcement agencies across the state of Utah, the Summit County Prosecutor's Office, the Medical Examiner's Office, expert witnesses who worked hand in hand with law enforcement, Eric's friends, Eric's co-workers, my friends, and my family, our entire team of lawyers and experts in the civil lawsuit. There are far too many people to mention by name, and I suspect if I try to, I will inadvertently leave someone out. But to all of you, please know that this would not be possible without your efforts, your support, and the strength of the community that has stood beside us. Both my family and I are forever grateful to each of you. I am also very grateful to you, Your Honor, to this court for the dignified manner in which it presided over the trial, and to the members of the jury for faithfully performing their civic duties. Today is Eric's birthday. I stand before you because he can't. He was taken away from my dad, my sister, his nieces, his friends, our community, and worst of all, from his 3 amazing sons. Sorry. He was taken away from us by a person he should have been able to trust, the person he should have trusted most in the world, his wife. It's impossible to fully describe how devastating Eric's death and Kouri's crimes have been to our family. Nearly every aspect of our lives has been permanently changed, and we have no choice but to live with those changes and with Eric's loss forever. Eric was a phenomenal brother, father, son, nephew, grandson, cousin, friend, and businessman. Eric and I were extremely close. We went through school together and navigated life side by side. Wherever Eric went, I was usually tagging along right behind. In school, Eric's nickname was Richie, and mine was Little Richie, a reflection on how inseparable we were. He wasn't just my brother. He was my constant, my protector, and one of my closest friends. Eric was the kind of father who anticipated his children's needs before they ever had to ask. He made sure they were always having fun, taught them how to be respectful and kind, and was constantly planning for their future. His mind and heart was always on his boys, always. Everything he did was for them. Eric was the very best uncle. He made his nieces, my daughters, feel truly special. He always found ways to have fun with them. He doted on them with love and attention. Eric was an incredible son, always there for my parents, stepping in without hesitation and helping in every way he could, without being asked. The bond he shared with my mom was truly special. We would often joke that the umbilical cord had never really been cut, but in truth, it spoke to the deep, unbreakable love they had for each other. This is who Eric truly was, a man defined by love, integrity, and unwavering devotion to his family. He is none of the things that Kouri tried to portray him as. Those mischaracterizations were nothing more than a vile effort to deflect blame. And those mischaracterizations stand in stark contrast to the reality of the man we all knew and loved. Eric's life and his actions and the profound impact he had on those around him speak for themselves, and they tell a story of goodness, strength, and character that cannot be rewritten or diminished. The saddest part for me in all of this is that I got something with Eric that his sons never did: time. I feel cheated that I only got to spend a few decades with my brother, but I should feel lucky in comparison. As Eric's eldest son told me shortly after his dad's death, he and his brothers did not even get 10 years with their dad. It is devastating that Eric is not here to coach them, to work the family ranch with them, to teach them how to drive, to attend their high school graduation, to send them off to college, to see them get married, or to celebrate the birth of his future grandchildren. His 3 sons are going to grow up and live nearly their entire lives without their dad. They are going to get to know their dad more from the stories we tell about them than their actual experiences. In all likelihood, by the time they are each 44 years old, which is how old Eric would be today, they will have little to no actual memories of Eric. And they have to go through life without their dad because their mother planned and carried out his murder. She could not have done anything more selfish or more cruel to those boys. In the place of a stable, secure, and loving home, Kouri gave the boys permanent trauma. They were in the house the night she killed their father. They were awake. They knew that something terrible had happened to their dad. As we heard on the 911 call during trial, one of them even walked into Eric's bedroom, where Eric's body lay dead, poisoned by someone who his son should have been able to unconditionally trust, love, and depend on. No child should have to bear that trauma. But Eric's 3 innocent sons will bear that burden, and they will bear it for the rest of their lives. Kouri's selfishness and cruelty did not end with Eric's murder. In the time after Eric's death, Kouri has done nothing but isolate, manipulate, deceive, and do harm to those boys. Almost immediately after Eric died, she cut them off completely from our family, from Eric's family. The isolation was calculated and strategic. Kouri used the boys as bargaining chips with my dad. She repeatedly threatened not to let him see his grandsons unless he could convince me, as Eric's trustee of his trust, to capitulate to her legal demands and give her all the trust assets. While isolating the boys, Kouri provided them with false and harmful information about me and my family. When DCFS took custody of the boys following Kouri's arrest and asked where they would like to go, they expressed fear of my family. The fear was not based on reality, but on what they had been told. For over a year, Kouri led them to believe that I hated them, that I was attempting to take Eric's money for myself, and that I intended for them to be left without support, that they would be homeless and starving. These statements were entirely false and had no basis in reality. Had they not been subjected to that influence, they would have known the truth. Prior to Eric's death, our families were very close. My daughters and his sons had strong friendships, and I had a meaningful individual relationship with each of my nephews. I spent time riding horses with one, helping another identify summer coding programs, and the youngest participated in ice skating lessons with my daughters. Our families shared holidays, worked together on our family ranch, took trips together, and I was present the day each of the boys were born in the hospital. The boys have expressed their confusion about these circumstances. They have stated that prior to their father's passing, both Eric and Kouri frequently told them if anything were to happen, they should go with me, that I would care for them and support them. Following Eric's death, however, those messages changed. After Eric passed away, Kouri prevented all contact between our family and the boys. She prohibited communication and continued to provide them of false information about us. When we were finally able to see the boys again, approximately 15 months after Eric's death, the boys hardly recognized the relationship we had. Instead, they viewed my family and me with fear and hesitation, as though we were strangers. Kouri also went to great lengths to jeopardize the boys' financial futures. I know you are very aware of this. Among other things, she drained the personal bank accounts that Eric had set up for his boys as college funds. She allowed the boys' Social Security survivor benefits to be funneled to individuals who were not taking care of the boys. And she sued me in my role as Eric's trustee and personal representative, not once, not twice, but 3 separate times. The goal of her lawsuits is singular. She wants all of Eric's assets for herself. Despite her lies and fanciful public portrayal, she knows that none of Eric's assets are going to me, my dad, or my sister. In fact, she knows exactly where Eric wanted everything to go, and that is to his boys. And yet, for 4 years, she has aggressively tried to take their inheritance from them. Even now, despite her erroneous debt, a murder conviction, and a string of pending felony financial charges, Kouri's civil lawsuits live on. Those lawsuits have been emotionally grueling, all-consuming, and unimaginably expensive. And tragically, every dollar on those suits is a dollar that Eric's boys will not get. Of course, Kouri can't have other people or the public thinking that she's trying to take away her children's inheritance. So for the past 4 years, both in court and in the media, she has demonized and vilified me. She has hurled wild accusations in my direction, including that I hacked her bank accounts, forged her bank statements, paid off witnesses, unduly pressured law enforcement into investigating her, and quietly pulled the Summit County prosecutor's strings. It is despicable that for doing nothing more than trying to honor Eric's wishes, Kouri has cast me as the evildoer here. Just as bad, honoring Eric's wishes has landed my sister and myself, and unbelievably, my 2 daughters in Kouri's crosshairs. One of Eric's sons recently told me that Kouri used to say, "I will get them one day." Apparently, she was talking about me, my sister, and my daughters. Her infamous walk the dog letter, the part the jury did not hear, confirms her desire to harm me. In it, she talks at length about her plans to get at Amy and me, including by targeting my daughters, both of whom are under the age of 10. It takes a sick mind to target children. The mere thought that someone who has so little regard for human life or decency might one day walk free is horrifying. I worry about the safety of Eric's boys, my daughters, my sister, and myself. There is nothing Kouri will not do, and no one she will not hurt, to achieve her own selfish ends. I am not the only one that is afraid. There are 3 little boys who, instead of fearing those who love and adore them, as Kouri would prefer, worry constantly that Kouri might show up one day and take them away. Eric's sons deserve so much better. They are not bargaining chips. They are not cash cows. They are not props for some twisted children's book about grief and loss. And yet that is what they've been reduced to by Kouri. To my unending sadness and horror, Eric himself understood all too well the danger she posed to his children and to his family. When Eric told me he had changed his estate planning and appointed me as his trustee and personal representative, I begged him to end the marriage and go his separate way. By that point, he had already consulted with a divorce attorney and was deeply afraid that he might not be awarded sole custody of his children. He made the heartbreaking decision to stay because he could not accept the risk of what might happen to his sons if Kouri had equal custody. He told me he would live his life through hell every single day of his life until his youngest was 18, because he believed Kouri was the most evil person he had ever met. He knew that his sons did not like her. He told me as much many times. He knew that they would prefer to be far away from her, but he also knew that divorce carried significant risks. And he said he could never allow his children to spend half of their time alone with her, because he was certain they would be exposed to harm and things no child should ever experience. He made it clear that in his mind, if Kouri were given equal custody, his children would be in the care of someone he believed to be deeply dangerous. He feared the people they could be exposed to and the damage that could be done. At the same time, he spoke with deep love and admiration for his boys. He told me that they were the most amazing boys in the world, and that none of this was their choice and none of it was their fault, and that he would do everything in his power to protect them for as long as he possibly could. Kouri loves to go on and on about how this case is a media sensation. She's right. News outlets from here to Europe have covered it. There have been countless newspaper articles, podcasts, and TV specials about it. Every hearing is live streamed on numerous YouTube channels. Every filing is scrutinized by internet lawyers and true crime junkies. There is no question that this case is famous and that Kouri is now famous. But what Kouri never mentions in talking about her fame and notoriety are the reasons why this case is now famous. It is famous for how appalling and sickening it is. It is famous because a mother meticulously planned to kill her husband, killed him while their children were sleeping in the next room, and then had the audacity to hold herself out as the author of a children's book about grief and loss. It is famous because she spent time Googling luxury prisons for the rich in America. It is famous because from her jail cell, she scripted a bunch of phony testimony so that her brother could perpetrate a fraud on the court. It is famous because she victimized her own children and threatened to victimize Eric's nieces. The fame and attention are directly proportional to the evil that has gone on here. This is not a situation where the idea of rehabilitation should be entertained. In taking Eric's life for her own selfish gain, Kouri did not only harm Eric, she permanently harmed 3 kids who were under the age of 10. She took away a dad, a son, a brother, an uncle, a grandson, a nephew, a cousin, and a friend. Eric's death has caused immeasurable pain to so many. Obviously, there's nothing the court can do about that. And you cannot bring him back. But what you can do is give Kouri's victims at least some measure of closure. To that end, I ask that the court impose a sentence that ensures Kouri never has the opportunity to harm Eric's children or our family again. Please do not let my brother's life be worth nothing more than a 25-year punishment. Please do not leave those boys to wonder whether Kouri might track them or their children down in the future. Please do not create a possibility for Kouri to endanger Eric's boys, my daughters, my family, or anyone else ever again. Please sentence Kouri to a life in prison without the possibility of parole. Thank you.
Thank you, Kate. Morning, Clint.
Hello, Your Honor. My name is Clint Benson. I'm Katie's husband and Eric's brother-in-law. Eric was an innocent man, a devoted father, and someone whose life revolved around his children and his family. Because of Kouri's choices, he never had the opportunity to say goodbye to his children, to reassure them, to share the final moments every family deserves. That loss cannot be measured. His children will spend the rest of their lives carrying the pain of a father taken from them far too soon. What makes this tragedy even more painful is the calculated nature of the crime. This was not a momentary mistake, a lapse in judgment, or a crime of passion. It involved planning, preparation, testing, and deliberate action. Eric's death was carried out in a way that caused fear, suffering, and helplessness. Kouri either watched or sat by as Eric succumbed to fentanyl poisoning instead of providing any kind of aid to him. She was fantasizing about a dream life funded by Eric's death. Eric was killed in his home by a traitor sleeping next to him in one of the most cowardly acts imaginable. We are profoundly grateful to every investigator, prosecutor, detective, law enforcement officer, juror, judge, forensic expert, and public servant who work tirelessly and honestly to uncover the truth. Their dedication ensured that Eric's voice was not lost and that justice could still prevail. We are equally grateful for the incredible community surrounding us. This community has shown unwavering support and has been there for Eric's boys without judgment and through some of the most difficult times imaginable. The boys are succeeding and thriving because of the people around them who continue to provide support and look out for their safety. Going through every aspect of this murder easily led to a dark place while fighting against an individual focused on only chaos and vengeance. However, the people surrounding us, including the sheriff's officers, principals, teachers, school staff, coaches, counselors, neighbors, and church members, created an unbreakable force for what is good, just, and right. No sentence can bring Eric back. No outcome will erase the suffering caused by these actions. But accountability matters, truth matters, and justice matters. Kouri continues to shirk responsibility for her actions, for the pain she has caused, and for the resources she has squandered, both Eric's and the state's. Even after everything that has been revealed, Kouri has demonstrated zero genuine accountability or remorse for the devastation she has left behind. Instead, she has repeatedly attempted to distort the truth, create false narratives, and portray herself as the victim. She has used the legal system as part of her schemes. There has been lawsuit after lawsuit, motion after motion, delay after delay, all in an effort to shift blame away from the person responsible. The evidence, the truth, and the outcome of this case all tell a very different story. What is especially concerning is the continued hostility from Kouri and her family, as well as their desire for vengeance directed towards our family, a family already devastated by an unimaginable loss. Statements they have made about going to war and getting the Richins demonstrate an ongoing mindset rooted in blame, anger, and retaliation, rather than remorse or acceptance of responsibility. Kouri will continue to try to convince the public that she was a good mother through media outlets that choose not to research or report on the countless motions and facts presented in this case or other cases, but instead simply regurgitate the false narratives of a sick and evil person. Kouri and her family continue to plan media campaigns focused on lies, targeting anyone foolish enough to spend time listening to them. Kouri is not before this court because she was mistreated, because she is a victim, or because the Richins family manufactured a false narrative as she and the Darden family would like to portray. She is before this court because of the choices she has made, choices that resulted in Eric's death and permanent trauma to anyone who has loved him. Kouri chose pride, seeking to project an image of success. Kouri chose adultery and lust, prioritizing her secret lover over her husband and her children. Kouri chose fraud and greed, hoping to profit from Eric's death. Kouri chose murder, and she continues to choose vengeance against the victims of her actions. The time for Kouri to make choices is at an end. Now it is time for her victims to choose. Please let Eric's children have a chance to choose lifelong peace, comfort, security, success, and happiness. I ask this court to impose a sentence of life without parole, a sentence that truly reflects the gravity of this crime, the irreversible harm caused to our family, and the calculated choices that led to Eric's death. Thank you, sir.
Amy, good morning.
Good morning. Honorable Judge Mrazek, my name is Amy Richins. I am Eric Richins' sister. Today, I'm here to speak as a victim and to speak for Eric because he no longer has a voice. I addressed this court in 2023 when we were living in a state of visceral shock. Now, 3 years later, we are here at sentencing on a date that carries a weight I can barely describe. Today's Eric's 44th birthday. Birthdays are supposed to be proof of life, a day to celebrate another year of growth, Instead, today is a cruel reminder of another year Eric will never see, and a reminder of the fatherhood that was stolen from his 3 sons. Before I talk about what this crime has done, I need you to know who Eric was. Not as a headline, but as a person. Over the course of this trial, so many people described Eric in strikingly similar ways. They called him outgoing, confident, funny, competitive, dependable, driven, and fiercely loyal. He was a leader, a hard worker, a rancher, a businessman, a coach, a best friend, a brother, a son. But more than anything, people described him as a phenomenal father. Eric had 3 sons, and he coached many of their sports teams. He was the kind of dad who showed up not just for his own children, but for everyone around them. Sometimes I think about all the children who lost him too, the kids he coached, mentored, and believed in. I cannot imagine the confusion and heartbreak they felt when someone who had become such a steady and trusted part of their lives was suddenly gone. Eric was a real person, a deeply loved person, and the loss of him echoes through every life he touched. On my 16th birthday, I was sitting in my 10th grade English class when I got a text from Eric that said, "Come outside." I walked out, and there was Eric, standing with flowers and that mischievous grin we all knew. I asked what he was doing there, and he just said, "Let's go. We've got to get a little mud on your tires." I had just bought my first truck, a used Ford F-150. Eric took me up into the mountains, and we took that truck off-roading for the first time. It was exhilarating and terrifying, but I felt safe because he was there. That was Eric. He made life bigger. He made people feel brave, and he protected the people he loved. That is the brother I lost, and that is the father his boys lost. In 2023, I told this court that I was tormented by the sequence of events of that night. Today, that torment has not faded. I still wonder when Eric realized he was in mortal danger. I wonder what Kouri said to him in his last moments. I'm still haunted by the question, did his boys hear their father's final struggle? If Eric had died of an illness, we would have cared for him. If it were an accident, there would have been kindness. But there is no comfort here. In his last moments, after being intentionally poisoned, my brother was faced with the ultimate betrayal. Eric's sons were 9, 7, and 5 when their world was shattered. They are now 13, 11, and 9. These are the years when a boy learns how to be a man by watching his father. What makes this crime uniquely heinous is that their grief will never pass. It will reinvent itself at every milestone. This crime didn't just happen once. It happens every single morning when those boys wake up and realize their father is still gone. They did not just lose their father, they lost the life they knew. Eric's death didn't end the harm. It began a grinding process of re-traumatization. Early in this process, I remember being told this case would be a marathon, not a sprint. We did not understand how every hearing, filing, delay, and public narrative would reopen wounds all over again. As if losing Eric was not painful enough, our family was then forced to grieve under public scrutiny. After the publication of the grief book, our family became the subject of public narratives, attacks, and speculation. At one point, I received a message sent from a burner phone that said, "You think you're funny? Kouri will get the last laugh. Your jealousy is as disgusting as your family." Law enforcement later confirmed, through warrants, that the message came from Kouri. That moment stayed with me because it captured what these years have felt like. Not just grief, but intimidation and distortion. Yes, our family hired a private investigator. But when someone you love dies suddenly and deep in your gut, you believe something is terribly wrong, you do not stop searching for answers. The real question is not why would you investigate? The real question is, what wouldn't you do? What wouldn't you do for your brother, for the truth? I also feel compelled to address the emotional toll of the trial itself. As the designated victim representative, and more importantly as Eric's sister, I have a right to be present in the courtroom. Yet during the proceedings, I was essentially kept in the dark. Due to the courtroom layout, I could not see the exhibits or the evidence. When we requested simple accommodation, we were told that the trial was being broadcast on court TV and I could excuse myself and watch from home with the rest of the world. Being told that my right to be here was interchangeable with a television broadcast was a profound violation. I did not want to watch Eric's life and death as content from my couch. I didn't want to go home after a grueling day and listen and watch it all over again. I had a right to be here, to face the evidence directly. Still, to this day, I have not been able to rewatch the trial because it's so time-consuming and painful to relive. I still have not seen all the evidence that was presented. Your Honor, I need to say this clearly. Someday, those boys will grow up and look back at the records of this trial. I need the truth to be the only thing they find. The claims made against Eric's character were not just legal defenses, they were acts of secondary violence. Eric was a protector, not a predator. These lies were a desperate attempt to justify the unjustifiable, and they have added a layer of cruelty to our grief that is nearly impossible to bear. I also need to correct the record on a few misrepresentations. First, the prenup. It was provided well before the wedding, not in a last-minute way. Second, the incident between Kouri and me. I never touched her. Kouri pled guilty to assaulting me. Yet she and her circle have continued to spread false narratives. This is a pattern of distortion that has kept our family trapped in conflict. There is something that has haunted me for years. And I found out Katie was the exact same today. I begged Eric to leave too. I begged him to divorce her. But Eric was trying to protect his boys. People often struggle to recognize intimate partner violence when the victim is a man. But Eric's actions spoke for themselves. He documented conversations. He tried to protect himself. He knew after Valentine's Day that she had tried to poison him, but he also believed that if he left, he could not fully protect his children. So he stayed because he was trying to keep them safe. This trauma has seeped into every corner of my life. And also, it has also deeply affected my own family and marriage. My husband, William, watched me be consumed by the pursuit of justice. For 4 years, we have lived in a constant state of stress, grief, and emotional exhaustion. I lost my job as a professor at Montana Tech University on the very day I was subpoenaed to appear in this court. Eric was so proud of me earning my PhD, and teaching students was something I loved and that made me proud. It now seems like another thing that Kouri's actions have taken away from me. But the most devastating loss is one that isn't in any police report. Because of the unrelenting stress of this investigation and the constant attacks on our family, I suffered a traumatic miscarriage of twins. We lost our children. We lost the future we were building. Kouri's actions didn't just end one life.
They reached out and stifled the lives of my unborn children as well. That loss lives inside this tragedy too. Eric's murder did not just take someone from my life. It plunged me into a darkness. It stole the light I once carried. It erased the future I had planned. Every day, I wake up and step into this same crushing emptiness, where time itself feels frozen and meaningless. The laughter of my future children, the warmth of my family, the simple joy of waking to a new morning, all of it has been devoured by this crime. This grief is limitless, resembling the ocean. Sometimes it softly touches the shore, other times it pounds against it with fierce force. Occasionally, it surges like a massive tsunami, overwhelming everything. These changes can occur suddenly, and like the ocean, it cannot be controlled. I didn't just lose my brother. I lost my sister-in-law. I lost someone I considered my friend. We'd had good times together. That loss is so complicated now, Your Honor, because it forces you to grieve someone who is still alive while facing the horror of what they have done. It is grief that doesn't resolve. It just sits there heavy every day. This crime has fractured our family in ways outsiders cannot understand. One of the most painful realities is that my husband and I do not get to see our nephews. This tragedy has created a wall of trauma between us, and that feels impossible to climb. Because of this crime, we are no longer present in those boys' lives the way Eric would have wanted. In 2023, I told this court I never knew evil like this existed. Everything I have witnessed since has confirmed that. Kouri did not just kill Eric, she attempted to kill the spirit of everyone who loved him. She lied to his children, she lied to the world, and has shown no remorse while dancing on his grave for profit. Your Honor, a parole-eligible sentence is not a conclusion. It is a reoccurring nightmare. It guarantees that every few years, Eric's sons will be notified that their father's murderer is seeking freedom. It forces them to relive the trauma repeatedly for decades. Eric died trying to be his children's shield. He can no longer protect them, so now the responsibility falls to this court. I ask you to provide these boys with the finality and safety they deserve. I ask you to ensure that the noise of Kouri Richins never enters their lives again. For the years of suffering we have endured, for the children who will grow up without their father, and for the life she stole from Eric and the peace she stole from us, I respectfully ask that you sentence Kouri Richins to life without the possibility of parole. Happy birthday, Rico. Thank you.
Jessica, good morning.
Good morning, Judge.
Take your time.
My name is Jessica Black. I'm a licensed clinical mental health therapist and a registered therapist. Myself and my colleagues are here today to read the victim impact statements for 3 children. We are here as advocates on their behalf. After a developmentally appropriate process, the boys were able to decide individually how they wanted to share their statements, and this is what they chose. Our roles are to read their words exactly as they wrote. The boys want the court and the world to hear their side. This is from WR. I woke up to sirens, and there were a lot of people at my house, and I was definitely scared. I felt confused. I was in a bedroom with my brothers, and I didn't know what was happening. At first, I was really scared because I didn't know what was happening, and I had no control, and I felt helpless. I felt really overwhelmed. After my dad died, Kouri would put us in the basement while she was with the neighbor. I felt scared because I thought something really bad was happening again. She would take me to places that smelled really bad. Everything she did made me feel uncomfortable. When someone talks about Kouri, it makes me feel hateful and ashamed. She took away my dad. It's made me have a hard time trusting people. I was scared that Kouri's family would come to my school and take me. I had to go to counseling with DCFS in Heber, and I did not like it. DCFS made me talk to Kouri, and I couldn't do things that I wanted to do. I felt not important to anyone. I feel a lot better about myself now than I did with Kouri. I can't ever see my dad again. I want her to go to prison forever. If she got out, I would be so scared, really mad, and I wouldn't want to go with her anywhere. I'm worried that she would take me away from Katie and Clint. Once she is gone, I will feel happy, and I will feel safer and relaxed, and trust people more.
Thank you. Christina?
Yes, Your Honor. I am Christina Green. I'm a licensed clinical social worker, not registered play therapist, and I will be reading for 8R. You took away my dad for no reason other than greed, and you only cared about yourself and your stupid boyfriends. You were not caring and watching over me and my brothers. I had to be a parent to W. C and I would walk him to the bus stop, feed him, and watch him. You were not concerned about our health. When we got hurt, you didn't even care. When C got ran over by a side-by-side, you still made him go to the soccer game that day without taking him to the doctors first. You would lock C in his room, and I would have to go to the kitchen and bring him food. You shamed us when we didn't want to eat uncooked lasagna you made. We threw it away because we couldn't eat it. Then you made us watch videos of children starving in war areas. You wanted to scare us into eating something that wasn't cooked. You wouldn't let our dog outside, and then the dog would pee inside. You created this problem, then you would smack my dog on the head as hard as you could. You wouldn't let me put my kitten in the garage for safety at night, and we found it eaten by raccoons the next day. You wouldn't let us turn on and use the heater lamp for the chickens and bunnies, and they froze to death. You would always argue with my dad and lock the door. You were not playing the role as a real mother does. You were doing the opposite. Now my dad can't be my coach anymore, can't be at any of my games. He won't be at my birthdays. He can't teach me how to drive. He won't be at my graduation, and he can't take me camping or fishing. You made me paranoid about sleeping on my dad's side of the bed by saying I might die or get harmed when I was just trying to be close to my dad after you killed him. You took away everything from me and my brothers. I don't want you out of jail because I will not feel safe if you are out. You have never said sorry for anything that you have done to me and my brothers. I don't want you to hurt anyone again. I know that you will need to stay in jail to fully take accountability for what you did to me, C, W, and my dad. With you in jail, I will be able to continue to feel safe and live a happy and successful life without fear of you hurting me or anyone I love. Thank you, Your Honor.
Sarah?
Yes, my name is Sarah. I'm a licensed clinical social worker and registered play therapist, and I'm going to read the victim impact statement for CR. My name and age now, my name and age I was at the time of the crime. CR, age 12, now 13. I was 9 when my dad was murdered. What I would like to see happen if the perpetrator is convicted of the crime, I would like to see Kouri get a life sentence. My thoughts regarding an appropriate sentence for the person who is accused of this crime and if they are found guilty. I think Kouri should get a life sentence because what she did is very sick, because it had no reason to happen and it impacted a bunch of people, including me. These are some reasons why I think she should have a life sentence. The information I feel is important for the judge to be aware of in sentencing. I think the judge should know that my dad was a good person and very thoughtful and kind and helped whoever needed help. He was always taking the extra mile to help people. My physical injuries as a result of this crime are as follows. I was sleeping and then I went to get a drink of water, then went back to bed. And when I woke up shaking and Bailey called the ambulance and they came and I couldn't talk for a while, I think Kouri had something to do with it because she didn't call the ambulance. She called Bailey and Bailey called the ambulance. At the ER, Kouri resisted to have my blood drawn, and kids who usually have this kind of seizure is when they are a few months old to a year old. I learned later that Kouri bought more fentanyl and had it in the house when this happened. I think this is what happened. She did what she did to my dad in the living room. My experienced emotional injury because of this crime is described as follows. Sad. I feel mad that I have to feel sad. I went from being scared for my life to feeling really good. I was scared for my life because I didn't eat that much. Kouri was always drunk or gone. I was always locked in my room. I can't remember, but I am pretty sure the lock was on the outside. Kouri threatened she would kill my lizard because we didn't want to watch some weird show with her. All of our chickens died because there was no food or water. My rabbit died because we didn't have food or water. The goats almost starved to death because she bought moldy hay and she didn't water them. Nothing ever got fed or watered. It didn't feel good to worry about my animals. I felt like I had to take care of my siblings. Ash mostly took care of me though because I was locked in my room. Ash would bring me food. Kouri would lock me up if I told her she was drunk. This happened pretty much daily. I feel angry that she locked me in my room. I am angry almost all my animals died. I am angry she threatened to kill them. I am angry she killed my dad. I started to feel really good when I moved into a safe place. It was safe because the people around me were safe, Katie and Clint. I felt safe at Jake and Shalina because I wasn't with Kouri anymore. Counseling. I feel annoyed that I have to go to counseling and tell the story about what happened 55 million times. I feel better now because I know it's to help me. I would like to not have to go to counseling. I would like to have to not worry about anything after this trial is over. I want the judge to know. I hope Kouri gets convicted to a life sentence. Kouri is always drunk. I want the judge to know my dad was a good person and I miss my dad. I miss my dad, but I do not miss how my life used to be. I don't miss Kouri, I will tell you that.
Thank you. Mr. Bloodworth, anything further from the state?
Your Honor, the state moves to admit state sentencing exhibits A through I previously provided to the court and defense. I have copies now I can bring to the court.
Any objection, Ms. Dester?
Yes, we do object to some of those being on the public docket, and we can, if we want to take a break, we can go through that with the prosecution. I actually sent him an email asking if they would be filed publicly. His response was no, so I was unaware that he was going to do that.
Admitting them and filing them publicly are two different things. Any objection to their admission?
Not to their admission, only to their public filing, Your Honor.
Okay, we can work that out. States A through I are admitted. I need a break. We'll be in recess until 11:10. If during that break you and Ms. Nestor would come to some consensus about what the defense wants to have listed as private and or protected depending on the content.
Your Honor, the state agrees all should be.
Okay, understood. That's the order of the court. We'll be in recess until 11:10. Follow the directions of the court security director and the bailiffs in terms of how to leave and re-enter the courtroom. Thank you. seat. Thank you. We're back on the record in 231-500-139. Mr. Bloodworth, just to confirm, anything further from the state?
No.
Okay. Ms. Lewis, Ms. Nestor, please tell me what's contemplated.
Your Honor, I have some opening remarks. Then we have some letters that some of which we've been asked to read. Others are here to read themselves. Due to the excessive publicity, several of the people have asked that only you and the prosecutor know their names, and that we not say their names. And so I'm going to provide you with each letter as we go that has their actual names on it. All of them are willing to confirm with you privately that they've written these letters as officers of the court. We assure you they have, but they did not want to appear on camera.
That's fine.
And then, after we do a set of the letters, Mr. Ramos has some very brief remarks, and then we're going to put on 3 more. Then Ms. Lewis will close out remarks, and then Ms. Richins will do her allocution at the very end.
Understood.
If that's sufficient.
Please.
Thank you. May it please the court. Excuse me. We began this journey when Kouri Richins stood before this court, stood before your honor, and entered a plea of not guilty. And now, after being convicted by a jury, she stands before you again. And on this day, she will tell you again that she did not do what she has been convicted of doing. And that is her right under the law. And we, her advocates, we are tasked with a sacred duty. A duty to protect and preserve her constitutional rights at all costs. In the face of criticism, scorn, and ridicule from the public, the media, and anybody else connected with this case. We have been committed to our duty throughout this trial, and we remain so today. It is our privilege and honor to stand beside Kouri. We believe in her innocence completely. And we will continue to stand by her as she takes her appeal to the next level, to a higher court. But that battle remains for another day. Today, she stands before you, convicted by a jury of 5 felony counts. We recognize and honor that this court is also tasked with a sacred duty. A duty under the Constitution and laws of our state to decide the appropriate sentence in light of Ms. Richins' convictions. The enormity of that responsibility cannot be denied. Everything we will present to your honor today is submitted for your consideration with an abiding faith in the court's commitment to its sacred duty, and in the prayerful hope that mercy will prevail over calls for retribution. As the state has conceded in their briefing, in order to decide an appropriate sentence, it is right and just for this court to look not only at the conduct for which Kouri Richins has been convicted, but also at her entire life. The good things she has done making her worthy of the mercy of this court. Things such as the personal traits and characteristics that suggest she is not the monster that the prosecution portrays, but a human being, a mother, a daughter, a sister, a friend, a person that has made mistakes, but a person who has loved deeply, a person who's completed acts of kindness and love and care toward others, a person who's contributed to her community, a person who, even in the darkest time of her life, reached out to help others who were incarcerated alongside her, a person who unselfishly tried to ease the pain her family and friends experienced as a result of this case. Now, we have asked people who know Kouri the best to show you the person they know and love. You will hear from family and friends who saw her the most. You will hear from people who worked with her. You will hear from people who spent time with her since she's been incarcerated and have seen how committed she is to rehabilitation while she's in jail. Even more telling, you will hear how she's helped others even when facing unbearable situations in her own life. All of these individuals will reassure this court that she can be productive and make positive contributions in a carceral setting. You've heard from the state their cry for the harshest punishments available under our laws. Yet you also presided over this trial. You saw the evidence and the absence of facts that would justify such penalties. I am sure this court is aware of what a sentence of life without parole actually means in a prison setting. These individuals are locked down in their cells 23 hours a day. They are not provided with the opportunity to participate in programming, seek education, work at jobs in the prison. For all intents and purposes, they are treated as death row inmates. They are denied in-person visitation. They are stripped of any sense of community or humanity. They have no hope of any future reunification with the people they love. Out of the thousands and thousands of cases that go through our criminal justice system, less than 100 individuals have been determined to be worthy of a sentence of life without parole. And that is because judges throughout this state understand that such a sentence presumes that an individual is wholly incapable of redemption or rehabilitation and should be punished in the worst way imaginable until they die alone in a cage. And Ms. Lewis will talk more about that later. But in the meantime, you're also going to hear from 3 people who've never met Kouri Richins. They know nothing about her case, but they know about what life without parole means. You are going to hear from a mother whose son was murdered and how many years ago she was in the position that the Richins family is in now. You will hear about her journey to forgiveness and how after many years she came to regret seeking the penalty of life without parole for her son's killer. You will hear from a woman who understands how Kouri's boys feel. Her father killed her mother and was sentenced to prison. You will hear how she learned to forgive her father and how she's enriched her life through finding her way into a relationship with him again. And you will hear from a former prosecutor, someone who sat right where Mr. Bloodworth sits now, and how he personally witnessed the rehabilitation and tragic end of an individual he put behind bars for life. All of these perspectives are important because they remind us and the court that the recognition of the precious gift of life takes many forms and can change over time. They remind us that the decisions made by this court today can reflect our own humanity and inspire us all to have hope and believe in forgiveness. Finally, Your Honor, you're going to hear from Ms. Richins herself. Her allocution is unusually long. She has worked very hard on it. We ask the court to allow her to take about 30 minutes or so to read her words aloud. She is going to share with you what matters most to her in this world, her love for her boys. It is all she has left. Everything else she has ever held dear in her life has been stripped from her. It is her hope that in openly and honestly sharing her love and hopes and dreams for her boys with you, that you will see what it is inside of her that is worth saving, that is worthy of mercy, and that is filled with hope, humanity, and love. So with the court's indulgence, we'd like to read aloud some letters that have been provided to us. As I discussed, some have asked us to read it and only share the names with you in the prosecution. Some are here to read them themselves. And we are grateful to the court's indulgence to listen. And we're going to start with a letter from Kouri's mother, and Ms. Lewis is going to read that letter. And I have a copy of it that I'm going to provide so the court can read along if you like. And I also have copies for the prosecution as we go.
And we will add this to the information as part of the record.
Thank you, Your Honor. Not public.
Understood.
Yes.
Thank you.
Thank you, Your Honor.
Good morning, Your Honor. Kouri's mother, Lisa Darden, is here in the courtroom. She's actually, I feel, given me the privilege to read her words. She was concerned about her ability to read the person. Your Honor, Kouri is my daughter. I write to you today carrying grief that words struggle to hold. First and foremost, I want to acknowledge the loss of Eric. He was my son-in-law, my friend, and a truly wonderful father. Eric had a kind heart and a generous spirit. He was deeply loved, and he will never be forgotten by me or by the many people whose lives he touched. Eric once saved my life, and I have carried that gratitude with me every day since. His legacy lives on most clearly through the 3 beautiful boys he left behind. Your Honor, I speak today as a mother and as a grandmother. The children are my greatest concerns. These 3 boys have endured unimaginable loss and upheaval in their young lives. They lost their father, then their mother, then the sense of safety and continuity every child deserves. Their world has changed again and again through no choice of their own. Whatever sentence is imposed will shape their lives forever. Whatever sentence is imposed, that was their choice. I will continue to watch the boys grow, whether at school events, or sporting activities, and throughout their lives. I will keep them in my prayers, hoping they grow into emotionally stable and resilient young men. Kouri is more than the worst day of her life. She is a mother who has devoted herself to her children since the day they were born. Before all of this, she was deeply involved in their schooling, their sports, their faith, and their community. She coached teams, volunteered weekly at school, led youth programs, and taught her boys compassion through service, from food banks to flood relief to helping firefighters and families in need. Her life centered on her family and on helping others. In many ways, everyone impacted by this case has suffered loss. However, the greatest burden has fallen on 3 innocent children. These boys have experienced repeated disruption and trauma at an age when stability is essential. Before these events, they lived in a loving home with 2 devoted parents. They were surrounded by family, supported emotionally and financially, and deeply connected to both their mother and father. Their lives revolved around school, sports, family traditions, and feeling safe and loved. That sense of security was taken from them in stages. First, they lost their father suddenly and without preparation. They were informed by officials rather than being guided gently by a parent, a moment that forever changed their childhood. Their mother then spent more than a year helping them navigate grief, modeling compassion and emotional resilience, and working closely with them to understand loss in age-appropriate ways. She even found creative ways to help them cope emotionally during this painful period. Then, they lost daily access to their mother. Once again, they were told life-altering news by strangers rather than family. The boys were moved between placements, disrupting routines and emotional progress, despite beginning to feel settled and unsupported. Throughout this time, they maintained a meaningful and positive relationship with their mother through letters, phone calls, visits, and counseling. Later, they were moved again, against their expressed wishes, away from family caregivers and trusted relationships. Each transition compounded their confusion, anxiety, and grief. Children need continuity to heal, yet these boys have experienced repeated separations from the people they rely on most. As a grandmother who helped raise these children, I have also lost daily contact with them. They were a central part of my life, just as I was part of theirs. The separation from their maternal family has been devastating, not only to me, but to the boys themselves, who deserve access to all safe and loving family connections. Your Honor, these children have already endured more than most adults will in a lifetime. Being placed in the middle of adult proceedings and repeatedly confronted with painful realities risks further emotional harm. They love their mother. They need reassurance, not fear, healing, not more loss. I ask the court to carefully consider the cumulative impact on these children and the importance of preserving their emotional well-being and future stability when determining your appropriate sentence. Your Honor, I ask the court to take a moment to consider Kouri Richins as a whole person, beyond headlines or assumptions, and to understand the life she built before this case. Kouri has been driven, disciplined, and committed to growth from a young age. She graduated from high school in 2007, completing her studies a year early. She continued her education and earned her associate's degree in 2010. In 2012, she obtained her bachelor's degree, the same year she became a mother for the first time. In 2013, Kouri married Eric, and together they began building a family. Their second son was born in 2014. Kouri continued pursuing education while raising her children, earning her master's degree in 2017, followed by the birth of their third son shortly thereafter. Professionally, Kouri has consistently worked to better herself and provide for her family. She obtained her real estate license in 2019 and later earned her general contractor's license in 2021, achievements that reflected her work ethic, independence, and determination. In 2022, Kouri experienced a devastating loss with the sudden death of her husband. Despite profound grief, she sought constructive ways to cope and help others, publishing a children's book in 2023 focused on helping children process loss. After her arrest in 2023, Kouri did not retreat from self-improvement. While incarcerated, she earned her paralegal certificate in 2025. In 2026, she completed her MBA, pursuing education under extraordinarily difficult circumstances. She continues to seek opportunities for further education, demonstrating perseverance and a commitment to growth. Your Honor, this timeline reflects a pattern of responsibility, resilience, and continued effort to better herself, even in the most challenging moments of her life. I would like to illustrate Kouri's character through her actions and the way she lived her life, particularly as a wife, mother, and member of her community. Kouri was deeply devoted to her family. She was a committed wife to Eric and a hands-on present mother to their 3 sons. Their marriage was built on partnership and mutual support. Kouri consistently supported Eric in his career, hobbies, and interests, including his involvement in sports and coaching. She encouraged his passions and stood by him throughout their life together. In return, Eric expressed his commitment to caring for his wife and children, and their shared priorities were apparent in the way they lived and parented. As parents, Kouri and Eric focused on raising kind, engaged, and active children. Kouri was closely involved in her son's education, sports, and activities. She volunteered weekly at their school, coached youth soccer and basketball, served as a scout leader, and was present at practices, games, and events. Her time, energy, and focus were always directed toward her children's well-being and development. Beyond her immediate family, Kouri consistently showed compassion for others. She was active in community service and believed strongly in teaching her children empathy through example. Together, they volunteered at food banks, participated in flood relief by filling sandbags for elderly residents, baked cookies for firefighters during fire season, and assembled care packages for families and individuals in need. She also helped ensure that children in the community had proper winter clothes by donating nearly 100 pairs of snow boots to a local elementary school. During the holidays, Kouri made extraordinary efforts to help others, purchasing, wrapping, and delivering hundreds of gifts to families who were struggling. She also demonstrated thoughtfulness in her extended work family by assembling personalized gift boxes and organizing holiday gatherings to bring people together. In 2023, following her husband's death, Kouri published a children's book designed to help grieving children process loss. She donated hundreds of copies to children who had lost a parent and visited schools to read to students dealing with grief. Although the book achieved some commercial success, her intention was not profit. It was to help children feel less alone during one of the most difficult experiences a child can face. Kouri has always viewed her greatest accomplishment as her family, her husband, her children, and the home they built together. Her loyalty to her family is unwavering. As an aunt, she has been a consistent and loving presence in her nieces' and nephews' lives, providing child care support, attending milestones and school events, and assisting her siblings whenever they needed her. She has been the person who organizes family gatherings, holidays, and shared traditions, keeping the family connected. Faith has also played an important role in Kouri's life. She and her children regularly attended church and participated in faith-based community activities, reinforcing values of service, compassion, and responsibility. Your Honor, these are not isolated gestures. They reflect a long-standing pattern of generosity, responsibility, and care for others. Kouri's life before this case was defined by service to her family and community, and by her commitment to raising her children to be compassionate and engaged members of society. From a young age, Kouri demonstrated responsibility and a strong work ethic. While still in high school, she worked nights, weekends, and holidays to help support her aunt's business, using her earnings to pay her own way through college. That sense of responsibility never diminished. She continued to support extended family members whenever they needed help. Only 3 weeks after losing her husband, Kouri faced another profound loss with the death of her uncle. Even while grieving deeply herself, she stepped forward to help her aunt by taking on the responsibility of planning the funeral. This pattern, putting others' needs ahead of her own pain, has been consistent throughout her life. Kouri has always believed that no one should have to navigate grief or hardship alone. Kouri and I share an exceptionally close relationship as mother and daughter. She has stood beside me during some of the most difficult moments of my life, including surgeries and radiation treatments, providing care, support, and comfort without hesitation. Our relationship is built on mutual reliance, trust, and love. I, in turn, have played an active role in her family's life, helping care for Eric, the boys, and Kouri, and being deeply involved in their daily lives. Kouri also shares a strong bond with her brother. Though close in age, and like many siblings growing up, it was the loss of their father shortly after high school that solidified their understanding of the importance of family. Since then, the relationship has only grown stronger. They have supported each other through life's milestones, challenges, and joys. As a mother, Kouri has always made sure her children felt surrounded by family. She intentionally included her brother in holidays, family gatherings, and everyday moments, reinforcing the value of connection and belonging. She welcomed her brother's wife into the family from the very beginning, making a deliberate effort to ensure she felt included and supported. She has constantly offered help with family milestones, celebrations, and responsibilities, always striving to ease stress for others. Kouri takes pride in maintaining a close-knit family. She believes that shared time, whether during holidays, sporting events, small gatherings, or simply simple evenings together, is essential. Creating those moments of connection has always mattered deeply to her, and she has worked intentionally to keep her family united. Kouri played an important and deeply integrated role within the Richins family, particularly during times of hardship. When Eric's mother passed away in Hawaii, Kouri provided steady emotional support to the entire family and assisted in organizing funeral arrangements, stepping in wherever help was needed during a very painful period. Her commitment to Eric's family was genuine and enduring. At one point, Eric's mother expressed that Kouri was not simply her daughter-in-law, but her daughter, a reflection of the closeness and trust Kouri had earned within the family. Kouri and Eric prioritized time with extended family, creating meaningful memories together, including regular visits to St. George, Utah, to spend time with Eric's grandmother. When one of Eric's sisters faced unemployment, Kouri helped her secure work at the hospital where she herself was employed. She also routinely provided childcare for her sister-in-law's children, allowing them time together as a couple. Her involvement went beyond logistical help. She always participated in family milestones, including serving in a bridal party and assisting with wedding planning for another of Eric's sisters. During a particularly difficult period in that sister's life, Kouri accompanied her to a self-help retreat, offering both emotional support and companionship. Within the Richins family, Kouri often served as a source of calm and connection. She consistently worked to ease tensions, provide comfort, and maintain relationships during challenging moments. Her efforts contribute significantly to the overall well-being of the family. Kouri's compassion extended well beyond her immediate and extended family. She opened her home to the parents of a friend whose house had been damaged, offering them a safe place during a difficult time. When another friend's parents lacked firewood, their sole source of heat during the winter, Kouri arranged for a truckload of wood to ensure they stayed warm. She maintained close, supportive friendships, participated fully in friends' major life events, and was actively involved in the lives of their children. As a neighbor, Kouri was equally attentive and caring. Her home was offering a gathering place for neighborhood children, and she routinely prepared meals for parents working late or offered help to neighbors facing illness, including one undergoing chemotherapy. Her generosity was never performative. It was quiet, consistent, and motivated by genuine concern for others. Kouri is not a perfect person, but she is an authentic one. Her life has been marked by steady acts of kindness, loyalty, and service toward her family, her friends, and her community. She has always found purpose in easing the burden of others and helping people through difficult moments. Following Kouri's separation from her children, they were placed in a living situation that differed from what they expressed as their preference, despite having strong and meaningful bonds with extended family who had long played an active role in helping raise them. As young children, they had little control over these decisions, which added to their sense of uncertainty and loss. Kouri's sons are now facing significant emotional challenges in their day-to-day lives. They are processing grief, separation, and repeated changes, all at an age when stability is critical. Like their mother, Kouri's eldest son is especially sensitive and expressive, and he has struggled deeply with these transitions. All three boys are currently receiving counseling, which has been essential in helping them cope. Kouri has consistently supported therapeutic intervention and has emphasized the importance of counseling not only for each child individually, but for the family as a whole. In particular, she has advocated for additional individual support for her eldest child, recognizing his specific emotional needs. The circumstances surrounding their separation and the rules governing communications have made it difficult for Kouri and her children to openly share their feelings with one another. This limitation has taken an emotional toll on both the boys and their mother. Important thoughts, reassurances, and emotions often remain unspoken, creating additional stress and sadness. As a mother, Kouri experiences deep anguish over her inability to comfort her children as she once did. She worries constantly about their emotional well-being and struggles with the pain of knowing they are hurting while being unable to fully support them. Her concern for her sons remains constant and unwavering. Kouri has endured profound emotional and personal suffering since the loss of her husband. She is grieving the absence of the man she loved and built a life with, while navigating separation from her children and family under intense public scrutiny. The weight of these losses is immense, and it has affected not only Kouri, but her entire family, her mother, her children, and those who love her. Despite being incarcerated, Kouri has continued to demonstrate resilience and personal responsibility. Within the confines of jail, she has dedicated herself to education and self-improvement, using her time to study and work toward meaningful goals. These efforts reflect her character and her desire to grow, contribute, and remain a constructive presence, even under extremely difficult circumstances. Like many marriages, Kouri and Eric faced challenges. When difficulties arose, they chose to address them responsibly by seeking marriage counseling rather than turning away from one another. Those efforts strengthened their relationship. By all accounts from those closest to them, they were in a period of renewed connection and commitment, focused on their family and their future together. Your Honor, I stand before you as Kouri's mother. I love my daughter. I have known her for her entire life, not just through this case. I cannot speak to every aspect of what the court has considered, but I can speak to who she is as a human being, as a mother, and as a member of her family. I do not believe that Kouri did this, nor do I believe Kouri could possibly be capable of this crime. I can't validate what she did financially one way or another, and that's something Kouri will have to live with. I respectfully ask the court to consider a sentence that holds Kouri accountable for the jury's verdict, while still allowing for the possibility of mercy and hope. A sentence without the opportunity for parole would permanently separate her from her children and leave no room for redemption. Kouri's life has meaning, especially to her 3 sons and her family, and I respectfully ask that the sentence reflect not only accountability, but also the potential for rehabilitation and profound long-term impact on innocent children. Your Honor, I ask from a mother's heart that Kouri be given a sentence that allows the possibility of a future, one in which she can continue to grow and one day be a positive presence in life and her children's lives again. I firmly believe the jury reached an incorrect conclusion and that this outcome represents a profound injustice driven by personal bias. I do not believe Kouri is capable of committing murder. No one understands her loves her children as deeply as their mother does. Thank you for listening, Your Honor. I love you, Kouri, Carter, Ashton, and Weston. Her story does not end with this sentence. It is the strength of her comeback that will define it.
Thank you, Ms. Lewis.
Your Honor, at this time we would ask Renee Odom. She is going to read her own letter. We ask that she approach the podium, and I will provide it to the court and the prosecution as well.
Of course. Renee, good morning.
Good morning.
One moment, please. Thank you. Renee, please proceed.
My name is Renee Odom, and I am here today as the sister of Kouri Richins. I want to begin by saying nothing I share today is meant to excuse or lessen the seriousness of what has brought us here. Eric's life was taken, and that loss is permanent. I want to acknowledge Eric by name and say that I loved him. He was kind to me. He was a part of my life, a part of my children's life, and a part of my family. He matters deeply, and he is missed. This tragedy has devastated our family, and its deepest impact continues to fall on Kouri's 3 boys. For more than 3 years now, they have been unable to see or speak with their mother. They have lost their father, and at the same time, they have lost access to their mom. Even in separation, Kouri has never stopped being their mother. She writes to her boys every single week. She reaches out every birthday, every holiday, holding on to that connection with everything she has and reminding them that they are loved. Kouri is my baby sister, and she has been an integral part of my life and the lives of my children. She has shown up for our family in ways that are impossible to count. I was there at her graduation from high school. I was there for the wedding of Kouri and Eric, moments filled with love, hope, and dreams for the future. She was there for my wedding and the birth of my son. She was there for me when I graduated college. She stood beside me at the baptism of both of my daughters. She poured her heart into giving my oldest daughter a beautiful sweet 16. These were not obligations to her. This is who she is. Kouri has always been the glue that held our family together. She hosts every Christmas. She planned every family vacation and made sure that no one ever felt forgotten or left behind. She believes deeply in helping others, and she has lived with this belief throughout her life. Even from behind bars, Kouri has continued to help people, offering support and encouragement and kindness any way she can. That desire to be of service has never left her. Kouri is a great sister, an awesome aunt, an amazing daughter, and she will always be a devoted mother. She is also the smartest person I know. Kouri has earned 2 master's degrees and is applying to a PhD program. Growth and learning and becoming better for herself and others have always mattered to her. Most of all, she loved her husband and her children with everything that she was. I continue to struggle to reconcile this tragedy with the loving sister and the mother I've always known. I understand and respect the court's responsibility to impose a just and lawful sentence. I am not here to challenge the verdict or to minimize the harm that has occurred. I only ask that the court see the full human picture, the pain, the accountability, the lifelong consequences that are already being carried. Please leave room for hope of a life with her boys. The impact of this tragedy will remain with Kouri and her children for the rest of their lives. Our family deeply feels the absence of her presence and that of her boys, her guidance and her love. I love you, Kouri, and I will always stand by you. Thank you, Your Honor, for letting me speak and considering my words.
Your Honor, at this time, I'm going to read a letter from Bree Darden. Your Honor, at this time, we'd like to read a brief letter from Bree Darden. That is Kouri's sister-in-law, who also worked with her at her real estate business. I know Your Honor heard some testimony about that. She has a newborn baby, so she can't be here. Your Honor, I was introduced to the Richins family around 8 years ago, excuse me, and was able to have been around Kouri, Eric, and the boys since the youngest was 1. I spent many days, weekends, holidays, birthdays, barbecues, etc. with them all, and was able to learn so much about the family dynamic and the love they had for one another. No, their family wasn't perfect. No one's is. But those boys were loved beyond belief by both parents. Kouri and Eric did everything for the boys, to protect them, to teach them, to encourage them, to show them love, and mostly to show them 2 loving parents. My heart goes out to the 3 boys, as they do not deserve to be going through all this, as well as they do not deserve to be alienated from one side of their family. I miss them dearly every day. To know Kouri is to know the love she has in her heart. Kouri is one of the most selfless and caring people I know. She lived for those boys and lived to be the best wife she could be. Yes, she made mistakes in her marriage, as we know. So did Eric. But at the end of the day, they chose each other and their family. As a loving mother, exceptional caretaker, and benevolent humanitarian, Kouri was truly a devoted volunteer. She never stood still when she knew she could help another, embodying the definition of true character. From the moment this sudden, unexplainable tragedy occurred, there has been a distaste for Kouri for personal reasons rather than factual reasons. From allegations made by individuals she regarded as family, to authorities not conducting a systemically correct investigation and then not being given a suitable, unbiased venire. The conclusion of this case seemed inevitable. Although I am not here to argue the verdict, I am here to help provide perspective on views you were unable to hear about. Kouri is a mother, a sister, a daughter, an aunt, widow, and at the end of the day, an imperfect person striving for grace. She is someone whom the community trusted, neighbors enjoyed, and her boys counted on as a supporter. I respectfully ask that the court consider the totality of her character and her full life history when making a determination. Your Honor, the next individual that spoke is Kouri's aunt. This is Lisa's sister. Her name is Doreen Kouri. Your Honor, thank you for allowing me to speak today. I have spent many sleepless nights trying to find the right words for this moment because it is heartbreaking to stand here and speak about someone I care deeply about in a courtroom like this. I believe in you, Kouri, and I'm very proud to be your aunt. I stand before the court not to minimize the seriousness of this case, but to speak about the person I've known outside of these proceedings. The woman I know is not the monster these proceedings may have made her appear to be. When I think about her, I do not think about charges, headlines, or verdicts. I think about the mother I watched love her children with every part of herself. I think about the woman who worked hard to build a better life through education, determination, and sacrifice. I think about someone who wanted more not only for herself, but for her children and the people she loved. Her children were never just part of her life. They were her entire world. I watched her celebrate their accomplishments, comfort them in difficult times, and carry the weight of motherhood every single day. She loved fiercely, deeply, and unconditionally. Eric and those boys were her life. Both Eric and Kouri were very loving and attentive parents. They were solid, they loved hard, and they played hard. I also watched her work tirelessly to educate herself and create stability for her family. She pushed herself because she believed in building a meaningful future. She was proud of what she accomplished, but even more proud of being a mother. This conviction does not erase the years of humanity, goodness, and compassion that existed before this moment. I know there are people who may only see the charge or the verdict, but I ask the court to remember a person is more than the worst moment of their life, or in this case, more than a verdict that many of us still struggle to understand and accept. The woman I know is compassionate, intelligent, nurturing, and deeply human. I do not believe she's cruel or beyond redemption. I believe there's still goodness in her, and I know there are many others who believe that too. Whatever sentence is imposed today will not only affect her, it will echo through the lives of her children, her family, and everyone who loves her for years to come. Her children still need their mother's guidance, love, voice, and presence in whatever way they can still have it. I understand the weight of the court's responsibility, and I speak with respect for these proceedings. I only ask that when sentencing is considered, the court remembers the whole person standing before you today. Not only this moment, but the years she spent loving, learning, sacrificing, and being devoted mother. I love you, Kouri, and I love those precious boys. I ask for mercy, I ask for compassion, and I ask that the court see the humanity in her so that so many of us have seen for years. All right, the next one is an individual that did not want their name read in the public, so I'm going to provide it to the court and the prosecution only. This is a close friend of the family. To the Honorable Judge Mrazek, I'm writing to respectfully share my personal relationship and observations with the Richins family and 3 young boys, and to ask that you consider sentencing Kouri to 25 years to life rather than life without the possibility of parole. From 2017 to 2019, I had the privilege of working as a babysitter for Kouri and Eric's 3 children. I was able to view this family at a time when things in life were good for them. The youngest, Weston, was still in diapers, and we worked on potty training together. What struck me most during that time was the stable, loving, and orderly home the 3 boys had to grow up in. Kouri was a young mother, close in age to 2 of my own children, and she'd established a true house of order. The home was beautifully decorated. I particularly remember the bright fall decor. The walls were lined with photos of the boys at different ages, and they had a wonderful playroom over the garage. The family worked together, played hard together, and clearly loved one another. I recognized the effort and pride in caring for her family. When she was out of town one week, she left detailed meal plans for me to use the crock pot so Eric could come home each night to dinner with the boys. Those meals were so good that I replicated them for my own family. I was so impressed by her age progression photo display in the hallway that I had canvases made of my own grandchildren in a similar fashion. I even copied some of her simple but festive fall decorations and bought similar cowboy kid toys for my grandchildren after seeing how much her boys enjoyed them. Kouri's positive influence extended beyond her own family. I brought many of her ideas home with me. I do not wish to minimize the tragedy of this case. I watched the funeral online and was heartbroken, especially hearing young Carter say he would now be the man of the house. I believe Kouri deeply cares for her children, and I have to believe they love her as well. 3 boys' lives will be forever affected by the court's decision. I believe in the possibility of rehabilitation and the value of preserving hope. I respectfully ask that you not eliminate the chance that one day these 3 sons would be able to make their own choice as to whether or not to have a relationship with their mother. Kouri is not a threat to society. Please give her the opportunity to serve her sentence with the possibility of someday returning to her family. Thank you for your time and considering my perspective. Your Honor, the next individual that's going to be addressing the court is going to do it himself, and that is Mr. Greg Hall, and he's here to read his statement to the court.
Sir, please proceed.
Good morning. Good morning, Your Honor. Before I say anything else, I want to express my deepest sympathy and most sincere condolences to the Richins and Darden's families. Nothing I say today is meant to diminish the weight of what has brought us into this courtroom today. My name is Greg Hall. I have known Kouri for over 7 years, both personally and professionally. And we have stayed in daily contact by phone, text, and in-person visits throughout her entire incarceration here in Summit County. I am here today to share with you what I have witnessed firsthand about the person I know. In the years before Kouri was incarcerated, she made a habit of looking for people who were struggling. She not only volunteered for many years at children's schools and donated, but you've heard about the 100 pairs of snow boots, but she also did follow up to make sure that those children had clothes. She has volunteered at the soup kitchen for years and brought her boys along with her because she wanted them to teach them about service and kindness to others. When Kouri found out a neighbor had been diagnosed with cancer, she anonymously arranged for a massage therapist to visit her. When my own wife was in an auto accident, a care package showed up at our home. If a family was having a difficult time purchasing a home, she would offer to take little or no commission in order to help them. Please know that none of these things were ever done for recognition. They were done because all she ever wanted to do was good. Your Honor, what I would like the court to understand the most is that the goodness and kindness toward other people that defined Kouri before her arrest has not gone away since being incarcerated. When new inmates arrive frightened and disorientated, Kouri is the first to step in. She helps them get their footing in an environment that is unfamiliar and frightening to them. She's also tutored other inmates working to further their education. She has helped women who cannot read or write navigate through the system and draft letters to their family on the outside. When women in her unit receive bad news from home, she is the first to sit with them and comfort them. She has used her time inside to study, and she takes her studies very seriously. She has earned multiple degrees, including a master's degree since being incarcerated, because she wants to be of use to other incarcerated women who struggle with literacy, with their legal paperwork, and with the simple daily reality of being inside. She enjoys studying religion and ethics and the practical application they have in our lives. She attends weekly church services and has helped to create new programs within the jail that other inmates now rely on. She studies late into the night, every night. She prays for her boys and for her family every day. She also prays for others in need. She writes to her sons, though her letters are returned to her unopened. She has not stopped trying to contact them, to express her love for them. Your Honor, the Kouri that I talk with each day is still filled with kindness, with goodness. Even to this day, as we speak to one another, she continues to ask and care about how people on the outside are doing. My family, her family, people we mutually know, before ever talking about herself. I'm not here to argue with the verdict of this court. I am here to tell you that the person I have known for over 7 years is still there, still trying, still useful to people around her in the small ways available to her to continue to be of service and provide acts of kindness. I only ask that the court please take this into consideration today. Thank you, Your Honor.
Thank you, sir.
Your Honor, the next two letters are from individuals who are investors with Ms. Richins in her real estate business. Both of these individuals did experience losses of money. So although they may not be victims in this case, they, I guess, are technically victims in the case that is pending. So I think their perspective is important. The first one, for some reason, I only have one copy. I'm going to give just a moment for Mr. Bloodworth to read it. Then I'll read it, and then I'll hand it to the court.
Thank you.
Honorable Judge Mrazek, I'm writing to you regarding whatever sentence you need to impose on Kouri Richins. I implore you to impose the lowest sentence possible, including the possibility for parole. Due to the defense resting in this case, you and the jury only heard everything negative that could possibly be said about her from the prosecution, their witnesses, and the media. There was always another side of her that was not presented. As one of the investors in some of Kouri Richins' properties, she never asked that we invest. We always asked her after seeing the quality of the work done. She had a real estate license and got a general contractor's license. Yes, we made money on some of the properties, and yes, we lost money on the legacy property due to her arrest. She made sure we were aware that we could lose our investments. During the time we did spend with her, we found her to be honest, caring, super smart, and constantly talking about her love of Eric and her children. She adores those boys and was involved in all aspects of their lives and very proud of all of them. I understand she has used the time in jail to obtain a second master's degree. I honestly believe that even spending time in prison, that she could still be a valuable and contributing member of society and hopefully one day have a relationship with her boys. I do totally understand how difficult it is to have someone's life in your hands, as I felt that weight as an Air Force flight nurse in Iraq many times, caring for our wounded warriors. We all need to have hope. Please do not take that from her, as she has already lost so much. And I'm not going to reveal the name on public.
Thank you.
The second one is also an investor, Your Honor, that did lose a significant amount of money. So some type of victim status here. Honorable Richard Mrozik, thank you, Your Honor, for the opportunity to address the court at this sentencing hearing. Actually, okay, I do have an extra of that one. Thank you for the opportunity to address the court at this sentencing hearing for Kouri Richins. May I first say that I was so impressed with your professionalism and demeanor during the trial. It appeared to me that you were very thoughtful in trying to judge fairly during the court proceedings. I would like to speak on my real estate experience with Kouri over the 3 years that I invested in 10 or more fix and flip home transactions. My wife, my son, and I were so impressed with Kouri and the great job she did in finding and remodeling the homes that we invested in. She worked hard in making those properties look beautiful after they were remodeled, and we all made money from them. We could not have been more proud of Kouri and happy for her and her family. Knowing from her brother Ronnie that she'd lost her father at a younger age, I told her once in a text message that I was unofficially adopting her as my daughter. She was a great mom for her boys, and she and Eric were so involved in their lives. What has happened since has been a tragedy for all the families involved. I never met Eric, but knew that he and his workers helped with some of the stonework on the remodels. Kouri and Eric helped stage a house that my son and I remodeled that Kouri found for us in Ogden. She listed it and had it sold in 3 days. Those were good times when the market was great for doing fix and flips, and we all benefited from it. Unfortunately, about the time of Eric's passing, the market changed and interest rates skyrocketed. Those who had house remodel properties suddenly found the buyer's market dried up and houses were not selling. We lost money as well as many of our friends in the real estate business. In watching some of the proceeding on court TV, I personally did not think that the state proved beyond a reasonable doubt that Kouri was guilty and responsible for Eric's death. I was surprised at the jury's verdict because it left doubt in my mind based on the testimonies given. Kouri has lost everything: her husband, her 3 young boys, friends, family, and her home. May I appeal to the court that her sentencing may grant her the possibility of parole at some future time. Thank you for your kind consideration. And also this name we are not reading out loud. We also have several very short statements from people who have worked with Ms. Richins in the jail. These are volunteers that give their time, no money, that come to the jail to help people that are incarcerated to try to better themselves and better their lives. This first one is from the art class facilitator, Ms. Katie Fish. Dear Judge Mrozik, I'm writing to you today on behalf of Ms. Kouri Richins. I have known Kouri over the last 2 years within the context of the educational programs for the Summit County Justice Center. I facilitate an art class as a representative of Mountain Life Church. In that art class, Kouri's carried herself with ease and warm regard to the other inmates and those of us present as facilitators. While she's shown care for the other inmates, she has also been very respectful to those of us facilitating. Even when she had been carrying challenging emotions, she's conducted herself with respect and grace. I understand that my interactions have been limited and have been laced with an expectation of certain polite behavior, but it is also not just a given that inmates will uphold that same respect and decorum. She has chosen to present with ease, care, and grace. From the brief conversations we've had about her life, I do believe she is a different person from who she was before being there. I hope and pray that her heart continues to be led toward faith and transformation. Thank you for your time. The next individual is another volunteer who teaches the class of biblical truth at the jail. This individual is named Eric Aper. Dear Honorable Richard Mrozik, my name is Eric Marty Aper. Through Mountain Life Church in Park City, I've been a volunteer at the Summit County Jail for 8 years, helping to teach biblical truth to those incarcerated there and leading church services on Sunday afternoons. Kouri Richins has been a regular attendee of these services since May of 2023. the start of her incarceration and has shown an amazingly consistent and upbeat, positive attitude. Kouri contributes in the church service discussions. She frequently comes alongside other inmates and encourages them to attend church as well. Not only does she encourage church attendance, she also carries the applicable issues that we discuss back to the pod where she resides, looking to find the peace and love of Jesus Christ in difficult situations where the inmates live. I have witnessed her kindness in talking with and encouraging fellow inmates that they can succeed in drug treatment programs, complete education programs, and work to overcome frustrations that come with poor decisions that end up with incarceration. Please call me with any questions or let me know what I can do to help with regards to Kouri Richins. And then the last one is also, I believe, a pastor that leads church services. Nope, I think I might pull that out. Yeah, I do. I don't think I have that one, so I may need, thank you. This next one then is from Craig Moline, who's one of the pastors as well. Can you read that while I'm doing this? To the Honorable Richard Mrazek, Your Honor, I'm one of 4 people privileged to rotate in on Sunday afternoons from Mountain Life Church to lead church services with inmates at Summit County Jail. On any typical Sunday, we will pray with inmates, sing a couple of songs, no matter how bad it may sound, read a psalm and discuss it, and then teach on a subject from Scripture. For 3 years now, Kouri Richins has been in attendance to those services. We've seen her be hospitable to other inmates, inviting them to services. She's participated in discussions, and we've seen her as a help to other inmates. At the beginning, we gave her a study Bible that helps give life application hints along with an explanation of the text. I smiled recently when I saw her Bible sitting in front of her, and I observed it doesn't look new anymore. It looks like a well-read book. In our teaching and discussions, we have talked about being intentional about posturing our hearts before sovereign God and coming to Him with humility with our prayers. We talk about what it means to have a personal and intimate relationship with God through Jesus. She has acknowledged her faith in Jesus and acknowledged she has felt His peace in rough times, what is often expressed in the Psalms. She has commented, when life around you falls apart, we still have a God to lean into and who reaches down and cares for us and gives us comfort and hope. The Kouri I know will thrive where she is. She will trust in her God for peace, and she will pray. She will continue to pray for her loved ones, and she will be a positive influence to those around her. Respectfully submitted. And then one last letter from the jail. Oh, yes. This is also a volunteer, an individual named Heidi Tunney. Dear Judge Mrazek, I'm writing to you on behalf of Kouri Richins. I've been working with Kouri over the past 2+ years as a volunteer at the Summit County Correctional Facility. I taught her in the addiction recovery program. I attended church with her on occasion. I worked with her in a yoga program that I started at the facility for the incarcerated men and women too. I found Kouri to be very easy to work with and very enjoyable to be around. She was very thoughtful in her conversations in class. She always showed the utmost gratitude for anything that was done on her behalf. I also noticed that she was a leader among the other incarcerated women. She tended to be a peacemaker and stayed above the fray and away from the pettiness and challenges that sometimes arise among incarcerated women. The women in general respected her and looked to her as a leader. Kouri actually was one of the women that asked me to get a yoga program started for the incarcerated women. She saw a need there and she acted on it. I started and have taught that class for almost 2 years now. Kouri was the most dedicated student. She only missed a couple of times the entire time I taught, and the times she did miss were when she was meeting with attorneys or had court appearances. She has continued to attend even after she was found guilty at her trial. I wish nothing but the best for Kouri. She has a very long road ahead of her. I hope and pray she will continue to use the programs provided to those that are incarcerated to better herself and lead the other women around her. The last letter we have in this section is going to be read by Kouri's brother, Ronnie, who's here to read it himself. And then we're going to have, Mr. Ramos, there it is. Mr. Ramos make a few very brief comments Then we'll conclude with our final three, and then we'll close out with Ms. Lewis and Ms. Richins, unless the court needs a break. Doing all right?
No, it might make sense to take a break before Ms. Richins, given what you have previewed regarding timing.
Great suggestion, Your Honor.
Okay.
All right, this is, if Ronnie can come on up.
Good morning, Honor. I'd like to address the court with actually a person what I did to break the Kouri.
Okay.
Little sister, I love you. I miss you. I miss our random banter. I miss your calls. I miss your constantly over-the-top positive attitude every time you speak. I miss our game nights. I miss Eric's stupid finger gun dance after we won a game. I miss our holidays. I miss you sending the boys to wake me up on Christmas morning, way too early after we stayed up way too late preparing Christmas for them so that it would be absolutely perfect. I miss our Sundays together. I miss arguing with the boys about who's better, Messi or Ronaldo, Brady or Rogers. I miss our backyard games. I miss me and the boys running all over you at sports in the backyard and Eric getting mad because you weren't competitive enough and you were really just out there to have fun and laugh. I miss you constantly luring me into your newest ideas and getting me excited about them. I miss vacationing. I miss family volleyball. I miss playing Madden and FIFA with Eric and the boys. I miss your stupid goats. I miss the soccer games and the celebrations we created for the boys after they scored a goal. I miss Carter's smile and his obsession with goat videos. Ashton's freckles and his competitiveness. And Weston's baby blues and tenderheartedness. I miss hearing them say Wani and playing catch in your living room. I miss your family. I miss our family. I miss the life that was stolen. I miss the life that was stolen from us for reasons that we can't yet fully understand. We don't, with 100% certainty, know what happened to Eric. No one does, but we do know with 100% certainty that it wasn't caused by you. We know that, the police know it, the prosecution knows it, and everyone watching this trial knows it. They could not prove their theory, just the opposite, and yet here we are. For some reason, unbeknownst to us, really bad things happen to really good people, Cor, and you were just really too good of a person, I guess. I promised Dad a long time ago that I'd always look after you, Mom, and I intend on keeping that promise. We'll get through this together, and the injustice that's occurred here in this courtroom, it'll be righted in time. Your innocence will shine too brightly to be contained once you've actually had a fair shot at defending yourself. When the day comes, I just know somehow that you're going to change a lot of lives that really need your help. And until then, little sister, just know. Just know that I'm right by your side, and I'll always be right here for you. I love you.
All right, thank you. Mr. Ramos.
Morning, Judge.
Your Honor, I want to maybe begin by speaking just plainly and honestly. I disagree with the jury's verdict. I'm deeply saddened by the way that justice was rendered in this case. I don't believe that this outcome fully reflects the truth or the humanity involved. But our Constitution demands something difficult of all of us, especially of officers of the court. It demands restraint. It demands respect for the process even when the outcome wounds us. And so, while I disagree with the verdict, I respect the jury's decision. And while I disagree with many of this court's rulings, I respect the lawful authority of this court, and of Your Honor. This is because the rule of law only survives if we continue to honor it, even in moments of disappointment and pain. But as a Catholic, there's one authority higher than any courtroom, verdict, or government power, and that is God. I say that as a reminder of humanity and of human limitation. Our system of justice is imperfect because every human is imperfect. I think that humility matters here today. It matters because the sentence of life without parole risks becoming something greater than punishment. It risks becoming the declaration that redemption no longer matters. The late Pope Francis said that life without parole is just a death penalty in disguise because it extinguishes something fundamental to human dignity, and that is hope. Hope to all involved, victims, condemned alike. Refusing to impose a sentence of life without parole today doesn't mean Kouri is going to walk free. It doesn't mean that she will someday leave custody. She may very well spend the rest of her natural life in prison. It also does not mean that her victims who have spoken today, her kids, doesn't mean that they have to forgive her. They may never change their minds. They may never forgive their mother. And also, no court has the authority to demand that they do. But refusing to impose a sentence of life without parole does mean that we do not close the door completely. It means we do not presume to know with absolute certainty what a human life, victim or condemned, may become decades from now. It means that we do not extinguish hope entirely. Time changes people, pain changes people, grief changes people. Even victims and victims' families over years and decades sometimes arrive at places their present suffering could never foresee. Some discover forgiveness, some discover peace, some simply discover that healing and permanent condemnation are not always the same thing. And others don't. A sentence of life without parole assumes none of that human change matters. Not the change in the person condemned, not the change in those harmed. A life without parole sentence freezes every human being, victim and condemned, inside the worst moment of their life and declares that moment permanent. Our Constitution demands more restraint than that, because a real measure of justice is not what we do when mercy is easy. It is whether we preserve humanity when mercy is hardest. No sentence handed down today will undo suffering. A different verdict wouldn't have reversed tragedy. But there is a profound moral difference between saying you must be punished and saying you are beyond redemption forever. One is justice restrained by humility. The other risks becoming judgment without end. And no human institution possesses the moral certainty to make that judgment absolutely. That lies with God alone. Thank you, Judge.
Thank you, Mr. Rose.
Your Honor, I told you in the opening statements that we were going to do something a little bit different when we called upon some perspectives of people that don't even know Kouri, but that have been through this horrific journey through no choice of their own. One is from a mother whose son was murdered. Again, we're going to just share her name with only the court and the prosecution. Honorable Honorable Judge Richard Mrazek. I'm going to skip the names, including the name of her son. My son was murdered almost 30 years ago in a random act of violence. He was only 18 years old. The man who killed him was just a few months older. I know the kind of grief that changes your life. I have felt the despair, darkness, and rage that comes from that loss. I know what it's like to try to rebuild your life with a heart that will never be whole again. And I know what it feels like to believe that the only thing that will ease that pain is inflicting pain on the person responsible for never getting another day with the one you love. I grieve with the family of Eric Richins. I am heartbroken for them, especially his children. And I want to be clear that nothing I'm sharing today about the criminal justice system and its many failings should be taken as any sort of criticism of them and how they feel or act in their grief. But I feel compelled to share my perspective with the court because I wish I had known what might be on the other side of experiencing the grief of losing my son and trying to navigate the criminal justice process at the same time. And I don't envy the decisions you have to make. I only want to tell you a little of what one broken-hearted mother has learned, and that is that the criminal justice system needs more humanity. It needs more mercy. And I know this because of the man who murdered my son. Sending someone to prison without the possibility of parole should be reserved for the very rare, absolutely most heinous cases. Sending someone to prison without the possibility of parole is to decide they are irredeemable, that they are not capable of change, and will never be worthy of our trust again. It is a fate so bleak, I am not sure how anyone survives it, let alone do what my son's killer did. He went into the worst place imaginable and found a way to be a better human being. He spent the first 18 years of his adult life in maximum security. Those who are sentenced to life without the possibility of parole have few opportunities to participate in programs or work because resources are limited, and why would they waste them on someone who's never getting out of prison? The criminal justice system has gotten better and better at punishment. Mercy has almost been extinguished. We're supposed to find a balance. We're supposed to remember that these are human beings, and these decisions will ripple through generations, even strangers. I am afraid with the increasing number of people sentenced to life without even the possibility of parole, we've decided it's easier to throw people away than to try and help them change, or even allow them to try and make amends for their mistakes. Far too often we let our fear and our pain put the focus on punishment with no consideration for mercy. I did that. I wanted the man who killed my son to die. I wanted him to suffer. I didn't care what happened to him as long as he never got out of prison. But as much as I know about pain and loss, I know more about hope and forgiveness, and that's thanks in part to the man who killed my son. He was sent to one of the worst places in the world and became one of the best people I know. Nearly 20 years after my son's death, I received a letter he wrote, expressing his sorrow and his remorse. His apology helped me heal, deepened my forgiveness, and created a bond that continues to bless the lives of many people. I know that every case is different, but I also know the power of hope. I believe in second chances. I believe a life sentence imposes punishment without destroying hope. My personal hope for Kouri is that she does what that individual did, that she finds a way to become a better person no matter what. I thank you for taking the time to read this letter. I know it's a heavy burden to make this decision. I express love and support to those involved and pray we'll all be better to each other. And then I also would have one more, and then we have someone who's going to testify on WebEx. Speak on WebEx, not testify, sorry, speak on WebEx. This is very short, Your Honor. It is from a former prosecutor that imposed these types of punishments. Thank you so much. Also, I'm keeping his name private. As a matter of fact, I'm going to skip the very first sentence because it would reveal who he is. So I'll just let the court read the first sentence quietly. I was in charge of the prosecution of a young man who committed 2 serious homicides at the Log Haven restaurant. He was prosecuted and found guilty. He was sentenced to 2 consecutive 5-to-life terms. 20 years later, while no longer a prosecutor, I happened to be at the Utah State Prison on government business. I was given a tour of the prison industries unit, and I saw an individual sitting at a large desk in front of a bank of computers. I asked about him and was told that he was the individual who had committed the crimes at Log Haven. I was told he was a model inmate, spoke 5 languages, had 2 master's degrees from Utah State, and was used as a go-between when there was unrest among inmates. He was respected by his fellow inmates. He was indispensable at the industries and had set up the entire computer system to run the unit. Coincidentally, the very next day I was speaking with the son-in-law of the father of one of the victims. He related to me how there had been a complete reconciliation between their family and the killer of their son. They had long ago forgiven him and wondered if I could help getting him paroled. I still had connections in the criminal justice system, and I told them I would try. I subsequently met with him at the prison, and I was equally impressed with how he had turned his life around. We were able to get him an expedited parole hearing. Tragically, he died from suicide a few months later when he was falsely accused of inappropriate access of the state computer system and removed from his position into a secure unit of the prison. This case was a textbook lesson of how rehabilitation can work. He was not the same cocky druggie that we sent to prison 20 years ago. I saw absolutely no reason why he needed to spend more years in custody. Even his fellow inmates told me they were convinced he had done everything to reform himself and become a valuable member of society. I agreed. Keeping someone incarcerated when they've proven themselves is just plain wrong. Prison sentences without possibility of parole create the same issue. I believe it should be reserved for the most violent and dangerous of individuals. Thank you for taking the time to read this. And then Ms. Lewis will introduce the final speaker, and then she'll have her comments, and then we'll take that break.
Who is the person you'd like me to?
Emery Blanchard.
One moment, please. Emery, if you'd please unmute your audio, I'd appreciate it.
Are we able to see her?
Oh, my apologies. Thank you. Emery, can you hear me okay?
Yes, sir, I can.
Okay. Ms. Lewis is going to make an introduction, and then you'll be free to make your statement.
Emery Blanchard understands what no one else in this courtroom understands. What the 3 children of Kouri and Eric are going through. When Emery was 12, I believe, she can correct me if I'm off there a little bit, her father violently killed her mother while she and her brother were in the next room. He was convicted, and it was, the state was seeking death, but ultimately he, at that time, when the jury couldn't decide unanimously on death, he was sentenced to life with the possibility of parole. And I'm going to let Emery take it from there and see what she wants to say.
Emery, please proceed.
Thank you, Judge. Good afternoon. I was asked here today to speak about a personal experience. My name is Emery Blanchard. I grew up in Park City, and in 1995, when I was 13, my father murdered my mother, Patty. It was a brutal and premeditated murder, and I was in the house when it happened and witnessed it. It was a death penalty case, but my father was sentenced to life in prison with the possibility of parole. At the time, I wanted him to go to prison for a long time, and I didn't want to see him again. I was afraid for my life and safety as well. My mother's parents and uncle raised me. We would refuse phone calls from the prison, but my family collected every letter he sent and saved them in boxes, just in case I ever wanted to read them. In a short 4 years, when I was about to turn 18, I decided I wanted to see my dad. I had questions regarding the murder that I needed answered for my own mental health. My amazing grandmother offered to take me to the prison while I was a minor if I wanted to see my dad. I wanted to spare her from having to face the man who killed her daughter, so I waited until I was 18 and could go to the prison on my own. I didn't know if I would be fearful of my father, or perhaps even so angry that I might attack him. None of that happened. The moment I saw him for the first time in over 4 years, he simply hung his head and said to me, "I'm sorry." We both burst into tears and held each other. I felt safe and as whole as possible again in his embrace. Yes, this was the man who killed my wonderful mother, but at that moment I realized he was still my dad, and I still needed him. The next decades were good at times and very hard at times. Many years I visited my dad often in prison. Some years were exceptionally hard for me, and I chose not to see him at all. I experienced a full range of emotions, and all of them were valid. I knew for my own health and peace, I had to learn to let go and forgive. No easy task, but this is when I truly mastered empathy and compassion. My father served 25 years until his first parole hearing. I was for parole, but nevertheless, he was denied and given another 5 years. At his age, I knew it was a death sentence, and it was. Just last year, after 30 years of incarceration, he died 4 days shy of his 81st birthday. My second worst nightmare came true, the first being my mom being murdered. I was not able to see him while he was dying. There was no compassionate release. Some may say he deserved that, and maybe he did. I can tell you that no amount of time served ever made this situation right. 20 years, 30 years, and even death. None of it can bring back my mom or repair the immeasurable damage that he caused me and my family. Once 20 years had passed, my grandmother even said to me, "It's been long enough. You want your dad." I wanted my mom, but I did still have a living parent, and I needed him. I don't tell you this story to tell you how to feel or that I understand how you feel. I'm offering that hearts and feelings can change over the years. To honor my mother, I'm a victim advocate who supports people in domestic violence situations, and I now help people with PTSD heal at my ranch in southern Utah using nature, horses, and farm animals as teachers. I teach compassion for humans and animals alike, and I found a way to turn my pain into purpose. But I will tell you honestly that life is still hard, and losing both of my parents at that young age harmed me greatly and left me with a very sad and lonely heart. No amount of prison time made me feel better, and in the later years, my father's incarceration wore on me severely. What I will leave you with is this: hold tightly to the good memories of your father, and in time, perhaps your mother too. Cling to your family and siblings for love and support. Please let love reside in your hearts and not hate. I pray for your family and for your peace and healing, and thank you for allowing me to speak today.
Emery, thank you very much.
Thank you, Emery. Your Honor, there is so much more to sentencing a person than punishment. That is why in sentencing someone, the court must consider the totality of the circumstances, the whole person, and who that person is beyond their worst act. In their sentencing memo, the state cited to State v. Holland, which was a death penalty case. The state quoted the court as follows: "The psychological reality is that aggravating circumstances in first-degree murder cases will virtually always outweigh mitigating circumstances." However, what the state left out is what the court said next, which was that the Eighth Amendment doesn't allow the death penalty in every case, and courts must take a long, hard look at the totality of the circumstances, the values of society, and the value of all human life. And though this is not a death penalty case, the same would apply to a sentence of life without the possibility of parole. Ms. Nestor spoke a little bit about what a life without parole sentence looks like. Locked down for 23 hours a day. If we treated our dogs like this, they would be taken away. Yet, this is how the state wants Kouri Richins to be treated. A sentence of life without parole is safe for only the most heinous of crimes. The state wants to place Kouri in that category. They say she is in that category. but this simply is not the type of crime that we typically see get a sentence of life without parole. Currently, there are approximately only 72 people in Utah serving this sentence. These include people such as Edward Deli, the co-defendant of Vaughn Taylor, who is currently on death row. They killed 2 women, kidnapped 2 young girls, and attempted to kill those girls' father by lighting their cabin on fire. I believe that was in Summit County. It includes Daniel Ray Troyer, a serial killer and rapist of women in their 80s. He was convicted of killing 2 women, admitted to a 3rd, and likely killed a 4th. That authorities are aware of. It includes Matthew John Breck, who kidnapped a 10-year-old girl, stabbed her multiple times, severed her spinal cord, and left her dead on her front porch. It includes numerous individuals who brutally murdered children, some who murdered police officers. There are only a handful of people serving life without the possibility of parole for killing a spouse. And in all but one of these that I could find, they killed more than just their spouse. They are individuals who killed their spouse and a child, or killed their spouse and someone else in the process. The only one I'm aware of who killed a spouse and no other individual is Craig Crawford, who set fire to the home of his estranged husband, leaving him to die in the fire. And then there are individuals serving sentences of 15 to life who committed arguably more heinous acts than what Kouri Richins has been convicted of. Eric Sampson abused his wife for 28 years, ultimately killing her in their St. George home, leaving her dead in their bed. He continues to maintain his innocence, and he's serving 15 to life. John Weston Erickson stabbed his wife to death in front of their 2 young children, also injuring his 7-year-old daughter, who attempted to wrestle the knife out of his hand, serving 15 to life. Joseph Castillo, his wife, stabbed his wife to death in their garage while his teenage son tried to stop the attack. These men are all serving 15 to life sentences. There are many more examples. Murder is the worst of all crimes, but to say that this particular case is the worst of the worst is simply not true. The state chose the evidence they put forth to obtain their conviction, yet they are not satisfied with what was presented in this court and to the jury, and instead they waited until 2 days before the sentencing hearing and publicly filed what can only be described as a character assassination, filled with unsubstantiated claims from unknown and unsworn sources who will never be cross-examined about these claims. The timing of this filing was no coincidence and left no time for our team to arrange rebuttal witnesses or evidence. Furthermore, it appears that the sentencing memo was not a so subtle attempt to get into the public eye evidence they elected to hold back from their case in chief, and then were precluded from presenting when Ms. Richins exercised her Fifth Amendment right to remain silent and submitted the case to the jury without putting on any evidence. To allow the state to use the sentencing hearing as a public platform to make new unsworn allegations untested by cross-examination or sufficient investigation would violate Ms. Richins' right to due process and would be contrary to the Utah Supreme Court's finding in State versus Limesick. I don't know if I'm pronouncing that right, but I have the site if you want it. Which stating that the due process clause of Article 1, Section 7 of the Utah Constitution requires that a sentencing judge act on reasonably reliable and relevant information and exercising discretion in fixing a sentence. The state's memo should be stricken in its entirety and not considered by this court. Not only are the claims made by the state in their sentencing memo unreliable and irrelevant, much of what they argue is either misleading or outright false. I'm not going to go into everything that we take issue with, but I do want to point out a couple of examples. They state that DCFS supported a finding of emotional and physical abuse by Kouri against her oldest son. What actually happened is that DCFS made an initial finding based solely on reports. This is similar to a probable cause finding that then sends the matter to the juvenile court. The court, however, did not find that Kouri had abused or neglected her children. They found dependent but no fault. In other words, that the children needed intervention, but due to no fault of Kouri Richins, due only to the fact that she had been arrested. They did not even find that she had acted negligently towards her children. The state put forth at length what they believe Kouri's middle son, AR, would have testified to had they been able to call him in rebuttal. Although it is true that Ashton said these things 3 years after the death of his father and after conversations with Eric's family members, this is very different than what he said to law enforcement immediately upon Kouri's arrest a year after Eric's death. At that time, his statements were completely consistent with Kouri's, that Kouri, had gone to sleep in his room the night his father died. The state argues that Kouri's boys are afraid in part because she still maintains life insurance policies on them. Kouri was of the belief that these policies were no longer in existence since she had not made any payments on them in over 3 years. And in fact, a letter was sent, or an email was sent from Brian Freckleton, who testified, to Ronnie Darden, as Ronnie is the owner on these policies, that this was over a year ago, that the life insurance policies are lapsing, and wanted to let them know if they chose to do anything about that, which they did not do anything about that. So we only discovered yesterday, Kouri only discovered yesterday that at least 2 of these policies are still active, as the payments have been automatically taken out of dividends. So in other words, the policies have been paying for themselves. These are policies that Eric and Kouri took out together in 2017. However, now that Kouri knows that these are still active, she will cancel them. Hopefully, in all sincerity, this will be one less thing for those boys to worry about. Kouri never asked her family to report criminal activity or asked for criminal prosecutions against any of the Richins family or against Cody Ray. She never asked family members to file bar complaints. And until yesterday, neither Kouri nor anyone from her team had ever heard anything about a dating profile being set up online in the name of a lead detective. She did none of these things. And if they were done by others, it was not at her request. We are asking the court to discount any and all allegations in the sentencing memo that have not been previously raised in court in order to be stricken from the record. The court does have before it reasonable and reliable testimony from individuals who know Kouri or who have unique perspectives on the sentence of life without parole that may assist this court in discerning the appropriate and proportionate punishment in this case. The testimony of these individuals revealed that Kouri is so much more than what she has been portrayed as in this case. Everyone who was around her says she was a wonderful mother, just like Eric was a wonderful father. The state argues that she shows no remorse. Kouri has remorse, and she has regrets about many things, and you're going to hear some of those when she speaks. However, she cannot show remorse over something she did not do. She maintains her innocence and has every right to do so. Having said that, however, she stands before this court today convicted of the crimes charged, and she fully understands them. So sentence her on what she was convicted on, not what the prosecution says about her character. As much as they think they know her, they do not. They do not know Kouri Richins. Like Alex said, we're saddened by this case. We are saddened by the verdict. I respect the court system so much. I come from a family of judges and attorneys and was raised with the utmost respect for our justice system. I disagree with the verdict, but I respect it. I have to say though, in all the years of practicing, which are now quite a few, this is the first time I've had a client convicted that I believe to be innocent. It was much more painful than I would have anticipated. Over the last 2 years, our team has got to know Kouri. Kouri is one of those clients, very few clients, and I've represented thousands of people. Most of them you don't remember. Many of them you don't like. Many of them, some of them, you feel are dangerous. But Kouri is different. Kouri, every time she calls, asks how we are. There have been times when I've shared bits of my life with Kouri, particularly having children that lost their father before age 10. We've talked a lot about that and what that does to children in the best of circumstances. I can't imagine had my boys not had me. because the pain and suffering and the long-term effect that it's had on them will never, ever end. But when I share something with Kouri, when I share that someone is ill or that someone is having a problem, sometimes I don't even remember I've said it, and when she calls me, she always asks, how did that turn out? You know, is your family member okay? Before we talk about her. Every time. The state is not only asking for life without the possibility of parole, they're asking for consecutive sentences. The sentences in this matter should run concurrent to one another. Pursuant to the line of cases, Strunk, Golly, and Smith, the sentencing statute favors concurrent sentences. And looking at the totality of the circumstances, imposing consecutive sentence would constitute an abuse of discretion. In State v. Gray, the Utah Court of Appeals cited Golly and Strunk, holding that the Board of Prisons' ability to grant parole is an integrated component of the rehabilitative needs factor that must be balanced with other required factors. Even though the statutory language has been modified since Strunk, Golly, and Smith, the language still applies. And the Supreme Court and the Court of Appeals still looks to that language. The board should still be allowed to function and make the decision if regarding the rehabilitative needs of Ms. Richins. Running sentences consecutive to a sentence of life without parole is senseless. And if this court imposes a sentence of 25 to life on the aggravated murder, but runs the other charges consecutive, the effect will be the same. She will likely never get the opportunity for parole.
I don't think that's true. Have you run the initial guideline? It's a genuine question.
Yes.
I think it only adds.
The guideline on the attempted murder is 192
It only
months.
adds 41 months if we run it consecutive.
Before she's eligible
Right.
for parole. But, well, I'm going to come back to that.
Yeah, if
will.
you're running the guideline differently, I'd like to know.
I mean, no, I'm not running the guidelines differently, but the sentence is, well, I talked about
understand
this.
your larger point, and I apologize for
That's
interrupting you, but if you do have a different running of the guidelines, those forms are not obvious, I'd appreciate it.
Well, I would say a sentence of 25 to life, and then if she serves additional time, does not guarantee parole, and I'm going to talk more about that.
Okay.
And it's almost unheard of for someone to be paroled at their first parole hearing on these serious offenses. And looking at the totality, there are mitigators. Kouri had no criminal history at the time of Eric's death. She was involved in positive ways in her community. She volunteered regularly. She headed up a sub for Santa every year. She was a friend, a daughter, and a mother, and excelled in these roles. She educated herself. She was involved in every aspect of her son's lives. There is no reason to hold her in prison for life. We asked this court to impose a sentence of 25 years to life. When you put aside all of the media, all of the intrusives, and you look at the crime she is convicted of, this is an appropriate sentence. A sentence of 25 to life is not a sentence that guarantees the release of Kouri Richins. It is not saying that she even should be released. What it is saying is that the decision whether she should be released is a decision for someone else to make on another day. A day that will be, at a minimum, 25 to 30 years in the future. A future that could look very different than today. Although today is not a day for forgiveness, that day may come. A sentence that allows for parole is a sentence that gives a pathway to forgiveness. You heard from Emery Blanchard, the only person in this room that understands what the Richins boys have been through. You heard how the day came when she missed her father. She wanted her father in her life. I know that she came to a place that she hoped to spend one more day outside of the prison walls with her father. And that day didn't come. He was not paroled, and he died in prison. I don't minimize what Kouri's boys are saying today. I understand it's contradictory to what other people are saying regarding Kouri as a mother. I don't know why they're saying these things, but what they think and feel today, they are allowed to think and feel those things. They should be. Their feelings are valid, and it's okay. and I think Kouri will say this too, but she wants her boys to know it's okay. People change, all of us change. Kouri will change, those little boys will change. A sentence of 25 to life will not be easy time, it will be hard time. For the first part of that sentence is generally served in maximum security for the first 3 to 4 years. But if the day comes when her children want to see her face to face, a 25 to life sentence will make that easier for them. If they, like Emery, decide someday they want a relationship with her, even one behind the walls of the prison, a 25 to life will make that possible. And a sentence with the possibility of parole, like I said, does not mean she will be paroled. It's very possible she will spend her life in prison. And quite frankly, if her case does not come back on appeal, and she is in prison and she maintains her innocence, parole's highly unlikely. But the Board of Pardons is uniquely qualified to make that decision. That is their job. And it is a particularly important job in the most serious of convictions. They will be the ones looking at a woman who will then be in her 60s or possibly 70s. They will decide if she has been rehabilitated and if she is a danger to the community. These are not decisions that can be made today. We don't stand here today asking you to give her a second chance. We ask you to let those best qualified make that decision when the time comes. When Kouri's and Eric's boys are grown. When they can tell the board if they feel the same way that they do today. You heard a letter read today from a woman who once stood in the shoes of the Richins family. At sentencing, she wanted life without parole for her son's killer. Now she does not. She has changed. Her views of prison have changed, and her feelings towards the man that took her son's life has changed. But a life without the possibility of parole, the sentence cannot be changed. If Kouri and Eric's boys someday change their mind, and it is too late to say something different than what they've said today, this day will become one more day that haunts them. If in 30 years they still do feel as they do today, they will have the opportunity to express those feelings. But don't allow their statements at age 9, 12, and 13 become another tragedy, another trauma that they may end up suffering as adults. A sentence that doesn't allow even the possibility of parole is a sentence that tells the world there is no hope. There is no growth. There is no change. There is no room for forgiveness. There is no room for love. That we are all our worst act and will never be anything more. And that is not the human experience. In a world where humanity is waning, act with humanity. In a world where hatred is encouraged, act with kindness. In a world where forgiveness is seen as a weakness, act with compassion. A sentence of 25 to life with the other charges turned concurrent reflects the seriousness of this offense, takes into consideration the totality of the circumstances. Further, it follows the recommendation of the pre-sentence report, and it is the appropriate sentence in this matter.
Thank you, Ms. It is 12:55. We're going to take a break until 1:25 to make sure Ms. Richins gets an opportunity to use the restroom and eat something. Mr. Bloodworth, you look like you have something to say.
Your Honor, does the court want to hear from the state one last time before the Chanel case?
I do not. I have this firmly in hand. I would like to make it clear, in case there was any ambiguity, that the court has considered and is denying defendant's request to strike portions of the state's sentencing memorandum.
Yes, thank you.
Court will be in recess until 1:25. Let's make sure that Ms. Richins gets something to eat. Thank you. We're off the record. portions of the state's sentencing memorandum.
Yes, thank you.
Court will be in recess until 1:25. Let's make sure that Ms. Richins gets something to eat.
At this point in time, we will be going over the parts. We're going to go. Hello, Bubbles. Good to see you. Okay? So, anyway, we are going to be seeing the more of the cross. I believe it's the cross. It began in the other trial we were watching earlier. Remember, it's not, live time, but it's the part that, we're going to watch it the way through, until they come back.
Scared, I was nervous.
Over 10 times.
With my brain injury, I needed to.
Over 20 times?
I don't know the exact number.
It's quite a few, isn't it?
There's multiple times.
And so you knew the general order of the questions that were going to be asked of you, isn't that right?
It's the truth, yeah.
This past weekend was Mother's Day, isn't that right?
Yes.
The day where we celebrate the women in our lives that put children first, correct?
Mothers who have children.
Yeah, sustained. Not sure how that has anything to do with it.
In 2011, you failed Haley, isn't that right?
I did.
In 2013, you failed Haley, isn't that right?
Yes.
And in 2011, when you failed Haley, you said she fell down the stairs leading to a traumatic brain injury, isn't that right?
She did.
And there was no safety gate in the house, correct?
It was broken.
It was broken. You didn't get another one, correct?
I believe I did.
You believe you did?
Yes,
And you
I
weren't
did.
using it?
I did.
You did. Then it wasn't being used by you?
Yes, it was.
It was being used?
Yes.
So she fell through a safety gate, according to you?
I'm saying after that.
After that, you got a safety gate. Okay. And that's a failure on your part as well as Mr. Barnes, isn't that right?
Yes.
The fall occurred when only you and Haley were home?
Yes.
And other than Haley, who was not able to talk at the time, you're the only person that can say what happened to Haley, isn't that right?
Yes.
In 2013, you failed Haley again, didn't you?
I neglected her, yes.
She went from the 80th percentile in weight to the less than 6th percentile while in your care.
In our care.
You're in Mr. Barnes' care.
Yes.
You're both responsible.
Yes.
You both failed her.
Yes.
She was losing hair.
She was.
She was injured with a broken bone in her foot.
It was undated when that happened.
I didn't say that. I said she had a broken bone in her foot. You agree with that?
A healed broken bone.
Her leg was swelling to the point that your own mother took her in, right?
Yes.
Because she couldn't walk.
I don't know if she couldn't walk.
You were a caretaker for her at the time.
Yes, that was several years ago.
You talked about, on direct examination yesterday, the fact that Mr. Barnes was not working and you were working during that time frame, correct? Do you remember that testimony?
Yes.
You were working less than 5 hours a week.
I picked up shifts when I could. It varied.
The evidence is that you were working less than 5 hours a week.
It depended on the week.
But for the most part, you were working less than 5 hours a week.
Judge, I'm going to object. That's answered.
It's not answering the question.
The answer said it varies.
Sustain.
You spent most of the day yesterday, roughly about 5 to 6 hours, talking about Derek, correct?
I don't recall how long.
A lot of your testimony has dealt with Derek and Derek's violence, isn't that right?
Yes.
Perhaps not even the last hour of your testimony talked about Alex and the last moments of Alex's life, isn't that right?
I did.
I'm gonna object to mischaracterizing. I think we brought that up well before the last hour.
The jury knows, they have their notes.
They know. Move on. That's been asked and answered. Go on.
You would agree with me that the vast majority of your testimony has been talking about Mr. Pedron.
You asked this already. Move on.
I want to talk to you a little bit. Yesterday we talked a little bit about the dirty underwear in the bathtub, correct?
Yes.
And you said that if you see the dirty underwear, you throw it away immediately.
I do.
You throw it away immediately. You're not going to deal with it again, right?
No.
Okay. And you attributed the dirty underwear to Mr. Pedron, isn't that right?
Yes, he.
You also said that there was a bottle related to urine in the same bathtub, isn't that right?
Yes.
Okay. And you also attributed that to Mr. Pedron, isn't that right?
Yes.
We saw on body cam when law enforcement arrived, you were wearing black pants and a red sweatshirt, isn't that right?
Yes.
Can I have the Elmo, please?
Are these already admitted, or which exhibits?
Yes, they're already admitted.
Oh, yeah, sure.
This is exhibit number 96. This is the bathtub, correct?
Yes.
This is the dirty underwear?
Yes.
And this is the bottle you were talking about?
Yes.
Here? That's what you're talking about, right?
Yes.
Okay. And you attribute those things to Mr. Pedron?
Yes.
Okay. And you're sure about that as you sit there today?
Yes.
Okay. State's exhibit, excuse me, this is defense exhibit 254. What are you wearing in this?
A robe.
A robe, correct?
Yes.
A bathrobe, correct?
I used it every day, every night.
When you were texting with Raphael at approximately 9 p.m., you said, I just took a shower.
I believe I said I was going to take a shower.
Are you sure about that?
I'm not sure. I thought that's
If your
what I
text
said.
message said, I just took a shower, then you would be mistaken. Isn't that right?
Can you show me?
Yes, I can. Now, let me just ask you this question. You would not take a shower in a tub with dirty underwear in it, right?
Absolutely not.
You would not take a shower with a bottle that had urine of your child in it either, correct?
No.
If there's a time differentiation of about a half an hour when you stop texting with Raphael, and then after that you return and you say, I just took a shower, that would be consistent with you taking a shower, isn't that right?
I don't believe I did take a shower because there was dirty underwear in there and I didn't want to clean the tub. I didn't feel good.
Why would you tell Raphael you took a shower if you didn't take a shower?
I was flirting with him.
And you have a bathrobe on consistent with taking a shower.
I never used my bathrobe after I took a shower. I used towels. I used my bathrobe to stay warm. I didn't feel good. I still use a bathrobe in the house, walking around.
State's Exhibit 146. I'm showing you page 12. Can you read this message from you to Raphael?
Yes, it says, I just took a shower.
I just took a shower, meaning you just took a shower.
Yes,
That's what you messaged him.
it is.
You would not take a shower in a bathtub with dirty underwear or that bottle, correct?
Right, meaning I did not take a shower.
You just told him you just took a shower.
Right,
Those are your words.
yes,
So are you lying to him about it?
I
Are
was.
you making it up now because it doesn't fit what you told this jury yesterday?
Objection, argumentative.
Sustain.
You told this jury yesterday that the dirty underwear were from Mr. Pedrin, the bottle was from Mr. Pedrin, correct?
Right.
And you
It
told this
was.
jury yesterday that you would not stand for underwear, dirty underwear, or that bottle being in the shower. You would get rid of it immediately.
If I was changing a child, I would get rid of it. I didn't feel good that day, and I did not want to deal with the dirty underwear and cleaning that shower.
The shower isn't just one message with Raphael. You guys talk about a shower quite a bit, isn't it?
I don't remember.
Because Raphael says to you when you're talking about the shower, he says, I want to shower with you.
Yes.
And then you continue on having a conversation with Raphael about how many dates it will take before you have sex with Raphael or shower with him. Isn't that right?
Yes.
And you say it's going to be at least 4 dates.
Action relevance.
Sustained, I'm not sure. The shower thing is relevant.
The
Overruled.
sexual activity is not.
It's context, Judge. These are her statements.
Okay, I'm going to overrule the objection, but move on. Is there more?
Yes.
Okay.
I did not take a shower that day.
You're telling us today you did not take a shower even though your words that day say you did.
Right.
Because that one fit with what you told this jury already.
Objection argumentative.
Sustained.
I didn't tell them I took a shower.
No, your messages did.
Right.
You're the one that changed Alex Xavier that evening, correct?
No. I
Put him in his pajamas.
I didn't change him. I put pajamas on him because Derek did not.
You put pajamas on him.
Yes.
Those were fresh pajamas and clean pajamas, correct?
They were what I found in a pile.
They were what you found in a pile?
Yes.
You inspected those pajamas?
I did not. I did not feel good. I grabbed pajamas and put them on him.
You're aware that in the bedroom where Alex Xavier and you went to sleep on the evening of February 10th, 2023, there is an empty container of cotton candy.
There.
Characterizing bedroom.
She says it's her bedroom. How is this mischaracterizing it?
In the kitchen in the photographs.
It's not.
There may have been another.
$147, it's right there.
Yeah, I mean, we haven't had testimony on it, but yeah.
It's been marked as 147. This is your bedroom, right?
Yes.
You see an empty container of cotton candy right next to your white.
I do. I don't know what color it was. There was pink, there was blue. I don't know what color that one was.
You don't know what it was, pink or blue?
Right.
The label would indicate that's both, right?
No, it doesn't.
Are you familiar with that brand?
At the bottom, it looks pink.
It looks pink.
Looks like there's still some in there. It looks pink at the bottom.
There's cotton candy remnants all over the floor of that bedroom, isn't that right?
We don't know what that was.
You don't know what it was?
No, we don't know what that blue substance was.
It's all over in different spots in the carpeting, isn't that right?
We don't know if that's cotton candy.
There's a blue substance all over the floor, in the carpeting, in the floor of your bedroom, correct?
We also played with Play-Doh and we had magic sand.
I understand you're saying it's not cotton candy. There's a blue substance all over your floor in your bedroom, correct?
There was, but we don't know what it was.
You don't know what it was.
Neither do you.
There's also a blue substance on his pants, correct?
Yes.
Consistent with him getting into whatever blue substance is on the floor and in your bedroom, isn't that right?
Action argumentative speculation.
Overruled.
That blue substance could have came from something they ate another day.
Could have came from another day. It also could have come from that night when he was only with you, right?
We don't know.
We don't know. We would know if you kept a better eye on him, wouldn't we?
Action argumentative.
Sustained.
It's
It's your job to watch him 24 hours while he has this broken leg, correct?
Objection, speculation, argumentative.
She said it.
Overruled.
We were sleeping.
You're supposed to keep 24-hour supervision on Alex Xavier with his broken leg.
He was in my bed and we went to sleep.
My question is, were you supposed to keep 24-hour supervision on him?
I was, and he was in my bed.
He got to your bed because you moved him from the couch that he was on to the bed. Is that right?
Yes, I wanted him closer.
And the path that you would take to move him from the couch in your bed to the side of the bed that you put him asleep on would take you right past any objects that would be on the floor.
There was a lot of objects on the floor, yeah.
There was an open path, though, where you could walk and put him on the bed, right?
I don't know about open. There was a lot of stuff on the floor.
There's a lot of stuff on the floor. I'm going to ask the investigative sergeant Emerson to help.
Judge, I'll note for the record that it appears that the state is applying forensic protocol order, and that Sergeant Amundsen has placed a sheet of evidence paper on the floor and appears to be reopening an exhibit with fresh gloves.
Thank you.
I would note that the bag that was reopened, the chap's bag, appeared to strike the side of the wooden paneling of the court's raised bench area.
The record should reflect that State's Exhibit 110 is now on the floor in front of the defendant. It's in between the court reporter station and the jury box. Do you see the bag on the floor?
Yes.
That's the bag that was on the floor on the morning of February 11th, 2023, correct?
I don't remember exactly where it was.
You don't remember where it was?
Not exactly where it was, no.
You didn't move it between the time that you called 911 and law enforcement arrived on scene, correct?
No.
All right, so it would, wherever law enforcement found it, that's where it was, correct?
Yes.
And you're aware that it was photographed and captured on the floor next to the bed, correct?
Yes, I mean, wherever they photographed it, or wherever they found it.
I want you to look at the size of the bag that's in front of you.
I see it.
That bag, you're saying you don't know if that was out the evening of February 10th, 2023, when you took Alex Xavier from the couch, would have had to move past this bag and put him on the bed. You're telling us you would never have noticed this bag on the floor.
I didn't.
You didn't?
No.
You didn't because it wasn't there, right?
It was wherever they found it. I mean, I had plenty of, if I would have seen it in my walkway, then I would have seen it. It was not in my walkway.
You gotta,
I'm sorry, I didn't
answer the question, then ask a question.
Judge, for the record, the bag is placed horizontally facing towards Ms. Dikeman, not vertically. The width of the bag is at its widest.
That's fine.
Do you have a picture of where it was placed? Then I can better tell you.
It was admitted into evidence. I don't have it in front of me right now. We can
Well,
cover
that doesn't help me then.
This bag is noticeable on the floor right now as we sit here, right?
I need to see where it was.
My question is this noticeable right now on the floor as we see it right now? Yes or no? Yes or no?
I need to know where it was in the room.
I'm asking if we can get the picture. It's captured on body cam, so I'll cover that a little bit later.
Okay.
Judge, I'll agree with that. There was a photograph of the bag where it was found, if that helps move this along.
Yeah, could you tell me which photograph it is?
No, it was one of the state's exhibits.
We'll come back to it. I want to talk to you about the timeline of that evening into the next day, okay? Derek makes a phone call to you at 5:19 p.m. before he arrives home, isn't that right?
Before he arrives home from work?
Yes, 5:19 p.m. Derek calls you.
Okay,
You guys talk for approximately 5 minutes.
okay.
You agree that Derek got home around 5:30 in the evening, is that fair?
I believe so.
Okay, tell us exactly what Derek did when he first walked in the door.
He went in by Alex.
You went in by Alex
Yes.
and did what?
I was not in there, but I know he went in right in my room.
You went right into your room right by Alex.
Yes.
Then what happened?
Then I went upstairs by Jalen and I heard noises. I didn't know for sure. So I waited and I was talking to Jalen. And then I heard him again and I came back downstairs.
Well, if you heard noises, it's safe to presume that Jalen would have heard those same noises. She was right next to you.
I'm not Jalen, I don't know.
She was near you, though, correct?
She was.
And describe the noises that you say that you heard and you're not sure if Jalen heard or not.
I heard screaming.
Screaming.
Yes.
It was screaming so loud you could hear it upstairs.
Yes, Jalen had her music on YouTube and I still heard it.
So Jalen would have heard these screams too.
I can't say what Jalen heard.
It was so loud you could hear it over Jalen's music.
I heard it.
Major was downstairs, correct?
Yes,
Major was in his bedroom, correct?
he was.
Major was in his bedroom right next to the bathroom, correct?
He was.
And the screams that you say you heard upstairs in the second floor were loud enough to hear throughout the house? That far away?
I heard it upstairs.
Okay. And so if you could hear it, presumably Major certainly could have heard it.
All the domestic violence that happened in that house, Major was always in his room and he never came out. He would avoid it.
That wasn't my question. My question was, Major would have heard it if you could have heard it upstairs.
I'm not Major.
Sustain. She doesn't know.
Judge, can we get the forensic evidence off the floor?
Yep, it can be picked up, please. Unless you're going to use it for some other reason.
No, that's fine.
Yeah.
Judge, you want to take just like a 5-minute break so it can be, otherwise.
I'm just like, we need to clean that up, maybe find some other things. Yeah, let's take about a 5-10 minute break here.
After, Judge, or 10 after?
10 after.
Gloves on his hands. He's now.
Go ahead.
I observed Sergeant Amundsen place a new pair of gloves on his hands. He's now placing the chaps bag back into the previous evidence bag. My concern with this is that the bag was in the line of speaking of both Mr. Torbenson and Ms. Dikeman and potentially the jurors, where if there's going to be airborne contamination, it was right in that zone where that could happen.
Okay. I'm not too worried about that.
It's important to note this for the record, Judge, in case this ever needs to be tested.
I would just, then I think it's important to note my distance away from it, which is well over 6 feet. Studies show that it's extremely rare, if not impossible, for DNA to travel over 6 feet.
Okay. We'll see you at 10 after.
Thank you.
That on the record right now.
So, Judge, I would just note that before the jury came in, before or after the last break, Mr. Torbenson was still speaking about alleged drug transactions that the court found to be inadmissible, and I saw the door open and I saw the first juror coming through as that discussion was happening. Just putting that on the record.
Okay. Maybe we should talk about that issue since it's been brought up. I'm not the conversation, but you wanted to bring further information to the record. Go ahead.
Judge, the argument that I have relative to that is it's drug-seeking behavior on the part of Ms. Dikeman. She's seeking a specific medication that she's had a previous addiction to, and she's admitting to the police that she's seeking it from Mr. Colkind. The text message exchange that the defense admitted regarding Mr. Pedron, there's no demonstration that that's a completed drug transaction. In fact, it's just the opposite, because the person says that's a long 10 minutes, and that's the long message. So there's no indication that that's a completed transaction, yet that was allowed in evidence. This is exactly the same as that type of conduct here. It's drug-seeking behavior on the part of the defendant, which I think is arguably even more relevant, because in those text message exchanges, it's someone else seeking drugs from Mr. Pedron, not Mr. Pedron seeking drugs from somebody else. Here it's her seeking a substance she is previously addicted to, wanting to pay for it, and after she has testified on the stand that she does not seek or use outside of a prescription.
Judge, that wasn't her testimony. She admitted to that repeatedly on direct examination. We've introduced evidence of that. The court I thought the court had already ruled on the Ed Colkind issue. Otherwise, I would have addressed that in my direct. I thought the court made a ruling this morning indicating that it wouldn't be a proper fodder for cross-examination. The difference between Ms. Dikeman and Mr. Pedron is that Ms. Dikeman has constitutional rights here. Mr. Pedron is not entitled to the same right to a fair trial, to the same inferences as a Denny suspect. It's redundant. It's not in response to any question that Ms. Dikeman asked. Saying that she had drug-seeking behavior tells us nothing at all about whether or not she killed Alex in 2023, if she sought out oxycodone or whatever in 2019. It's irrelevant. It's prejudicial. It was previously barred just this morning by the court's order. I'm asking the court to exclude it.
I'm going to keep my order as is. I made that order earlier based on what I had. Let's just keep moving. I don't think that's a make or break huge issue here, but it is, I know it's yet another potential impeachment concept for or possible impeachment, not concept, but possible impeachment by the state. It's ambiguous at best with Mr. Colkind. I don't want to make much of a comment on this, but there is a question about constitutional rights. It is correct, Ms. Dikeman has an absolute constitutional right, well-established constitutional right to a fair trial. It's probably a little bit more up in the air on the issue of how Marcy's Law involves the victims of cases. So, but that there is definitely a tension between those two things. I'm just going to leave it at that. There's not a lot of clarity about where those lines are drawn.
Judge,
let's just move on.
I wasn't going to address that point, Judge. I was going to address something different.
Another issue? Yeah,
defense had a very long direct examination with the defendant over yesterday into today. And all I'm going to note for the record is the court has very quickly been shutting me down on questions. And the defense went over and over topics again and again and again to the point that it was utterly repetitive. I've only been questioning her for not even an hour, and the quickness with which you are sustaining my objections relative to what they went through and the timing I have relative to them, I just want noted for the record.
All right.
Judge, sorry to keep bringing up new evidence.
I am not treating the state any differently than I'm treating the defense. I find that just a little bit. There are asked and answered questions that are asked repetitively. I'm trying to sustain those.
That's what I usually do, yes.
Phones have filters on them, correct?
Yes, but...
You're also sending a text message to someone you're going on a date with the very next day, correct?
Yes.
Okay. You want to look your best. You want to show your best for that date. Isn't that right?
I've learned to live with this disability.
Oh, 354. Do you see that?
Yes.
And UTC means that we subtract 6 hours during this time frame. So that would make it 16:03:54, correct?
I'm not sure about that.
And thank you. I was hoping someone would. And that would make it 4 o'clock in the evening. Okay. Exhibit number 7 is Mr. Pedred's time card. Now, this is happening on January 19th of 2023. Here's the entry on exhibit number 7 for January 19th, 2023. Tell the jury what time he clocked out.
It says 5:10.
5:10. So you are messaging him about getting drunk and high, and he's actually at work.
He had people clock him out all the time. His friends would clock him out of work.
That's your accusation.
It's true.
This is case 231-500-139. Ms. Lewis, Ms. Nestor, anything further before we hear from Ms. Richins?
No, Your Honor.
Okay. I understand that Ms. Richins will like to stand at the podium.
Yes, Your Honor.
And you folks would like to join her?
Yes, Your Honor.
No problem. There should be Kleenex up there if you need it.
Yes, Your Honor. Do you want water?
My sweet baby boys, I know that today you don't want to speak to me, have a relationship with me, but you may think you hate me, and that's okay. I will never be angry at you for your feelings. When the day comes that you're ready, I will be here for you, waiting for you, and loving you. But I need you boys to know and understand that I have been desperately trying to get in contact with you any way that I can for years. That all of my communication has been completely cut off from you since early 2024. And now I will use any opportunity I can to get a message to you. Even if that means sharing it publicly to the world, fully restrained, in my jail clothes, in one of the most horrible situations possible. I don't care, and I'm not embarrassed or ashamed by any of it. All I care about is you boys. I will do whatever it takes for you to hear the truth from me and to come home to you. For the time being, I don't know when that is or when my next opportunity will be. So for now, bear with me as I have tried to consolidate everything I've wanted to share with you for the last few years, with everything I want you to know until I'm able to speak to you again, and one long message. And although you may not be ready to hear it today, that's okay. My hope is one day you will be. May 6th of 2024, temporary custody was transferred from the state of Utah Child Services to your Aunt Katie and Uncle Clint. My last video call with you boys was several weeks prior to that, around April 24th, 2024, when you were still in the state's custody. Once temporary custody was transferred to Katie and Clint, against my wishes, they cut off all of my communication between you boys and I. It was years before I would ever have a trial. I warned social services that if they gave custody of you to the Richins family, it would be the last time I would be able to see or speak to you boys again. And your opinion of me in this case and wild allegations would soon mirror those of the Richins family. And that's exactly what happened. You need to know The Darden side of the family fought a long, hard battle for custody, but was eventually ignored and denied. Since temporary custody was granted to Katie and Clint, they have not allowed me to see or speak to you. No more video calls, no more visits. They blocked the phone number for the jail so I can't call you. Birthday cards, Christmas cards, the letters I would send you boys, they were all returned or rerouted. All of my contact was cut off more than 2 years ago. So please, please ask them. Please ask them for your cards, for your letters, if I tried calling you. Please, just ask them. Whether it's now or in 10 years. The one thing I need you boys to know I did not abandon you. I did not just walk out of your lives one day to never return, to never call, to never show up. Regardless of what anyone tells you, I would never ever leave you boys. And I am so sorry if for even 1 second you thought that I did. If for even 1 second you thought that I didn't love you. Because that couldn't be further from the truth. You boys are my world, the reason I continue to wake up every day and fight to come home. You're my reason for living. I understand that you're in a difficult situation, mentally, emotionally, and physically. I understand you guys have been through an extremely difficult time this past 4 years. You should never have to deal with such tragedy, and I am so, so sorry that you are going through this. You boys have the right to be angry, and sad, and confused, feel in survival mode, have questions. All of this is completely valid. Your feelings are completely valid. And one day, when this is all over, we can sit down and talk about all of this and sort it all out. And I promise you boys, one day it will be over. I'm not perfect. I have succeeded and I have failed. As a person, as a wife, as a parent, we all do. I have done plenty of things I am not proud of. Some I regret, some I don't. Some I'm ashamed of, and some I'm not. I regret things I have done right in my life to later find out they were for the wrong people. I have said things I shouldn't have. I have done things I shouldn't have. Sometimes I haven't said what I should, or not meant what I did say. There are things I can't change, and long overdue apologies that I owe. There are would-haves, and could-haves, and should-haves. We all have them. We have all done them. And you boys will too one day, but in your own way. And that's okay. That's life, and we're human. Nobody is all good or all bad. We just get portrayed that way. You're going to succeed and achieve amazing things in this life. You're also going to make mistakes and fail at some things. But use those opportunities to grow and to learn. They do not define you, and don't ever let other people make you think that they do. We are not defined by our best or our worst moments. We fall somewhere in the middle, ever evolving, and you boys are ever evolving. Secrets diminish self-respect. They lose trust. They make us lose ourselves. I fell in love with someone who wasn't your dad. Your dad fell in love with someone who wasn't me. I did things behind your dad's back. He did things behind mine. Don't keep secrets. Always put your spouse first. Your dad and I didn't always do this, but don't be like us in that aspect. We made mistakes that I know I regret, and I'm sure if he were here today, he would say that there are a few things he regrets as well. Marriage is hard. Marriage takes work. Marriage takes love. Big love. Deep love. And you may think about divorce and you will have fights, but then you will make up and you will forgive each other. Because when your love is enough, your love keeps you together. Your love is all you need to ignore the noise. Your love never fails. Sometimes your dad would want to throw in the towel on our marriage, or I would want to throw in the towel on our marriage, but we never did. We always found our way back to each other. I would pick up his towel, or he would pick up mine. We'd hand them back to each other and start again. Because our love never failed. We stopped keeping track of each other's wrongdoings, and we forgave, and we moved on, and we loved. And if I had to relive all of those hard days all over again, I would do it without question. Your dad and I were a lot of things, a mess of sorts sometimes. But we were this crazy, beautiful mess that made us a family, because our love was enough. Our hard days never outweighed our good days. Our weak moments never outweighed our most memorable happy days. We always laughed more than we cried. We failed at some things, but we never failed at loving you boys. Our love was enough to make our house a home. Our love was enough to stay together, to raise you boys. Our love was enough to forgive each other when others said that we shouldn't. To do things for each other others may disagree with. Our love was enough to protect each other, even though it may cost us everything. Love can make you lose yourself. Sometimes it makes you do things you know you shouldn't, but knowing it's not wrong at the same time. Because your spouse is your person, your love is enough. One day, you will meet someone and fall in love and understand that just your love is enough. Enough to withstand everything else, the noise of the world, the obstacles, the trials of marriage, the heartache, bad choices, forgiveness. You will understand your love is enough, and your love never fails. Don't worry about what others think about your relationship. Don't worry if they would do things differently. You just love. And you love big, and you love deep, and you protect your love. Your dad and I didn't have it all together. But together we really did have it all. Because we had you three. Don't let anyone choose the direction of your life by their opinions and their judgments. Being able to hold yourself together in the worst of situations doesn't make you emotionless. Separating personal and business life and emotions doesn't make you unreasonable. Resentment can get the best of others. Don't let it get the best of you. People will always have a lot to say about lives they've never lived. Live your life the way you choose to live it. Just be safe and be healthy and be happy. That's all that matters. Sometimes people will want you to believe that life is simply black and white. That situations are black and white, but they're not. Life, situations, they are full of color. At the very least, shades of gray. Always question the color, even if you're only questioning the gray areas. Keep an open mind. Question situations and stay curious. You will have some people in your life tell you how their love for you is unconditional. But once your most private life has been revealed, you quickly find out just how conditional their love actually was. Choose the people you hold close to your heart wisely. And always be the friend that walks into somebody's life when everyone else chooses to walk out. Always remember, the only people you owe your loyalty to are those people who never made you question theirs. Every day you wake up, you get a second chance at life, to do whatever you want, be whoever you want, to succeed in all your dreams. Take the day and run with it. It's a blessing. Don't take it for granted. Sometimes you'll have hard days when all you want to do is count all the ways things are going wrong or have gone wrong in your life. In that moment, stop, take a minute, take a step back, take a breath, and switch your thinking to count all the ways that it has gone right. All the good that has come to you, boys. All the grace, the blessings, and the love. Remember that anyone can give up on something. That's the easy way out. True strength comes when everyone is expecting you to fall apart, but you hold it together, persevering through the hardest of times. Always persevere. Always prove them wrong. Because you boys don't give up, and you boys will never quit. There's always going to be someone out there ready to tear you down, misrepresent you, lie about you, tell half-truths, and judge you. They will judge you on decisions you do or don't make, what you did or didn't do, what you did or didn't say. They will take out of context and twist your words. They will judge you on your emotions or the way you grieve. You may show too much emotion, you may not show enough. They will tell you you're not grieving correctly, you're too angry, you're too sad, you're holding it together too well or not well enough, or maybe you're too ambitious. They will judge you on your demeanor, if you cry, if you don't cry, if you don't do anything at all. And all of this will get misinterpreted into something that it's not, formed by the opinions of who's ever creating it. And then silence is also too often misinterpreted and misjudged. But when people behave that way, it has much more to do with them personally than it does you. Everyone's entitled to their opinion. It doesn't make it true. Remember who you are and what you stand for, the truth, and ignore the noise. Ignore their noise. Ignore their egos, their entitlement, and their biased judgment. Those who abuse the power and the positions they hold will have a higher power to report to one day, and that higher power holds the final truth, their final truth. Don't ever let someone tell you how to show emotion, how you're supposed to react to any given situation. Don't care what others think about you, what others say about you, just let them talk. Just be you, be yourself, be authentic, be genuine. Because those who truly know you, who truly love you, is all you need. Forgive those who turn their back on you, but never forget. Don't hold hate in your heart toward others. It only brings you down more than it does them. Apologize when you're wrong, even if that apology is long overdue. You can't change what you can't change, and you can't change the past. But you can take accountability when you mess up. Admit when you make a mistake, even when it's embarrassing or humiliating, even when it can ruin relationships, careers, or your integrity. Be honest with yourself and those you need to. But never apologize for something you didn't do. Never admit to something you didn't do. And never beg for mercy for something you didn't do. Don't take the easy way out. Always stand up for what's right, even if you find yourself standing alone or with a small group of people that love you. Believe in yourself and be brave. Never give up on your fight, no matter how long it takes, months, even years. Never give up on truth, justice, and the fight of corruption. When something is broken, fix it. When something doesn't make sense, question it. If money is paying for it, follow the money. Your brothers are your best friends. Your dad and I raised you boys, that if you cared about nothing else in this world, you care about each other. Your brothers will always be there for you. They They will always be your brothers. You love them, you protect them, you take care of each other. You support each other, you help each other, and you trust one another. You be loyal to one another, and you keep each other safe and healthy and happy. And you stay together no matter what. You have each other's backs. Be patient with one another. Don't keep track of wrongdoings. Let them go. Forgive. Move on. Show compassion, empathy toward each other. And never go a day without telling one another you love each other. Because you are never too old, or too cool, or too busy to love each other. Don't ever settle for just good. Go for great. In school, in your career, in hunting, in fishing, in your relationships, in your goals. Exceed expectations. Be like your dad. Be generous. Be charitable. Stay humble. Give when you have too much. Give more than you take. Help when others are in need. Serve your community. Be like your dad. Never stop learning. Through education, through people, through travel, culture, through business and friends. From your success and achievements, from your mistakes and failures. Be like your dad. Love the outdoors. Find your peace, your therapy, your heart and soul on the top of a mountain somewhere where it's quiet, where it's calm, where you will be able to feel the spirits of those that you love and miss the most. Be like your dad. Laugh. Laugh often. Laugh loud. Laugh when you want to cry. Laugh when you're mad. Have that laugh that everyone recognizes and no one will ever forget. Even when you're gone. Be like your dad. Love your family through the good, the bad, the disagreements, the back and forth arguments. Choose forgiveness. Choose love. Choose happiness. Be a loyal brother. Be a noble son. Be like your dad. Have the hobbies that bring you excitement and joy, that give you a break from life, but build your life full of people and family who you love and that love you. Build a family that makes you happy to come home to every day.
with a career that makes you hold your head high. Be the friend everyone wants to be friends with. The dad that everyone wishes they had. Be like your dad. As your parents, your dad and I wanted to give you every opportunity or choice that we didn't have. We would do anything for you boys, or break our backs falling over obstacles and finding our way to be sure you had the best of the best. Even if we didn't always do it well, or have the right answers, or the words, we would give you everything that we had. But the one thing I can't give you boys are the answers that you want the most. Because I can't give you something that I don't have. An explanation that I just don't know. I've never lost a son. I've never lost one of my brothers, a nephew, or a best friend. But I did grow up with a single mother, and I have lost my father. I do know what it's like to wonder, what if Dad could have watched me graduate college, walk me down the aisle, be there for the birth of one of you boys? If only Dad were here. I do know what that's like. The lifetime of pain that brings. The sadness and the anger. I would never wish that upon anyone. Especially you boys. My own sweet babies. It's a lifetime of what ifs and if onlys. An empty hole in your heart where your dad's supposed to be. He's supposed to fill. He's supposed to walk through life with you, with us, with our family. I do know what that's like. So murder, an attempted murder, 4 years later, and it's still hard for me to say those words out loud. They get caught in my throat. I turn my stomach, and I try to avoid them as much as possible. Because it makes me physically sick to think about. But still to this day, I can't believe this is real sometimes. That this is our life. That this is my life. Convicted of taking one of the people out of my life that filled it the most. My husband, the father of my children, still in shock and still in disbelief. Accused and now convicted of such a heinous crime. Potentially costing me to never see you boys again. I just lost both of their parents. And there's no textbook answer on how or what we're supposed to do. How I'm supposed to react or move forward. And I'm so sorry you boys are being pulled through the middle of this absolute chaos. between two families fighting that both love you so very much. Trust and assets, our home, none of it matters. You boys are what matter. Your safety, your health, mentally, emotionally, all of that should be being prioritized. I will and have always prioritized your safety. I am your mother, and that is my job. And for anyone to scare you otherwise is just cruel and heartless. I'm sorry that 8 people from a jury who have never met you or me or our family had the right to determine our future. And they did that in less than 3 hours. In a perfect world, there might be justice. But in a perfect world, nothing ever goes wrong. Tragedies don't happen. Some think a verdict or the sentencing will be the answer that they seek or that they need, but it won't. It will only give them something else to think about for a while. It may help to disperse some of their hurt or their resentment, but it won't relieve it. This grief will outlive us all. The hundreds of lives that this has affected. The lifelong trauma you boys have suffered this last 4 years will outlive us all. You haven't had to just endure losing one parent, but losing 2. And no child should ever have to go through that. Especially when one was an unforeseen tragedy, and the other based on injustice and a system we're supposed to trust. Your dad's memory will always be the kind that's a physical hurt, the tightening in your chest when you think of him, particularly on days like today, his birthday, because he was so loved that no verdict or sentence will ever be able to release that kind of suffering. I'm broken without your dad, I'm broken without you boys. God did not put me in this world to take a life. God put me in this world to give life, your lives. And I don't know who or what I'm supposed to be if it's not a mother. Your mother. And as much as you've been influenced into thinking that Dad was murdered, that I took your dad from you, that is completely wrong and an absolute lie. And the thought of that is still as absurd today as it was 4 years ago. And just because someone may not be perfect, that's a far reach for them to be capable of murder. To kill someone, our someone. Your dad was in physical pain. A lot of physical pain. And just because some people didn't know or didn't want to see certain things, doesn't mean they weren't happening or they weren't true. He would have never left us intentionally. And I would have never taken him from you, from us. He was the glue that held us all together, that made us, us. Every little boy needs their father. Is he supposed to teach you the things that I could never explain? teach you and do things with you that only a dad can do. And only he could give you those life lessons between a father and a son. I would have never taken that from you boys. I know how much you need him, how much you loved him. How much you aspire to be just like him. And I would have never taken that from you. And I'm so sorry that I can't bring him back. For you, for me, for our family. I can beat myself up all day about how I could have been a better person or made better personal choices. And I can understand and accept you boys being upset about those things. But murder? No, absolutely not. I will not accept that. And I will not be blamed for something I did not do. I will appeal and fight these charges no matter how long it takes. Not because I have anything to prove to this court, to the state, to the Richins family, or to the world, but I do have something to prove to you three. I do care what you boys think, and I need you boys to know the truth. And because of that, I will never quit or give up on this fight for justice, the truth, and coming home to you. So please, I know that right now, you may not believe me. That you believe I took Dad from you, and that's okay. I still and will always love you. And I'm asking that you please just don't give up on me. I'm coming home. Not today, not this year, but we're going to make this right. Our justice system will get this right, although this courtroom can't seem to. We have a long road ahead, but I will never quit fighting my way home to you boys. I love you more than these words could ever express. I loved you before I ever met you. And I will love you long after I'm not here to say it. And every minute of every day, I miss you boys more and more. And I think about how much I wish I could be with you. And this nightmare would go away. And we could have our family back. This entire situation isn't fair to anyone, but it's especially not fair to you three. And you boys are all that matters. I want to remind you just how strong you are. That you are loved by so many, and I am beyond proud of you, of everything you have overcome, everything you have achieved, and how much you bring into this world. You boys have been through so much, and I wish I could take away all your sadness and all your pain. Tell you how much Dad and I love you, and that everything's going to be okay. I wish I could count the freckles in your little cheeks. Read you books before bed. help you with all your homework. I wish I could help you through your toughest nights and hear your laugh through your happiest days. But for now, that's just not the way it is. We have to be strong. We have to remember that our strength grows in these moments when we don't think we can go on. But we keep going on anyway, because we have to push through these hard days. Because in the end, at the end of this war, it will be so worth it. But I need you boys to always keep pushing through these hard days, because this will come to an end. I just need you to hang in there. Listen to your little hearts. Listen to your little bellies for the truth. Before you were told who to be and what to believe, remember who you are. Remember who we are. Remember our family. I will continue to call you every day, even if my calls are blocked. Just so you know that I'm here. I've always been here. And I will always be here. My cards, my letters, they will never stop. I will never stop. I love you forever, Mom.
That's all you're.
All right, ladies and gentlemen, a fair reminder. While inside the courtroom, everyone involved in this process must be treated with respect. We cannot have any outward reactions inside the courtroom. If any of you feel overcome with emotion, frustration, anger, whatever, of any kind, please remember just to look down. Keep your hands folded in your lap. The court has considered the following information. The evidence, information, arguments, and recommendations provided by counsel on the record today. The victim impact statements and other statements made on the record today regarding the appropriate sentence. And the pre-sentence investigation report as corrected on the record today, including the numerous statements attached to it. In addition, the court has considered each of the factors set forth in Utah Code 76-3-201 subsection 2B and has prioritized those factors as required by section 201-2C. Having considered the gravity and circumstances of the offenses for which Ms. Richins has been convicted, the number of victims, and available information regarding the history, character, and rehabilitative needs of the defendant, the court hereby orders that the sentences on counts 2 through 5 shall run consecutively to each other and to the sentence imposed on count 1. Moreover, the court exercises its discretion and chooses to impose no fines related to any sentence in this case. The court addresses the 5 counts on which Ms. Richins was convicted in reverse order. Ms. Richins, based on your conviction on count 5, third-degree felony forgery, the court hereby sentences you to an indeterminate prison term not to exceed 5 years. Based on your conviction on count 4, second-degree felony insurance fraud, the court hereby sentences you to an indeterminate prison term of not less than 1 and not more than 15 years. Based on your conviction on count 3, second-degree felony insurance fraud, the court hereby sentences you to an indeterminate prison term of not less than 1 and not more than 15 years. Based on your conviction on count 2, first-degree felony attempted aggravated murder. The court hereby sentences you to an indeterminate prison term of not less than 5 years, and that may be for life. Which brings us to the final issue, the appropriate sentence for count 1. Under Utah Code 76-3-207.7, there are only 2 options. An indeterminate prison term of not less than 25 years, and that may be for life, or life in prison without parole. And the law requires that the court consider each option. Under a sentence of 25 to life, and considering the effect of the 4 consecutive sentences, the time that Ms. Richins has spent in custody, and the current practices of the Board of Pardons and Parole, Ms. Richins would likely serve approximately 30 years in the Utah State Prison before receiving her first parole hearing. By that time, she would be 66 years old. Under a sentence of life in prison without parole, Ms. Richins would be in prison for the rest of her natural life, unless the Board of Pardons and Parole determines by clear and convincing evidence at some future point that she is permanently incapable of being a threat to the safety of society, at which time the board would have the authority to release her. Under either scenario, Ms. Richins will be incapacitated, meaning structurally prevented from harming anyone outside the Utah State prison system for at least the next 3 decades, and perhaps much longer. But the potential impact on the survivors of the tragedy created by Kouri Richins, most importantly, Eric Richins' 3 sons, is more difficult to predict. On one hand, if the court sentences Ms. Richins to life without parole, one or more of those young men may come to resent that the court eliminated any opportunity they might have in the future, decades into the future, to express an opinion as adults with substantial life experience about whether their mother should, for example, be allowed to die with dignity. On the other hand, if the court sentences Ms. Richins to 25 to life, one or more of those young men may spend the next 30 years questioning why the court failed to protect them from the prospect of the person who murdered their father being released from prison at some time in the distant future, perhaps when they have families and children of their own. The court's contemplation of how those young men may come to feel about today's decision some 30 years from now comes from a place of genuine concern for them and humility regarding the court's inability to predict the future. Sitting here today, it is simply not possible for anyone, not even those young men, to know how their view of this case may evolve over the next several decades. My hope is that every person affected by Eric Richins' death will, over time, find their way to a state of peace. As for today, the court's duty is to make a decision, a weighty, long-lasting decision based on the best information available today. And the bottom line is this: Kouri Richins was convicted unanimously and beyond a reasonable doubt of attempting to murder Eric Richins, her husband, and the father of their 3 children. And then, having failed in her first effort of spending the next 17 days not changing course, but doubling down, preparing to try again, and ultimately completing the act through the administration of poison. And for what? Money. All for pecuniary gain. A person convicted of committing that sequence of acts in that way and for that reason, and who causes the absolute tragedy that has befallen Eric Richins' sons and family. A person convicted of those things is simply too dangerous to ever be free. Accordingly, Ms. Richins, based on your conviction on count 1, first-degree felony aggravated murder, the court hereby sentences you to life without parole. You have the right to an appeal. You must file a notice of appeal within 30 days. You have the right to be represented by counsel on appeal. Mr. Bloodworth, anything further?
No, Your Honor.
Ms. Lewis, Ms. Nestor.
Your Honor, we anticipate filing a motion for a new trial and would like a date set. We have a substantial record in this case. We will file the notice of appeal of the conviction and the sentence and ask that everything be stayed pending the motion for a new trial as we're entitled to do under Rule 4B. Excuse me, but we think we need sufficient time to file a motion for a new trial based on the substantial record that exists in this case, longer than the typical 14 days, because this is not only the trial itself, but the years of litigation and motion practice that preceded the trial. We were hoping that we could get an agreed deadline of 90 days to file a motion for new trial, mainly because for half of June I'm out of the country and for half of July Ms. Lewis is out of the country. Normally we would ask for 60, but there's going to be a month in there where both of us aren't available. So we're asking for 90 days.
All right, Mr. Bloodworth.
Your Honor, the state objects. The rule provides for 14 days. You can't imagine this is a decision that was made today, I think. Council's had the last 53 days to prepare the motion, 14 days pursuant to the rule. I appreciate that it's a lengthy record in this case, but the issues available for the trial are fairly narrow. The state recommends the 14-day time period as provided by law.
There is one other thing, Your Honor, on that as to why we need the extra time. So we have asked the county to retain an expert to assist to do a declaration for our attached to our motion for new trial, and it's going to require us to go before a separate entity to decide whether that funding is approved, and that just takes time. So that's another issue we need.
I feel like there's more that I need to know in order to make this decision. And so I can also appreciate why defendant is concerned about the 14-day deadline so they do not lose that opportunity. Sitting here today with very little information and the state having very little opportunity to respond to this idea, I'll extend your deadline to 28 days. But within that time, if you want to file a motion to extend it, Ms. Nestor, with more detail, you have 14 days to file that motion.
Your Honor, can I ask for clarification? So the court
14 days from now, they have an opportunity, they have a deadline to file a motion to extend the 28-day deadline. If they don't, it's 28 days. I acknowledge that that 28-day deadline may cause practical difficulties for the state's team, and if I need to extend the state's response deadline, I will certainly give that fair consideration.
Understood.
Ms. Nestor, Ms. Lewis, anything else today?
No, sir.
Ms. Richins, you are hereby committed to the Utah State Prison and remanded to the custody of the Department of Corrections. This court is in recess. Please follow the deputy's instructions. We're off the record.
Those records say that he was at work, correct? You agree with that?
It says he was clocked in work. It doesn't mean he was at work.
Let's talk about what the additional messages say that also weren't shown. I'm going to show you State's Exhibit 151. There were just 2 text messages that were contained in 300 from the defense. This is a larger portion of the conversation. Would you agree? Absolutely.
I'm sorry, what's the exhibit number again?
151, Your Honor.
Thank you.
I want to direct you to the last 2 messages at the bottom of 151. Do you see it? You can compare it to these 2 messages so you can show that I'm showing you the exact same message chain. And what I've handed you is Defense 300. For now, Ms. Dikeman, you can just stay on page 1. Do you agree that the last 2 messages in Defense Exhibit 300 are at the very bottom of State's Exhibit 151?
Yes.
Okay. And yesterday you were only shown the 2 messages from Defense Exhibit 300. You weren't shown the rest of those messages. Is that right?
Yes.
Now, if you go up a little bit on State's 151, you can see a sentence where you say, you are already complaining about the Jenna part. Do you see that?
Yes.
You're referencing Jenna Love, isn't that right?
Yes.
Jenna Love is Alex Xavier's mother.
Yes.
And Jenna Love was about to get out of prison during this time, isn't that correct?
Not for a couple months.
Okay. You had some rules that you wanted Mr. Pedron to follow, or you weren't going to stay in a relationship with him.
I wanted her to stay away from me.
You wanted her to stay away from you, no contact with you, right?
Yes.
And you wanted no contact between Mr. Pedron and her as well. Isn't that right?
Away from me and my children.
Away from you and your children. You
Yes.
didn't want him having contact with her either, though.
That was left up to Derek.
Do you recall Derek sending at your request a text message to Aubrey, his daughter, saying any contact with Jenna would have to go through third parties?
I don't know what Derek did.
Okay, he sent that message or screenshot to you to prove to you that he wasn't going to have contact with Jenna because you didn't want that contact, isn't that right?
I don't see that.
It's not in this part, it's just before this part. I'm asking you if you remember all this.
No.
Do you remember having 3 rules for Derek?
Where's that?
I'll show those to you in a little bit. Now, in this message chain, the very next line after the 2 messages that you sent and we talked about in Defense Exhibit 300, you say, I gave you the option to make it right, and instead you want to call obsessive over Jenna and scream at me only about that situation. You see that on the second page?
I didn't get to read the second page. You told me to stay on the first page.
Okay, second page, it's the very first entry. Let me know when you're done.
Yes, I see it.
See it? What's the very next line that you send him in that very same message? Why don't you read it out loud?
It says it's just like you to only care about Alex and not Brantley and Araya.
So you're telling him he only cares about Alex and not the other 2 children?
Brantley and Araya always felt left out, yes.
Your very next message to him is one day they will have a man in their life who actually cares about them, right?
Yes.
So you're sending this to a man that you're afraid of.
Yes.
And you're telling him that his children are going to have a different man in their life.
Brantley would always ask me if I could give him a better dad.
I'm going to ask that be stricken from the record. That's hearsay.
But she was responding to your question, so I'm not going to strike it. Go ahead.
Turn to the next page, page 3 or page 36 at the top of that exhibit. The fourth entry down, you say, that's why all you do is say that you and Alex are leaving. Do you see that?
Yes.
Followed by you saying you don't give a fuck about me or my kids.
Yes.
You believe that Derek gave preferential treatment to Alex.
I believe that he left the other kids out when he would use Alex as a pawn.
And yesterday when you were testifying about this text message exchange, you said you didn't want Alex leaving the house with him because you thought he was going to be drunk and high when he had Alex in his care. Is that right?
He was.
Okay. The very end of this exchange, you tell, you're having Derek sent to your mom's house to pick something up for you. Do you see that? Derek sends you a message that says, I will call you when I'm by your mom.
Objection, hearsay, confrontation.
I think this is the effect on the listener, but what she's going to respond to. Go ahead.
And that's what it says.
That's what it says, right?
Yes.
And you actually sent the passcode to your mother's house for him, correct? So that he could get into the house? Actually, it's on a different exhibit from the next day, so I'll show that to you.
It says, and I'm sick of you throwing Alex in my face. Really, why should I care anymore?
I'm going to show you what's been marked as 152. This is a continuing exchange between you and Mr. Pedron, is that correct?
What page?
I'm going to show you the very last part of 152, which is a screenshot. What is the screenshot of?
It's of my mom's messenger.
And it's a message that you are forwarding to Derek with the passcode to get into your mom's house, isn't that right?
Yes, but it just says that Derek's stopping by.
You're sending him to stop by, isn't that right?
Yeah, it could be for anything.
Pick up things for you.
Yeah, I don't know what.
You said earlier that Derek and your mom don't get along at all, correct?
There was times where they did, but for the most part, no.
Okay. So this person that you're saying is drunk and high during this time frame, you're sending out in a car to go pick things up.
Judge, I'm going to object. I think that mischaracterizes this from the following day.
I don't know what the is this one continuous day? It's unclear to me.
One into the next.
Into the next
Ongoing
day?
Conversation, yes.
Right. The next day, I don't know that he was drunk or high.
This is the 20th is the day of the party, right?
Of Laura Lee's party?
No, the party that you said he had people over at the house.
Yes, but what time was that?
This message is sent at 0027:31. Subtract 6 would be
6:27 p.m.
6:27 p.m. You're sending him over to the house.
Right, and I don't know who was driving, and I don't know.
That's the day of the party. Or where he had people over at the house?
I don't remember exact dates, but if it lines up with the messages, then yes. But I don't know when he started the party.
Okay. I want to talk to you a little bit about Dr. Endres' evaluation of you. She said one of the things when she evaluated you and your personality is that you project blame on other people. Do you recall that?
I do recall her saying that.
And that you minimize your role or responsibility in things. You recall that?
I don't recall that.
Okay. When you were talking under direct examination yesterday, you said that you talked to the children about the basement stairs, the children being the children that lived with you in the house on OS, correct?
I don't remember saying I talked to them about the basement stairs.
You said you don't recall that.
Can you
testified just yesterday that you
Can you
talked to the children.
explain more about that conversation?
Yes, you talked to the children about those stairs being unsafe and they shouldn't play around them.
Yes.
Okay. That's not enough as a part of a parent to secure those stairs and make them safe for a child, is that right?
They were old enough to walk. They were old enough to know yes and no and understand not to play by the stairs.
So Araya should have understood as a 4-year-old child not to play by those stairs, in your mind.
Relevance.
You can ask if Araya was old enough to understand.
As you can see in the interview, Araya was a very smart child and she was very well spoken and she could communicate very well.
Okay. So you think that was enough as you as a parent to take safety steps for the children in the home, was just to tell them, hey, those are dangerous, stay away.
Yes, and that is why I told them to throw their clothes, not bring them down the basement stairs.
Same thing with prescription medication. You had a conversation with the children and you said, these are mom's prescriptions, stay away, don't touch, that's for adults.
Since my brain injuries, the kids noticed that I would always take pain medications or a lot of medications, I should say, not pain. And they would ask me, Mom, what are those? Why do you always take medicine? And I would tell them, Mom has to take them because of my head. You know how Mom always has headaches because they were used to quiet time. You know, Mom's head hurts, we have to have quiet time.
My question is that you believe just telling kids...
Explaining why we had, about the medication, why I explained to them.
I'm asking you beyond explaining it to them, should you have taken other safety steps?
That's not what you asked. You asked if I had a conversation with them, and I'm explaining.
Beyond having a conversation with them, should you have taken other safety steps with your medication?
Objection, speculation, resident, relevance. Calls for a legal conclusion.
It does not.
Overruled.
I had it in my drawer next to my bed where I took it morning and night, and I explained to them those are for Mom's head.
That bag of medication you had, you could have gotten rid of all those medications, couldn't you?
I planned on doing that, and then COVID hit, and we were on lockdown.
You could store them up high where no child could ever get access to them. You could have done that, couldn't
They
you?
were on a higher shelf.
They were on a higher
That's
shelf?
where I put them.
So they were on a shelf where none of the children could have accessed them, is what you're telling us today?
I believe they were either on that brown shelf or on my hanger shelf, which is where I put them.
And if they were on the hanger shelf, none of the children could have reached them, is that right?
No,
That's not right?
that is right.
That is right. None of the children could have reached it, correct?
No,
So the only person that could have touched that bag was you or Mr. Pedron?
correct.
The only two people that had the opportunity to touch that bag was you or Mr. Pedron, correct?
Yes,
Same thing if it was on the bookshelf, that was high enough that none of the children would access it, or no?
I can't say what the kids could have reached. I'm not the children.
You can observe how tall your children are and what they can grab, what their capabilities are, right?
Yes, but that house was very cluttered, and I don't know what they could have reached. I mean, there was...
Whose responsibility is it to put things that are dangerous to children out of the reach of children?
I did.
You did.
I put it up. I believe it was on the hanger shelf.
You believe it was out of reach for the children.
I believe it was on the metal shelf where I hung up clothes. I believe it was on that shelf. That's where I remember putting it.
I want to talk to you a little bit about your interactions with the police on February 11th, 2023. On February 11th of 2023, Sergeant Williams comes and talks to you, and you say that you want the no contact order dropped. Isn't that right?
Right after Alex died?
Yes.
Yes.
You said that multiple times that you wanted the no contact order dropped, right?
Yes.
Alex just died in the house.
Yes.
And at that point, you're telling us that you are searching for what could have happened to Alex to cause his death, right?
I thought it was an overdose.
I understand that's what you're telling us, but you're still searching for what it could have been, right?
In my head, I thought it was an overdose.
You wanted to provide information to the police that may be relevant to anything that happened to Alex, correct?
At that time, I thought it was an overdose.
I understand that's the rehearsed answer.
It's not rehearsed.
Just strike, asked and answered.
Struck, and it's also argumentative.
When you're having this conversation, you also bring up marijuana in the house, don't you?
Yes.
And you bring up marijuana in the house because that's a concern relative to something that Derek had, isn't that right?
Because he handed it to me before he went out to the cops.
Correct, because Derek used marijuana, right?
He did.
And that was what you would reference whenever you said Derek was getting high, was marijuana.
No, he used Xanax more.
You never told that to the police.
He didn't hand me his Xanax.
I didn't say you did. You never told the police about Xanax.
No, because he didn't hand it to me. I didn't have it. I didn't know where it was. He handed me the marijuana, so I felt like I had to tell the police because I knew where it was.
You knew the police were going to search your house. At that point, they had told you they were going to conduct a search warrant of your house.
Yes.
And actually, when they took your cell phone, they took it, you didn't voluntarily turn it over. They said, we're getting a warrant for your phone. Isn't that right?
No, he said I need to take your cell phone, and I handed it to him, and I gave him the password after I wrote down numbers.
Because he told you he was getting a search warrant.
I didn't care. I didn't fight him.
That's not my question. My question was, he told you he was getting a search warrant, right?
Asked and answered.
I don't recall.
You don't recall. You told this jury that you saw Derek Pedron do a line of Xanax on the table.
I did, yes.
At that point in time, you had to have a belief, if that's true, that there may be Xanax in your house when they're going to conduct this search warrant. Isn't that right?
I don't know what Derek did with his Xanax.
Exactly. You don't know if it's in the house or not in the house if you believe it's present, and you saw it previous evening, right?
I don't know what he did with his Xanax.
And the only thing that you mentioned as a concern when law enforcement told you they were searching the residence was marijuana.
Because I had had it in my possession.
We saw a number of videos through the course of this trial where Xanax and fentanyl were discussed by Derek to you, correct?
And I to him.
Correct. Those videos you never turned over to law enforcement, isn't that right?
Objection, comment on silence.
At any point?
Comment on silence, Judge.
Yeah, he can't comment on our silence, but did they turn over? That's the question.
Did you ever turn over those videos to law enforcement at any point in time?
I gave them to my attorney.
Okay. Those videos contain accusations made by Derek about you using drugs, correct?
They were accusations towards him using the Xanax because he was.
That was your response to him, but Derek always accused you of using Xanax and he accused you of using fentanyl, isn't that right?
He accused me of a lot of things.
On those videos, he accused you of using Xanax and he accused you of using fentanyl, isn't that right?
Yes, and other things.
Those were the drugs that he brought up every time, isn't that right?
And other things, yes.
And you were wearing patches during this time frame. You've already told us about that, right?
Occasionally I wore nicotine patches.
You're telling us they're nicotine patches, but these were what Derek would say to you, Xanax and fentanyl, correct?
Argumentative, asked and answered, speculation, and...
I'll move on. You knew that if you turned these videos over to law enforcement, they would have questions to you about your drug use, correct?
No, they could have drug tested me, and I was working with an attorney, and I handed them over to my attorney.
These videos were made in 2020 through 2022. You were not working with an attorney then, correct?
I was being advised by an attorney, yes.
In 2020 to 2022,
Yes.
you were providing these videos to an attorney.
No, I was being advised by an attorney to remain silent and not work with law enforcement.
Regarding what?
Regarding Alex's death.
From 2020 to 2022, you were advised to remain silent about the death of Alex?
I'm
He didn't die until 2023.
sorry, I get mixed up with the dates.
Okay. So you weren't advised at that point, correct? You agree with me now. 2020, 2022, Alex is alive.
Yes.
Okay. And Derek is talking about your drug use in these videos. He's talking about you using Xanax, you using fentanyl, right?
Objection, hearsay confrontation, asked and answered.
I'm trying to get her focused, Judge, on the answer.
So the question, what I'm allowed to ask is, did she turn over those, you've asked this couple of
No, I didn't.
You did not turn them over.
No.
And you knew that if you did, you would be examined for drug use issues, isn't that right?
I don't know.
You were asked about the school records for the children during your questioning yesterday. You agree that Alex Xavier had approximately 100 absences over a period of 2 years.
As well as the other children, yes.
He had more than the other children, though, correct?
I don't know.
You agree that Derek bears responsibility for that. You agree with that, right? He's the father. He should be getting Alex Xavier to school.
Yes.
Okay. And you agree that you also have responsibility for that, correct?
Yes.
You both have responsibility.
Yes.
Okay. And you both failed to get Alex Xavier to school on a regular basis.
I did. I couldn't.
We were shown 5 emails between you and the school. All those emails were from 2021 to 2022, isn't that right?
I get mixed up on dates, so it's whatever they say.
They were from when Alex Xavier was in kindergarten. Does that help?
I know there was emails from first grade as well.
Okay. The ones that we were shown were from kindergarten?
Okay. There was one email from when he was in first grade.
One from first grade?
Yes.
Okay. So that's 5 messages that we were shown over the course of 2 academic.
We were shown a lot. I don't know the number.
One of the things that you said when we left off before lunch was that you were scared to say anything about Alex no matter what. You recall saying that?
I was scared to say anything about all the abuse, yes.
Okay. Even when Mr. Pedrin was in custody the evening of February 10th, you were scared to say anything to Sergeant Kernine, correct?
Yes.
Or maybe it might be Deputy Kernine. Deputy Paff?
Yes.
You're scared to say anything to him? Scared to say anything to Laura Lee?
Yes.
Scared to say anything to your mom?
Yes.
Didn't say to anything to any of those individuals because you're scared, right?
Yes, I would cover up my bruises with stories.
One of the things you said on direct examination yesterday is that you were threatened with violence even if you talked to another man.
I was.
Okay. You said you were excited to be talking to Rafael Suarez.
I was.
You're excited to be going on a date with him.
I was.
You're excited about the prospects of starting a new relationship.
Possible, yes.
Okay. You weren't afraid of that at all, but you're afraid of disclosing child abuse?
Yes.
To protect Alex Xavier?
To protect all of us, yes. Other kids were being abused as well.
According to you?
Argument.
It's the truth.
You saw the forensic interviews of the children, correct?
I did.
They didn't disclose any abuse by Mr. Pedrin, did
They
they?
were scared of him too.
Judge,
I didn't ask anything about the forensics.
The forensic interviews, you did bring up the forensic interviews. You mean, which ones, the two?
I asked about disclosures regarding Mr. Pedrin right now. I think that's a different topic in the forensic videos.
Oh, yes.
and Judge, I think this calls for comment on the credibility of other witnesses, which is improper. I think that this is argumentative in the form that it's asked, as well as hearsay and confrontation.
It's an exception to hearsay. Counsel asked about the forensic interviews and her thoughts about the forensic interviews and the disclosures on direct. I think it's appropriate.
Overruled. Go ahead.
I said they were scared of Derek.
They were scared, so that's why none
Yes.
of them said anything.
Absolutely.
Okay. But they did disclose a lot about you.
Major did.
Major did, so did
Yes.
Brantley.
Brantley didn't.
He said, you choke.
I don't recall what Brantley said, but
He said, you hit.
I never hit Alex.
I'm saying what he said. He said, you hit.
I never hit and I never choked my children.
He said, you kick.
I never kicked my children.
The children were placed in separate homes before the forensic interviews were conducted and after the death of Alex Xavier, isn't that right?
Yes.
Major was with his dad,
Yes.
and his dad didn't live with you, right?
No.
He had no idea what or how you treated the children inside your home, correct?
They were all talking to Major before the interview.
They were all talking to Major.
His grandma and his dad were calling the sergeant multiple times after talking to Major,
About what Major was reporting, correct?
supposedly.
And you know those calls were recorded, correct?
To the sergeant,
Yes.
not the ones to Major.
And you know that the sergeant documented what those concerns were and they weren't relative to the forensic video.
Objection calls for evidence beyond this witness's scope.
Sustain.
You've heard those recordings. I'll move on.
Yeah.
Brantley was in a different home, correct?
Yes.
Brantley was in the home of one of your relatives.
Yes.
It was your relative that took Brantley to his forensic interview.
Yes.
Brantley, to your knowledge, was not having any contact with Major during that time frame, correct?
I don't know.
.153, these are the rules that you put in place for Mr. Pepper. Do you recognize this series of text messages?
1 second.
Do you see about a little over 1/3 of the page down, and it's a message from you, and it starts off with the word fix?
Yes. Are you going to stop with the or start with the first rule?
Your first rule is fix the shit with a no contact, correct?
Yes.
Okay, your second rule is tell the truth. It's better for a family to communicate, and you and her won't ever be. That's talking about her and Mr. Pedro and Jenna Love, correct?
I don't believe so.
And your option on that other one is or tell me the truth, meaning tell me the truth about whether or not you're communicating with Jenna Love, right?
No.
Your next rule is get rid of bitches,
All right.
because you thought he was seeing other women.
I didn't know.
And then the last one was make me feel loved, right?
Right. And not abused.
It doesn't say that. It just says make me feel loved.
But I know how I felt.
Your message is make me feel loved, right? He sends you a screenshot at the very end of this chain. I think it might be on your exhibit. I'm just turning it to mine so we can both look at it at the same time. The person in Mr. Pedrin's phone is heart my life and then flowers, correct? At the very top.
I see it.
Yeah. And this is a text message to AUBZ, who's Aubrey, his daughter, right?
Yes.
And he's telling Aubrey that if there's communication when his mom gets out, there will still be a no contact order in place. Isn't that right?
Yes, that's what he says.
He's doing this because this is what you want.
No, I don't. I never controlled Derek. He controlled me.
He's sending you a screenshot saying that he's not going to have contact and telling Aubrey about that because that's one of your rules.
No, it was not.
Moving 153 in evidence.
Hearsay confrontation.
This is her messages, right?
Her message.
But no, it's a message that Mr. Pedrin sent to his daughter that was screenshot and sent to her.
Okay. Okay. The earlier parts of the exhibit are received. The screenshot. Screenshot is hearsay. But the screenshot is in reference to what the response is, so it's completeness, so I'll allow it to be received.
And my only argument would be it shows his actions based on the messages sent to him, sent back to her.
I didn't make him do
Judge,
it.
I think that's the definition of hearsay.
That is the definition here, so I'm allowing it in just to show what the series of conversations are, so.
Yes.
And responses. Go ahead.
I want to talk real briefly about the chain of events surrounding Alex Xavier's fall down the stairs, as reported by you, okay? That fall happened on January 14th, 2023?
I'm not good with dates, so.
Okay. Did it happen the day before or the day of the birthday party that you attended for Christian?
Again, I'm not good with dates. That's the hardest with my brain injury.
Okay. If the birthday party that you attended for Christian was on a Saturday, you already represented to this jury that you wanted to get Alex Xavier medical care that Saturday at that party, correct?
I did.
And you also told us that it was Mr. Pedrin who was drinking and wanted to stay drinking and did not want to get medical care for him, correct?
Right.
Okay. The next day is a Sunday, though. And Alex Xavier isn't taken in for medical care at any point on that Sunday, is he?
I'm sorry, I do not remember the date. It's a blur.
Okay. He's not able to walk at all on Saturday. You have to pick him up and carry him. Isn't that right?
I did.
Okay. And you had to carry him, not only just physically carry him out of the car, but carry him into the house.
Yes.
And you had to carry him and put him on a bed.
Yes.
Okay. You told us earlier that you had balance issues, and so you didn't think you could do something like kick a child, but you're carrying around a 47-pound child.
It was very hard.
It was very hard, but you were capable of doing it, right?
I had to hold on with all my might.
And you carried him in that
Almost
house.
dropping him, yes.
And you carried him out of that house.
By the time I got to the vehicle or the bed, I was literally holding on till he was like to my knees. I struggled. The left side of my body is very weak.
And you could physically pick him up and put him in a grocery cart, correct?
Again, I struggled.
That's
And
higher up even to put a child.
If you can see where he was sitting in that grocery cart, it was on the seat, not in the cart. It wasn't in the cart. They had those double seats, so it wasn't like I was lifting him in the cart.
You picked him up and put him in the cart was my question.
Not in the cart, no.
You pick him up and carry him around the house.
No.
You moved him from the couch to the bed on the evening of February 10th.
Yes. Again, my right side is stronger than my left, so I
So you
sacrifice my right side.
you have the ability to balance and carry a 47-pound child.
I sacrifice my right side a lot, and I used the bed to scoot him to where he was laying. I've learned to live with this disability.
Outside of sending one video to Laura Lee involving Alex Xavier being yelled at by his father and telling her to keep it and hold on to it and not send it out, is there another example you have anywhere of how you protected this child from this claimed abuse that you say was being committed time and time again?
I sent over a dozen videos to Laura Lee.
That's according to you, not her, though, right?
It's the truth.
With all this abuse happening to the children in the house, according to you, to Alex Xavier, to the other children, you never reported it to law enforcement once.
I did.
When?
On the 911 call.
You never reported it to police after making that 911 call. When you were interviewed, did you?
I did that one time. I felt like I could that one time. After that, I was scared for our lives.
Scared for your lives to report child abuse, but excited for your life to go on a date. Thank you.
Argumentative, move to strike.
Saying. All right, redirect.
Josie, I want to talk about this issue with the shower. Back in 2023, how did you wear your hair?
I wear it either down or up.
Was it about the same length and, I was going to say width, but the same fullness as now?
Yes, my hair's always been long.
Okay. How did you go about drying your hair after you get out of the shower?
I'd put it up in a towel.
So you wouldn't blow dry it right after a shower?
No.
And Josie, if you are in the shower, would you wash off makeup or other things that you were wearing?
Yes.
I'm going to show what's already been admitted as 254. Josie, take a look at your hair here on the zoomed out view. Does that look like you had recently been in the shower?
No.
Does it look dry and like in the position that it normally would have been?
Yes.
And I got a quick makeup tutorial over lunch from Ms. Sanchez here, but does it look like you're wearing lip gloss or something on your lips?
Yes.
Is that something that normally you would have washed off in the shower?
Yes.
I'm gonna zoom in here to your eyes, and it looks like you're wearing eyeliner on the upper and lower sections of your eye. Is that correct?
Eyeliner and mascara.
Mascara. Okay, Mascara is the one on top, right?
That's the eyelashes.
Oh, the mask. Okay, the eyelashes. Would you have put makeup back on after a shower?
No, not if I was going to sleep.
Josie, fair to say that there were some flirty texts about possibly taking a shower with Raph in the
Yes.
series of those messages?
Yes.
You're familiar with that bathtub? I have one like that myself in my house. Is it your experience that water will, or droplets of water will remain in the tub for a period of time after taking a shower?
Yes.
And did you see any water or evidence of a recent shower in the tub?
No.
We're all addicted to our telephones these days. Are there parts of the day where you're not using your phone, Josie?
If I'm holding the kids to get them to sleep, Brantley was big on that. I had to hold him and rub his back. If I was watching TV, I would not. If I was eating something, I wouldn't. If I had a bad headache, because if I'm on the phone too much, I get the screen. I have to take a break.
How about if you're playing with the kids?
Yes. I stopped, one of the reasons, other than Derek accusing me of stuff, I stopped going on Facebook also because I noticed it was taking me away from the children.
Does it strike you as unusual at all, Josie, that there would be a period of time that you're not sending or receiving texts for half an hour to 40 minutes or however long that was?
Yes, I'm still like that. I won't text people back for a long period of time.
Did you take a shower?
No.
So, going to after Alex died, did you want Derek to see the kids?
Yes.
Why is that?
I mean, I don't know why, but even being abused and going through all that trauma, you just, part of you wants that person there. And I just wanted a piece of Alex. I wanted a piece of, even though he was so abusive, I wanted to feel like Alex was there. I wanted to feel like that life was there. And even if I was getting beaten, I just wanted to feel like my family was there.
Okay.
Just for a second.
Was Derek seeing the kids regularly after Alex died?
He would not come see the kids. He would come in the night only to see me.
Were you upset with Derek for not coming to see the rest of his kids?
Yes.
Now, the state suggested that you wanted Derek to come over to have sex with you. Was that the case?
No, but that's all he wanted.
So, Josie, you were asked several times why you didn't mention child abuse before. Do you recall those questions?
Yes.
What were you trying to tell Sergeant Crenine when you told him that you were scared of Derek?
It was so hard to open up and talk to the police about what was happening. It's like I couldn't get it out because of the fear. And when I told him I was scared, part of me wanted him to just care and be there and ask, but I couldn't get it all out. The fear took over, and all I could see was what would happen if I did, what would happen if I told. He would find me. Pictures of the guns, people he knew would find me. He would kill me and the kids and then himself.
Josie, did you believe that the police had any ability to protect you or the kids if you disclosed that Derek had been harming the children?
No, because he always got out. He always got the charges dropped. He always blamed me, made me get the no contacts drop, made me hound the DA.
Were you able to confide in Brian Moldenhauer about some of the abuse that was going on at home?
Yes, Brian was a very good friend of mine. He's one of those people that I've known for high school, and he's just never changed. He's been the same person since high school, and he's a farmer, and he's never been through trauma. He's just a really good person that I could talk to. And
Josie, you recall the 911 call where you said that Derek did the same thing to his 6-year-old as well?
yes,
Was that a moment of fear where you were you scared saying that even to the dispatcher?
I was, and I just spit it out, and I was scared.
And did anybody ever ask you what that meant?
No,
On the topic of protecting the kids from Derek, did you try getting a restraining order against him?
I did.
And do you recall in that restraining order, did you mention that Derek was becoming violent with the children?
Discretion is beyond the scope.
Judge, the state opened this door.
It's overruled. Go ahead.
I don't know, this is just.
Oh. This is a copy of a certified copy, but we have the certified copy here. If you're looking for that.
Let me see what you're talking about.
Josie, I'm showing you what's been marked as 313. Does this appear to be a restraining order that you tried seeking against Derek?
Yes.
Did anybody help you with that?
Yes, a lady from Salvation Army.
Okay, so this was the social worker at the Salvation Army?
Yes,
I see the date on page 3 here is it's signed June 25th of 2019. Is that accurate?
yes,
Would that have been the date that you signed it?
yes,
It looks like the notary is our current court reporter. Is that correct?
yes,
All right. So Josie, on the back, there was a section where you had to write what had happened with Derek. Do you recall that?
yes,
And
But for the purposes of this exhibit, I'm going to ask that be used for the limited purposes related to the children only.
Yep.
that is all I'm gonna use it for.
Thank you.
Yep.
And I am just gonna highlight a section here. Did you write that Derek uses violent force towards the children at our home?
yes.
What did you mean by that?
He was violent towards the children, and he would hurt them.
Offer 313 for the purposes used.
For the sole purposes used,
For
to
that
be
purpose,
received.
yes.
Yeah, be received for that sole purpose.
Josie, what happened with that restraining order?
He didn't follow it, and
Judge, I'm going to object. I don't think, can we have a sidebar on this?
Yes.
Let's talk about the house again, and we've already agreed that the house was pretty messy and pretty cluttered. Is that fair?
Yes.
Do you think that you would have noticed if a particular piece of property like that purse was on or off the floor at the time?
No.
I want to talk about Derek's call after Derek's phone call to you after he was arrested on the 10th. Or excuse me, your phone call to Derek after you were arrested in May of 2023. Do you remember talking about that?
Yes.
How were you feeling at that moment, Josie?
I was in shock. I didn't understand my charges. I had to keep asking the jailers what my charges were. I miss my kids. They were crying for me on the phone.
What did you mean, Josie, when you told Derek that you got what you wanted? I'm being blamed for it.
Before I got arrested, Derek kept telling me that.
Objection, this calls for hearsay.
Yeah, sustain.
What did you mean by that comment, Josie?
Derek said he was going to blame me.
Objection calls for hearsay. She's responding with his answers.
Effect on the listener.
So it's not being offered for the truth of the matter, only for the effect on the listener.
Only for why she would say that.
Okay, go ahead.
Okay, go ahead, Josie.
Derek said that when he was beating me at my mom's, that he was going to blame me for Alex's murder or death.
Why would you tell this man that you love him on the phone?
Because I was in a situation where I was alone. I wanted my kids, and I needed love.
I'm going to follow up a little bit on what you offered earlier with the state, but have you known Derek to have others clock him in or out of work if he was late or leaving early?
Yes.
Calls for hearsay.
The question was asked why she believed. This is what she believed. Go ahead.
He would come home and brag about it.
That's hearsay. I would ask that be struck.
Given the situation, I'll allow her to answer that question.
So talking about that purse or the Coach bag, Josie, you said that you believed it was on the hanger shelf. Did you know that it was there for sure?
In my mind, I picture it was on there.
You know whether or not Derek accessed that bag while he was in the room with Alex?
I don't know. I didn't.
Along kind of the same lines, why did you ask to lift the no contact order with Derek after Alex died?
Because we had a mutual hurt in common, and that was Alex.
You gave some testimony that you wanted to feel something. You wanted to feel like Alex was still around. Is that accurate?
I did, and I just wanted to feel, even if it was hurt and pain, I just wanted to feel some type of closeness to Alex.
So, Josie, you were asked why you couldn't take Alex to the doctor on Sunday after the birthday party. Do you remember that question?
Yes.
What was going on in your life where you couldn't take Alex to the doctor yourself on Sunday?
In the morning of Sunday, when we got back from the birthday, Derek had beaten me to the point where I could not move because he accused me of him getting beat up by the Hispanics.
By the Spanish-speaking men?
Yeah.
Was there any reason why Derek couldn't take Alex to the doctor on Sunday?
No.
Josie, in terms of the staircase, what efforts did Derek make to protect that staircase from children playing around it or falling on it?
He didn't.
He did nothing at all?
No.
Regarding the emails to and from Hinchin, the school district, were there additional emails that we didn't discuss between you and the staff of Hinchin?
Yes.
Were you in fairly regular contact with the school?
Yes, they considered me a helicopter parent.
A helicopter parent, did I hear that right?
Yes.
In terms of the text sequence that you were asked about where Derek swung by your mom's house to get something, would your mom occasionally have things for you, food or utensils or anything else?
Yes, she'd pick up clothes for the kids. She'd pick up, if I couldn't afford Tylenol, ibuprofen, soda, water. I mean, whatever, anything. She'd find something on sale. She'd pick it up for me.
Okay.
She was a mom.
And if that trip to your mother's happened the following day, do you know if Derek was still drunk and high, like you said on the 20th?
I don't know.
Why would you say in those text messages that Alex needs to be here at home healing and not out getting drunk and high with you?
That would have been the day before he went to my mom's.
Yeah. And why would you say that to Derek in a text, that he needs to be home healing, not out getting drunk and high with you?
Because Derek...
This was asked and answered in direct originally.
Sustain.
Were you telling the truth when you made those statements on the text messages, Josie?
Asked and answered.
Sustain.
Did you have any reason to believe that those texts from the 19th and the 20th of January would one day be used in a homicide trial 3 years later?
Asked and answered.
Overruled on that.
No, I would not, and I wouldn't have wrote them if they weren't true.
Give me 1 second, Judge. That's all I have on redirect.
Recross?
I just want to touch briefly on the photograph that you were showing after sending the text message that said, "I just showered," okay? The time frame where your phone has no activity is from roughly 7:47 to 8:29, correct?
I believe so.
Okay. The text message photo that you send to Rafael Suarez, the photo that we've seen in court, that's sent at approximately 9:20, isn't that correct?
If that's what it says.
Okay. And the photograph, you take a number of selfies according to your phone activity before you pick that one to send to your date for the next day, isn't that right?
That's what I usually do, yes.
Phones have filters on them, correct?
Yes, but...
You're also sending a text message to someone you're going on a date with the very next day, correct?
Yes.
Okay. You want to look your best, you want to show your best for that date, isn't that right?
I mean, I guess, yeah.
People don't generally send a text message to someone they're about to date the next day with no makeup, nothing on.
I do.
You do?
Yes.
Okay. That's not what you did here, though, is it?
I already had makeup on.
After you showered?
I didn't shower.
I understand you say that today.
Any redirect?
Josie, did you regularly wear makeup to bed?
No.
And the time frame of 7:47 to 8:29, would that have been right after Derek was arrested?
I believe so, but I'm not good with time.
He was arrested around 7:30.
I think so.
Were the kids upset at all by the fact that Derek had been arrested?
Objections beyond the scope.
It's related to this timing issue. I'll allow that question to be asked.
Not this time, no.
Okay. Did you have some things to do with getting the kids to bed and getting the kids rounded up after Derek was arrested?
Yes.
Did you use a filter on your phone when you were taking those selfies, Josie?
I'm not good with the filters, and those are usually on Snapchat.
Okay.
Other than, like, tints for the background.
And we don't see cartoon dog ears or anything on you, correct?
No, I don't know how to work those, unless it's on Snapchat.
Were you wearing makeup in that photograph?
I was.
Nothing further.
Anything further on that?
Nothing on that.
Okay.
Yes. Thank you, Judge.
Hey, step down. Why don't we take a break for about 15 minutes and we'll go from there. 10 to 15 minutes. Right, is that something you two could maybe talk about? And we could just, okay. And then just before we get into an argument about whether that is appropriate or not, and is there not at the latest? Of course, there's no, as deliberations, as you heard me say this before, I cannot tell you how long that takes. That's really up to a jury. But at least as far as the finishing of the full trial going to the jury, my hope is you'll have it no later than Friday at the latest. Good news. The other thing is, if you can come back tomorrow morning, 8:30, we should start right up with whatever witnesses, if there are any witnesses, and then we'll go to the end of the trial. Thank you so much. Please don't talk about the case as usual. We'll see you tomorrow. Everybody may be seated. Just let you know, Christina is taking what was sent to by the state to and is now we're incorporating it. Of course, we can discuss it. That's just to have so we can talk about the entire thing at that point in time. Sort of what I usually do is I make copies of the instructions, give you both copies of it. I'll have her send you an electronic version of it too, and then we can start working through it. Probably not till about 3:30 is when I think we'll be ready. She's working on it as we speak. One other question. This is a really Mr. Colkine's not being called as a rebuttal witness, right?
We don't intend on calling Mr.
Okay.
Colkine.
There's a logistic issue which we just need to clarify. My also hope is that we'll be out of here in a decent time today and then tomorrow, of course, but regular time. Anything else we need to talk about while we're waiting for that to be done?
Judge, I would like to argue the objections on the proposed rebuttal witnesses.
Okay, why don't we do that right now? Go ahead.
So, Judge, as the court recalls, Dr. Iniguez was excluded on a couple of grounds, both relevance and as well as in the context of the Daubert hearing, as well as the discovery violation. What we're looking at here is whether or not this is bona fide rebuttal, as defined by State versus Cacciatolo and subsequent cases. Bona fide rebuttal is not any evidence that the state wanted to put in its case in chief. It's not evidence that's defined by context or providing additional information. It's in direct rebuttal or response to our case. We were very careful not to open that door to Dr. Iniguez testifying on rebuttal to these issues. Both Dr. Christensen and Dr. Quentin testified that this would be expected to be a painful injury. We didn't contest that testimony. They testified to that. I agree the court or the state can argue that, but there was no disagreement that Dr. Iniguez is coming in to rebut. Rather, the testimony that's coming in rebuttal is testimony that the court excluded in the state's case in chief, and they're just trying to backdoor this as rebuttal evidence. It's not in response to anything that we've raised, and particularly if it's just being offered for context or information as to how a child might react in that situation. That's evidence that a reasonable prosecutor should include in their case in chief in direct and was excluded by the court as a result of the discovery issue. As to the lab evidence, this was evidence once more that a reasonable prosecutor should have tested and produced before trial. They had 3 years to send this to the state crime lab, and they didn't. We also intentionally avoided opening this door. Attorney Torbenson emailed me, I believe, last weekend saying that they had this tested and the presence of sucrose was detected, and advised me before I cross-examined Sergeant Amundsen as to that. In the process of this, I asked Sergeant Amundsen a very specific question. Before trial, were any of these substances tested? And he said no. I did not ask subsequently. The state did not redirect with subsequently. We intentionally did not impeach Sergeant Amundsen with comments on the body camera where they're describing on the body camera, looks like it could be a pill fragment. When collecting this evidence for that reason, I didn't want to open up that door. Additionally, I think this is problematic in that we requested a copy of the report or any other documents immediately after we were notified of this, because what the state's describing is effectively exculpatory evidence, where this is also inconsistent with the state's theory of staging the scene to make it appear like an accidental overdose. We've received no reports at this point. Obviously, I don't have a multi-million-dollar crime laboratory on retainer to get this evidence retested in the meantime, but this is not within the scope of rebuttal to say that we didn't test this throughout the case, now we're going to do it mid-trial and introduce scientific testimony, which has yet to be disclosed to us, contesting, consistent with the state's theory of the case. It's evidence that should have been tested. It's evidence that should have been tested a long time ago. It's also problematic in that, as the court knows, my wife works at UWL. I know a number of these people. I don't know who they're going to produce, but these are certainly people that I've met and have interacted with in the past. But just looking at this, I think, one, it's a violation of the state's obligation to continue to disclose exculpatory evidence as it came in. It's arguably exculpatory. Two, I don't think that this is bona fide rebuttal evidence as defined by Cacciatolo in direct response to something that we did here. The issue was, were they ever tested before trial? They were not. The state can't come in then and produce scientific evidence that we have absolutely no opportunity to rebut. We have no opportunity to assess the validity of this. If it's a student assisting with testing, if it's a test that's specific to sucrose or specific to or includes testing for controlled substances in addition to that, it's too little too late. I think that this is unfair surprise and that this evidence should be excluded in its entirety.
Let's talk about the lab testing first. Why don't we do that first? Go ahead.
All right, State versus Hatcher is the case that says that an issue that is raised during cross-examination by defense counsel can lead to rebuttal evidence on the part of the state. It's always been our theory that this is sugar. We said it from the start. We've talked about this being the cotton candy that was all over the floor, on the pajamas, and in the bed. That was the testimony essentially of Investigative Sergeant Rich Amundsen when he took the stand. The first I've heard of a pill fragment, and pill fragment was used throughout the questioning of multiple of the on-scene initial responding officers by defense counsel. They also used pill fragment when they were questioning Lieutenant Williams, when Lieutenant Williams was on the stand and not having the pill fragment tested. That raised a bona fide question. One of the things that State versus Hatcher talks about is that a jury trial is a truth-seeking function. The truth-seeking function here is having the testing completed and demonstrating that it is what we always purported it to be, and that is sugar. So the substance was tested. As soon as this issue was raised, we made arrangements, not with the Wisconsin State Crime Lab because they test for drugs. This is not drug testing. This is testing to verify that it was in fact sugar, which is what we believed and not what the defense was suggesting it was during trial. The testing came back as sucrose at a higher than 98% rate. It's been compared to other sugars, including other sugars that are often used in pills to constitute Xanax pills. It's lactose that's actually used in those pills, and it doesn't come back consistent with lactose at all.
So the people who tested this, did they know that?
They knew that sucrose was the main ingredient in.
But they're not experts in pills.
They're not experts in pills, and I don't anticipate them testifying about contents of pills. But I'm providing that information to the court to know how careful we were being in having this testing conducted. The student that tested, it's actually not a student. It's a doctor. His name is Alex Paulson. He just transferred to the university from Michigan last year. So he's been with the University of La Crosse for 1 year.
Judge, could I respond on the legal issue?
Go ahead.
Hatcher, as I understand it, is an unpublished but persuasive opinion. The opinion that I would direct the court to was State v. Konkol, Konkol. That was a case that addressed bona fide rebuttal with fingerprint evidence, where in that case the state was surprised by the defense indicating that he only had one beer with a .12 BAC, and they were permitted to introduce fingerprint evidence on other beer bottles or beer cans, I believe, to rebut that defense. The issue there was legitimate surprise. This should not have been a surprise. We viewed these pills, they were collected, or we viewed the substance, it was collected. It's something that's been on the radar for a long time in this case. And additionally, professors' findings here in the testing on this substance, we're entitled to a Daubert hearing on that. If they're going to discuss the veracity of these tests or the range of substances that were tested for, and I mean, that would be my request, is that we have a Daubert hearing on this matter as well if this introduce this.
But you don't have the report, right?
I do have the report. I can have it sent right now. I think it was just the final report was provided to.
But as we speak, he does not have the report. The state doesn't. The defense does not have the report, right?
We just got it.
Yeah. All right. Two things. One, I don't think this is a surprise. I think this material was all over the place. It was there. It could have been tested by the state a long time ago. It's been around 3 years. Actually, there's been a lot of evidence here that there's cotton candy, et cetera. It was brought to the attention that this did not look like it was a pill, et cetera. It wasn't tested by anybody. So having this type of testing is not, well, first of all, it's not a surprise because it was always around. It was in the scene. It was collected by the police. If there was a statement by, it was an officer who said it was a pill fragment, I believe in the video.
Well, it was Deputy Jar talking to Sergeant Amundsen on the body camera, where they said something to the effect of, sure looks like it could be a pill fragment, could be candy, we don't know.
Right.
Yeah.
So at that point, that was evidence that comes from day one, moment one in the case. If the question was raised, and this is not a surprise to the state at all. I agree that there would be a whole process of having, you might have the report right now, but they would also have a right to test it too, if they wanted to test it. So I'm not going to allow that lab evidence to come in. That's going to be excluded. Now, why don't you argue the other the issues of the Dr. Nunez? I apologize if I'm mispronouncing your last name, but go ahead on the issue of the doctor.
Me or?
Yeah. I think they already made their argument that they believe this was. They made the argument earlier. Actually, and I do have a question because this goes back to an original discussion we had just before we took the break. You said her testimony would be really more of an elaboration of what a child would feel.
She can provide more details regarding the symptoms of the child and the time frame for those symptoms because she deals with live patients and not individuals who are dead and performing autopsies. So she brings that unique experience. And in the testimony of Ms. Dikeman specifically talked about not really seeing any symptoms or not really seeing any symptomology. And I think in particular in this case, the symptoms that Alex Xavier would have had and the timing of those symptoms is actually a big issue.
And especially if the theory that if the theory of the defense is that this just happened only moments before he was arrested or within an hour or two of being arrested, So she's rebutting essentially what's being asserted by Ms. Dikeman, is what you're saying?
By Ms. Dikeman, that these injuries were inflicted during the narrow time frame that Mr. Pedram was there. Yes.
Or the observations of the pain, in other words. It's really rebuttal of the observations of the pain. Is that correct?
Yes.
Okay. All right. I'll give you an opportunity to respond to that.
Judge, it was something that was both raised with both pathologists who testified as to the pain that could be expected. We knew that to be testimony in rebuttal to Ms. Dikeman's preferred testimony. It was effectively done. This is something that the state noticed with Dr. Iniguez in the expert testimony that was excluded on direct. That does not make this bona fide rebuttal to say that we want more context or more information. The jury's already heard that testimony. And this, again, is surprise. We're going to bring in it's something that was well known to the state that this would be an issue in advance. It was something that was contained in the various expert notices. I don't believe that we opened that door at all. In fact, we didn't object to the questions about pain level that a child could experience under those circumstances. This is more of the same of what the court excluded. It's not scientifically reliable. Dr. Iniguez's experiences, however many or however few that she has, are not relevant to assessing how Alex Xavier would have reacted. But we've got two forensic pathologists that have already testified that yes, they would expect this to be a painful injury, and yes, they would expect the child to be exhibiting symptoms. It's not in response to anything that we have presented in the course of our case, and therefore it's not bona fide rebuttal.
Yeah. So first of all, on the qualifications of Dr. Iniguez, she's a specialist in the area of unintentional injury of children, specifically, or intentional injury of children, specifically when there's multiple planes of injuries, the severity of the injuries. She testified to that. She has the background in that area. She also testified to her qualifications and the research that she did. I did say at the time that I could see that she meets those qualifications to allow her to testify. The real issue that came down to, which excluded the testimony in chief, was the issue that the court felt that it was basically the report was not turned over until we actually had the Daubert hearing, which was too little too late. What the court will say is that I believe she can testify to a very limited purpose, which the state has outlined. Talk about these type of injuries would cause this type of pain in those she has worked with, and what she knows from whatever research she knows. But it's only about that issue. She's not to talk about it's her conclusion that this is a intentional infliction of injuries. What she can talk about is these type of injuries cause this type of pain, and when you would feel it, basically, because you would feel it soon after. I'm assuming the testimony will be soon after it's inflicted. Is that clear enough?
Pain and symptoms is the way I understand.
Pain and symptoms, yeah. Pain and symptoms. So she's allowed to testify to only that limited purpose.
Judge, I'd still like to Daubert Dr. Iniguez on her experience and rationale for her testimony in that matter.
We had a Daubert hearing. She seemed to have testified about her experience with injury. Are you talking about where the pain is?
Where the pain is, what experience she has with patients with this particular injury, how she can make that description, whether or not she can generalize that description to all children.
All right. What I'll do is we'll do a small, on that specific issue, we'll do a small hearing on that. I'd actually sort of like to hear what her testimony is so I can understand exactly how this will come in, but not only that, I think with her experience in this specific area, meaning the injury and its effects, without having going back to it, I allow a little bit of voir dire about that issue beforehand. So we'll be very specific area. I'm still at this point inclined to allow her in, knowing what I do know what she knows, unless there's something that comes to our attention in this process. But what we'll do is that if you can have her at 8:30, is that possible?
Flying in from Cleveland, so I don't think she'll be here until late morning. We're working on maybe getting an earlier flight. I'm not sure if it's possible, but we're trying. We didn't anticipate the defense resting today, Your Honor.
Yeah, I forgot she was in Cleveland. For some reason, I thought, yeah.
We're trying to get her in earlier, Judge. All the wheels are working downstairs to see if that's a possibility.
Okay.
If you want to come back for jury instructions, we can have an update.
Yeah, why don't we find out when she can be here, but I'll allow there to be a Dauber hearing either way.
Judge, yeah, I'll just put on the record that I don't believe this is in any way, shape, or form bona fide rebuttal. We're being sandbagged with an expert that we are not able to provide sir a rebuttal to.
I would just note that this topic was actually addressed in the Dauber hearing. I did bring up, because I think the defense was actually, they said that my notice didn't contain symptomology, but she talked about her history with working in a trauma section of a hospital for a number of years and working directly with patients, including patients with these injuries. We had a 2-day Dauber hearing, 2.5 days, I recall, and this topic was well-versed and well-covered during those hearings.
Yeah, I remember this topic being talked about. I'm not sure why this defense believes it wasn't talked about, but but I'll still allow there, because this is a really particular area, I still allow there to be a voir dire. I do not expect to spend more than a few minutes on this issue. I'm not going to spend like 2 hours on this, 3 hours on this issue. So be efficient, in other words. All right, find out when she can come. I'm going to talk to, when do we have you guys come back? Let me just find out what Christina is saying about being ready.
Judge, may I ask a question related to closings?
Sure.
Are you imposing time limits on the parties?
Well, it depends a little bit when it happens, but yes, there's going to be some type of time limits, but it has to be reasonable. I mean, I'm not going to make it 30 minutes or something like that.
I wasn't expecting that. But
yeah. I mean, I think you have to give me, looking at the openings, quite honestly, the States was very short. It was 30 minutes or something like that. Maybe 45. I can go back and look.
I think it was 54 minutes, and Attorney Zacher was an hour and 16. So they're relatively close.
They're relatively short. So yeah, you might be right about that. So yeah, I mean, what are you thinking it will take the state to present closing?
I was just looking from guidance from the court on what the court was going to.
If I gave you both an hour?
It's going to be longer than an hour.
It's not going to be much longer than an hour. I'll do an hour and a half. You'll lose a jury eventually. I mean, we've already been doing this for 2.5 weeks, so so make it an hour and a half. You both have, it'd be total hour and a half.
Broken up.
Yep.
Got it.
Thank you. All right. All right. This might take a little bit longer. Let's say another. Come back in about 20 minutes. Or about 10 to.
Oh, Judge, we would move to release Rebecca Ehlers from our subpoena, and my understanding is that the state is also doing the same.
Yes, we agree with that, and there's a number of other individuals that have been out in the hall that are asking if they can be released. If they are not on the defense list and we're not calling them, can all those individuals be released as well?
So long as the state is not calling them.
Okay.
Yep. Everybody is released who's not being called.
Yeah, and Attorney Zachary, did you want to make a record about the evidence in the bag?
Oh, yeah, so just so we're tracking the forensic evidence here, my understanding is that the chap's bag with the pill bottles was placed back into the original evidence bag, and the clerk intends to put that into a larger paper bag. We're fine with that as long as the integrity of that bag is maintained.
All right, thank you.
Judge?
Do you have any objection to that? Okay. Thank you for catching that. So that gets us to essentially to 145, which is on page 18.
Standard instruction, no objection.
Yeah, any objection? The next one we have 103, standard instruction. Any problem with that?
No, Your Honor.
There was the stipulation that was read to the jury, which is agreed upon facts. How does the court handle that?
Well, I think there's a stipulation. Oh, no, it says it right there. That's right. To be honest, I have not, because the stipulations I've had in the past have been ones that were stipulated in the trial, and so people heard them. I did not send them back to anybody. I did not repeat them. I think they've been referred to. Is there a feeling like because there have been actually more than just that one stipulation. There's some other bits and pieces been stipulated too. What were you thinking?
I just wanted to make sure, I'm not suggesting that it be inserted and that be read again. I think my question was more so how is it being handled if the jury has to see the stipulation again? Will that be maybe brought in court and it will be read to them again? And that's something we can address later, I guess.
Yeah, and that's exactly, I would bring them into court. It would, if we think it's appropriate, we'd read it. I don't know. I'm not making that determination, but if it was going to be done in any way, it would be done that way. It'd be in court on the record then, you're right. We'd probably do the cautionary instruction again too. And I can stumble through it a second time then, so another option. So having said that, well, not even a little bit of a laugh. Anyway, it's been long days, guys. Okay, 170.
Standard instruction, no objection.
I'm going to get rid of the paragraph about escape, flight, concealment.
I don't think 270 applies.
I don't think 270 necessarily applies, but I don't know, what's the state thing? $270 is yeah, I don't believe there was any specific character evidence about the defendant, so well, we move 270. Remember, we throw in the kitchen sink a lot of times here, just to make sure.
No objection to 155.
Objection.
Yeah, that's standard. 155, 275. Actually, what I'm going to do in 275 is, I think that's just the standard 275. I was going to use the instruction we had used. There's a different question, but the instruction we used during the actual trial, which I believe I gave you copies of, correct? Okay.
No objection to swapping that language.
Okay, hold on one moment. Okay, so that will have that different language.
Would this be an area where we incorporate the 275 for both?
Well, that was my next question, is that I would start with the cautionary instruction of other acts for the defendant, and then there would be an instruction for what you're asking is an instruction for Mr. Pedron also.
Correct, yeah.
My issue with that, Your Honor, is that Ms. Dikeman's entitled to the constitutional presumption of innocence, not, and those other acts were stipulated.
I agree with that, but they have to come in for an evidentiary purpose, and only for that evidentiary purpose, and that's exactly why we have 275, because it tells them what evidentiary purpose it is, and it specifically tells them they can't use propensity, and they cannot argue propensity in closings. So the law is the same for both. I would just ask that the same instruction be used for both the permissible purposes that they're suggesting that. I'd actually ask for the propensity-free reasoning instruction that Mr. Bowles added to the instruction. If that's going to be used for the other acts of Ms. Dikeman that the state has offered, I'd ask that the very same instruction be given regarding the other acts of Mr. Pedron.
The purpose that, so it's also identity, I believe.
Well, I think we pleaded motive, opportunity, identity, intent, context, credibility.
All right. This is what I would suggest is maybe work on whatever instruction you think should be for 275. And I can't do that right now for Mr. Pedron. Let me look at it. You know, I think for what I would end up doing, just so I'm just taking like a look at this, is I probably, if I use it, would stick it in before the propensity-free reasoning requirement, because there's the identity was only used for Ms. Dikeman, so now we have the other reasons for Mr. Hedron, which might get actually more complicated to write. Plus, it was a few more incidents. I don't know who wants to write this. I know it's not your request, but
I can submit a short list of the statutory purposes that we submitted Mr. Pedron's evidence for, if the court would, if that would, we can plug those in.
If he sends those to me, I can draft something.
All right, why don't you two talk before we leave? Okay. I just want to put a little. Okay, so assuming we work that out, then we get to 157, which is standard. 148. I do not have improper questions. We probably, oh no, we do have. We have 147 and we have 150. So those are all connected. Any objection to those? No. 158 is the
I would just ask that the court adjust it to past tense of you heard an audio recording, you heard audio recordings and viewed audio-visual recordings, recordings of proper evidence, etc.
Yeah, I would just put you heard and viewed audio-visual recordings. But it's sort of a 158 is interesting. It seems to say, hey, you're about to do this. What if I get rid of that last sentence? Listen carefully. Some parts may be hard to hear.
Fine, Judge.
And but you may consider actions, facial expressions, etc. We are not going to be. I don't believe we provided a transcript for any of them.
No, and the transcriptions that we provided were solely to comply with the local court rule on DAR reporting.
So I'll get rid of that last paragraph. Mr. Toberson, you agree? Okay, then we'll get to 190, that's standard. 195, standard. 200, obviously, do you want to have the paragraph about the defendant testifying?
What is that, 205?
We are at 200. It's at the bottom of 200. It's only added if the defendant testifies. It's bottom of page 25. No, wait, hold it.
Yeah.
Sorry. Page. Wait, I jumped ahead. I apologize. I went over 200. That 200 is the, I was looking at by accident 300. 200 is the expert testimony. Was there conflicting testimony? All that much?
I don't know that it was conflicting, but the jury, I suspect there may be an argument that it was conflicting because of the sequencing of the significance of the toxicology versus the injuries, maybe. I don't know. If Attorney Zachar wants the resolving conflicts of opinion testimony, I'm not going to try.
I don't know that there really was a conflict. I think Dr. Quinn and Dr. Christensen largely agreed with each other.
Yeah, maybe more of a weight question. So I'm going to take that out. I'm going to take that whole paragraph out. Sorry about that. Now we're at 300. 300 is not, that's what I was talking about, the defendant's testimony, paragraph about the defendant.
I usually ask for that to be included.
That'll be included.
No objection to the rest of 300.
Yeah, it's pretty standard. Any objection from the state? Um, 325.
Proper, Your Honor.
I'm just going to put in some of the witnesses. I don't think there was any delinquencies, right? I don't believe so.
It has the language there reflect convicted of a crime.
So wait, evidence has been received that some of the witnesses in this trial have been convicted of a crime?
The second one, I think
Yeah, we're talking about 327.
just one crime.
Oh, okay. I was about to say, you guys jumped ahead on me. All right, then we get to 340. Okay, 160.
Objection.
465, standard. 484 has not been modified yet. I know that Christina was working on it, so we'll have to modify that to reflect the language we have above. And then
I'll make the same request I'm making every trial judge, and that be that consistent with the offered as the first option.
yeah, I follow usually the general jury instructions. Plus, what's confusing in this case is because of how you have the lesser included, so it gets even more confusing. So I think it makes sense. I'm going to leave it as is. And then that just leaves 115, which is the standard jury instruction.
515?
Or, excuse me, yeah, 515. All right, so we'll have to modify those. Work on the other acts from Mr. Pedrin. I think, as I said, we're also going to be working on changing 484, so it's consistent with the verdicts. Partially, the verdicts are being written, so I think that, yeah, I don't think she's got them done yet, but she's going to work on the verdicts and then change that. Anything else we need to do tonight?
I think there was a stipulation with Dr. Henderson's testimony as well. I can draft, or we can draft something relative to that, just so it's part of the record.
Okay.
About the number of medical records reviewed?
Yes.
Oh, yes, that's what it was. That it was only 4 pages, not 1 to 200. Okay, yeah. Did you want me to read that to the jury at some point? I probably need to. Didn't I say it on the record? Yeah.
Oh, yeah, I mean,
Yeah,
if it's been instructed, I guess, like,
yeah, it was.
I mean, I would agree, we stipulated to that, so.
Yeah.
So, you know, if you wanted a written stipulation that we all agree to that back for the record.
That would be good, yes. It's already been said in the record, but that's fine. Okay. Listen, you guys had a long day, could have been longer. I appreciate the fact that we're here at 5 and not continuing much of the trial any farther. Anything further from the state? Anything further, Mr. Zacher?
Judge, just so I understand the court's timing here, if we're able to swing it, we're gonna go in after rebuttal, we'll go into instructions and then closing arguments?
That's correct.
Perfect, thanks.
That's my goal.
Alrighty.
All right. Wait, hold it. You sure you don't need to say where things are in bags or anything like that? Just kidding.
Okay, everyone, and the trial has ended for the day. It ended all the. It didn't end all of a sudden, but the people are done for the day. The trial. See. Pretty good. The metrics. All right, and that was quite fascinating. The way they took the cross. Oh, now from what I can see from the different cross that they did, the two, I don't know if they, I don't know 100% for certain, but I don't know if they really played anything back for her, but they were definitely, showing her different articles and pictures and having her make commentary about it. And he did a very good job with, prosecutor did a very good job with that part. Right. And we have that, and I'm going to look over here for a second. there was some of the Derek testimony that I'll play. If there's any objections, feel free to say it. This is sort of like an after part of playing one of the important witnesses, which was, the father. I believe that's who it is. We're playing it yesterday, and we'll play more of it now. Here.
And Alex won't go to sleep for you.
We watched a movie.
What movie?
I don't remember.
How not?
Because I don't. It was on Disney.
So what happened? What did you get into then?
I don't know. I wasn't awake. We went to bed at 2:30. What makes you think I got up and fucking knew, Derek? When I go to sleep, I'm asleep. I was tired. Are we done now?
Then why weren't you told them that?
I already told you. Because I was advised not to.
Why?
Because it's in my best interest.
But why?
I already did.
Okay, what does that have to do with anything?
They don't need to get it again.
But why though?
Because you know how they work. Quit acting like you don't.
That has nothing to do with it.
It does.
No, it doesn't.
It does.
How?
When you're under a microscope, it has everything to do with it.
So you won't talk to them to help figure out what happened to Alex?
How is me saying that I don't know going to help them?
Because you could tell them what happened.
I did.
This is what we were watching yesterday. This is a recording from the recording of them fighting each other. And this is when Derek was on the stand. We watched this afterwards yesterday, and I was just playing more of it. Right, so this is not from today. This is from, the trial is over for the day. And this was not from anything from earlier. This is from when Derek took the stand, and this is when they were arguing with each other. And some sort of recording, could have been a call. It could have been, one of them took out a video and recorded the other. Okay, understood. So now I'm going to continue playing.
Me repeating it isn't going to fucking help them know anymore. I don't know.
I just don't get how you say he was fine and then he wakes up. He doesn't wake up.
You know what? I don't get it either. I don't get how any of this fucking happened, but it's a fucking nightmare. And I hate waking up every fucking day. And I knew it was a mistake picking you up. Because this is not how I wanted to fucking spend another fucking bad day I had.
So I leave.
So leave. I really don't fucking know.
Derek, when you were at home on February 10th, that evening, did you know that Josie was texting another man?
No.
In that recording, you make a reference to her texting a boyfriend, correct?
Yes.
How did you get information about who she was in contact with that night?
From the police.
Did you know anything about what Josie's plans for the next day were?
No.
Specifically at the time you were home on the 10th of February?
No.
The recording number 2 now.
Where's my son's backpack and shit?
It was right in front of there.
No, it wasn't.
Yes, it fucking was. Right there.
Where? No, that's not where it was, because those white pants weren't there either.
There when you were here. I told you I could have found it. Don't listen.
So there's those blankets and stuff.
The one that baby blanket was in that black thing.
Yep, I got that one. Where's the other one?
The other one you used every night?
No, it was the one you got from the hospital.
I don't know. I haven't found it yet. And I'm not doing this right now. I'm not. Today's not the fucking day.
Okay.
Not everything's about you, Derek.
How is it about me?
Because it's what you want, what you need. It's not always about what you want and need.
You don't think that's important?
Derek, I'm not doing this. Today was not a good fucking day for me. And I would not have came and got you if you were gonna fucking fight with me.
Why are you mad?
Because I told you I'm not doing it and you want to keep doing it. Don't bother hoping.
Derek, what was happening in that video?
I was trying.
Recording.
I was trying to gather my son's belongings so I could have them.
In any of these recordings, did Ms. Dikeman know you were recording her?
No,
Where did you have your phone located?
it was in my jacket pocket.
I'm going to play the last recording now, Derek. Recording number 3.
You just said I'm not supposed to care about Alex.
No, I didn't.
Yeah, you said I need to.
Sitting there obsessing over him isn't gonna do anything.
Obsess over him until I know what the fuck happened to him.
Okay, well guess what? It's not gonna change anything.
Just say the words.
You need to contact the people who are gonna tell you. Stop fucking hounding me because I don't know. Okay? And I'm getting fucking sick of you using me to try and fucking figure out something I don't know.
How don't you know, though?
How would I know, dude?
Because you're the only one here.
I was fucking sleepy.
Truly believe
It was in the fucking night.
Oh, I can't marry you. Now settle down, Cupcake.
Okay.
What problem so big you don't think our fate can fix it, huh? How could you marry a woman so beneath you?
You want me to leave?
Thanks, Snickerdoodle.
I should have known to do this.
Do what?
Start shit.
I'm not starting shit. I asked you about what happened to my
And I
son.
told you a million fucking times, so get the fuck out. Go.
Is that what you want?
It is.
Good, Dicker.
Why?
Because I don't want you here.
Now listen here. We're gonna get married. We're gonna fly home to Fort Worth. I'm introduced to my golfing buddies. And then when I'm on the Senate, You don't be
Right.
outside.
Because I don't.
Beautiful and silent.
For real?
Don't break my heart now. You shouldn't, brother.
I'd rather be alone.
I'm helpless against your fruit-thinking tales.
How did that conversation make you feel, Derek?
Angry?
You feel like you were obsessing over Alex?
Yes.
Did that feel justified?
To obsess over him?
Yeah.
Yes.
Did you miss him a lot?
Yes.
You want to figure out what was going on?
Yes.
Your Honor, I wish I had timed this a little better. But I do need to take some time to fix that exhibit that wouldn't play. If the court wants to take a break for lunch, I will be very short after lunch, Judge, so
Yeah,
Attorney
and
Zucker can get started.
That's fine. I was wondering if we were about to wrap up for the morning. So let's take our lunch break. We can do that a little bit at the very end. Tomorrow, excuse me, this afternoon.
Okay. Something that we need to have addressed with the court before cross-examination of Mr. Pedron.
Okay.
I can raise it if I'm going to go into it.
Yes.
But you never saw Josie do that.
A whole bunch of different microphones to be able to cut it off. Okay, having said that, what was the issue that you needed to talk about?
Judge, just as housekeeping, first of all, I'm going to offer Exhibits 9 and 10, which are the transcripts of the recorded calls from March 2nd of 2023, and then also Exhibits 14. Excuse me, 12, 13, and 14, which are the other recordings that were done by Mr. Pedron. We know that these aren't available to the jury just to make the record whole. So I have those ready for the court. The other thing, Judge, is I anticipate finishing my direct examination pretty quickly here of Mr. Pedron. There are a few issues related to his other acts that I did email defense counsel about on Sunday. I don't know if that's something that they've had time to put thought into, but if we're not in agreement with those things, it may be something that we need to have addressed with the court before cross-examination of Mr. Pedron.
Okay.
I can raise it if I'm going to go into it.
Okay. Okay, first of all, on the issue of the exhibits 9, 10, 12, 13, 14, I assume there's no objection to that, or have you seen those transcripts?
I have, consistent with local court rule and our reporting, no objection.
Okay, they'll be received. They are the recording or the transcript of the actual videos that we do not do in a transcript. In other words, just to explain that on the record. And then on that other issue, if we come to it, let's just take a break, and if we need to address it or not at that point. Does that make sense from the state's perspective?
Absolutely, Judge. Thank you.
Sure. Okay. All right, so we can bring the jury in. Anything else from the state?
No, Your Honor.
From the defense?
No, Your Honor, thank you.
All right, let's bring the jury in. Everybody may be seated. Thank you. Hope your lunch was enjoyable. Just let us know if you need something special, any dietary things, just let us know. We'll try to break up the monotony of those lunches in the future. The other thing is, if you do need a break, I always find the afternoon sometimes starts to lag a little bit for people. Please just raise your hand and we'll take a 5-10 minute break. Having said that, I know that the state needed just to finish up something more with the direct. Go ahead.
Thank you, Judge. Derek, I'm going to play that last video for you now that wasn't able to be played before lunch. Just for the record, this is Exhibit 5. It's part of Exhibit 5. File name is IMG_5528.MOV with a timestamp of February 6, 2022 at 1:48 p.m.
Quit recording. It is a law. The judge already told you this shit.
No, they didn't.
They told Mark he couldn't record you.
He did not. He said
Yes,
stop
he did.
recording exchanges in front of kids. There's no kids
Quit
in here.
recording me.
No.
I'm not doing shit to you. You're instigating and talking shit. You put on a camera and your whole attitude flips.
You're abusive, Derek.
You are.
And you won't stop
What have
screaming
you been
at
sitting
me.
here calling me
You're screaming
over
at me
my
still.
tax money?
You're screaming at me still.
Dude, you're an ignorant fuck, dude. Okay.
Your card's right there.
Two can play that fucking game. But I'm not gonna, because I'm not a fucking child like you. I have shit on you. All the text messages to my buddy asking for fucking Xanax for you. Oh yeah, let's do this.
You mean that you bought and
Come on,
took?
you drug addict.
You mean that you bought and took?
Everybody can drug test me anytime they want. I will never have a pill in my system.
That was how long ago, Derek? Of
Let's
course
do
you
this.
don't now. You took
I
them
never
already.
will.
You're a liar.
Everybody that knows me knows I don't even take Tylenol.
Nice try.
What pills do I take?
Nice try.
What pills?
Nice try.
What pills?
The Xanax you bought. Go through your phone.
Yeah, I don't take pills.
Oh, okay. You just buy them from your
Good.
friend.
We're done.
Good. Leave me alone.
I will.
That's why I have to record you. You won't leave me alone.
Do whatever you want.
Derek, we talked about some instances of physical abuse where you admitted that you had gotten violent with Ms. Dikeman, correct?
Yes.
Have you ever sexually assaulted Ms. Dikeman?
No.
Did you ever make her perform sex acts without her consent?
No.
Did Ms. Dikeman ever threaten to release that May 2022 video of you yelling at Alex in the car to the public?
Not that I know of.
How would the two of you usually communicate when you weren't in person?
When we weren't?
Mm-hmm.
Through text or call sometimes.
Did you text just through your phones, or sometimes would you use other apps?
Just phones or just a phone.
Would you use Facebook sometimes?
Yes.
That was on your phone, though?
Yeah.
In the fall of 2023, was Brantley in your care?
What? When?
In the fall of 2023?
Yeah, I believe so.
And did he start having more conversations to you about what may have happened that previous winter?
Yes.
Not going into the specifics of that, Derek, what did you do with that information?
I had him re-interviewed.
You contacted law enforcement to have that done?
Yeah.
Has today been hard, Derek?
Yes.
As Alex's father, would you agree that you had a responsibility to keep him safe?
Yes.
Looking back, do you feel like you always lived up to that responsibility?
No.
Were there times that you relied on Ms. Dikeman to care for him even when you had concerns about that care?
Yes.
And it was your decision ultimately to leave him in Ms. Dikeman's care when you were arrested on February 10th, correct?
Yes.
When you got home on February 10th, Derek, where exactly was Alex positioned in the house?
He was in her room on the couch. On the far, it was like a love seat with a armrest in the middle, and he would have been on the right side of it.
Did he ever move from the right side of that love seat during the period of time you were home?
No.
Did you physically touch Alex while you were home?
No.
Did at any point you have to clean up his body during that time that you were home?
No.
When you last saw Alex, how did he appear?
He looked like he threw up, so he looked a little sick, but he was alive, well.
Thank you, Derek. Nothing further.
All right. Cross?
Yes, Your Honor. Mr. Pedron, you've given a number of interviews to law enforcement throughout the course of this investigation. Is that correct?
Yes.
You spoke with investigators on February 14th. Is that correct?
Yes.
On February 21st?
I don't know exact dates, but yes.
April 26th?
Yes.
September 8th?
Yes.
You've had a number of phone calls with investigators and attorneys for the state side.
Yes.
I'd like to start by talking about some of what you've told the investigators about Ms. Dikeman in the course of this investigation. You repeatedly told the investigators that you have never seen Josie harm Alex Xavier.
Yes.
You told investigators as soon as the 14th of February that you've never seen Josie hit your kids ever. Is that correct?
Yes.
You told investigators that you've never seen Josie even spank any of the children.
Yes.
You admitted to spanking the children.
Yes.
You admitted to spanking Alex Xavier.
Yes.
But you never saw Josie do that, correct?
Yes.
Now, in fact, one of the things that you told them was that you've never seen Josie behave violently in any manner towards your children. Is that correct?
Yes.
You never noticed any bruises on Alex that you didn't believe belonged there.
No.
You never Alex never told you that any of his bumps or bruises over the years were from Josie.
Not directly.
Well, that's what you told the investigators, right? He never told you that any of the bumps or bruises that he got were from Josie.
Yes.
Your Honor, hearsay.
That is what he said, correct?
Yeah, it's what he
overruled.
Yeah. Okay.
Your Honor, it's what the child said.
What the child didn't say.
Oh, that's correct. Okay. All right. That's correct. It's not you overruled. Go ahead.
Alex never said that to you, correct?
No.
And you told the investigators that none of the children appeared to be afraid of Josie.
I don't know about that.
Do you recall a meeting with investigator Fritz Leinfelder and DCI Special Agent Adam Frederick on September 23rd of 2023?
Yeah.
This was a meeting that happened inside of investigator Leinfelder's truck?
Yes.
And if investigator Leinfelder reported that you had disclosed none of the children appeared to be afraid of Josie, do you have reason to doubt investigator Leinfelder?
No.
And this was after Josie was arrested, correct?
I believe so.
By all appearances, Alex loved Josie.
I don't
Your Honor,
think so.
objection, speculation.
Sustain if you can establish what he observed.
Alex spent a lot of time with Josie.
Yeah.
Josie would read to him.
No.
You're saying that Josie never read to Alex?
No.
You weren't home during the days when Josie was taking care of Alex on many occasions, were you?
Or how would I know?
You've never seen Josie playing with Alex then?
No.
You've never seen Josie interact with Alex at all?
Interact?
And this is the person that you say that you wanted to take care of your son and watch throughout the days. Somebody who never interacted with him at all.
We were in a relationship, so yes.
Josie appeared to love Alex.
Speculation, Your Honor, objection.
No. Sustain.
Alex called her mom.
Yes.
And you repeatedly told the investigators that you did not believe that Josie harmed Alex.
Yes.
In fact, if you would have believed that Josie was harming Alex, you told investigators that you would have taken steps to prevent that, correct?
Yes.
You never experienced Josie denying Alex food, correct?
Not while I was there, no.
Well, that's what you told the investigators, right? You told
I
investigators
can only speak
that...
to them about what I know.
Well, Mr. Pedder, I'm asking you what you told the investigators. Did you tell Investigator Leinfelder that you never experienced Josie denying Alex food?
Yes.
Did you tell Investigator Leinfelder that you never experienced Josie denying Alex water?
Yes.
In fact, there was usually food in the house. Is that fair to say?
Yes.
And Josie kept a cart full of fruits for the kids to be able to eat, apples, oranges, that sort of thing?
I don't know.
You don't recall whether or not there was a cart in the kitchen of your home with fruit accessible to the children for healthy snacks?
I don't recall. I know there was a stand there with canned foods on it.
Do you recall, Mr. Pedrin, if the kids had microwavable dinners if they didn't like what was cooked?
Yes.
Things like corn dogs, correct?
Yes.
Hot Pockets?
Yes.
Chicken nuggets?
Yes.
You yourself have described Alex as a skinny kid, correct?
Yes, he was.
He was somebody who could eat and eat and eat, as I understood it. Is that correct?
I wasn't there all the time.
Need an exhibit more, please.
Exhibit 200?
May I approach, Your Honor?
Go ahead.
Better, I'm showing what's been marked as Exhibit 200. Does that look familiar to you?
Yes.
That appears to be a cart with fruits in it that was accessible in the kitchen. Is that correct?
Yes.
Offer Exhibit 200.
Objection.
Be received.
Move to publish.
Any objection? Could be published?
You're saying that you had forgotten that there was healthy snacks like fruit available to the children when Josie was living in the house. Is that correct?
I didn't say I forgot.
You agree that snacks like that were generally available?
Yes.
You never once implied to the investigators your belief that Alex was being starved or denied food.
Correct.
And in fact, the investigators asked you whether or not you observed Josie putting hot sauce on Alex's food to punish him. Is that correct?
False.
They did not ask you that?
Not to me.
And if Investigator Leinfelder were to report this, or reported that you said that you never saw that happen, you're saying that you didn't
I
have a
never
conversation?
seen that happen.
You've never seen it happen?
Right.
All right. None of the other kids said the same to you about Josie putting hot sauce on Alex's food?
Hearsay.
Sustain.
Yeah, I'm asking, did any child ever tell you that?
Objection.
I'm gonna sustain it.
Josie was the primary caretaker for these kids.
Yes.
She was the one doing most of the cooking.
No.
Who was doing most of the cooking, Mr. Pedron?
I would cook when I get home. She would make pizzas and stuff like that.
Who was doing lunches?
Well, she would.
Who was doing breakfast?
She would.
And who was doing the laundry, Mr. Pedron?
Josie.
Josie was the one going to the parent-teacher conferences for the children. Is that correct?
Correct.
She was the one that would contact the school when there were issues with any of the children. Is that correct?
Correct.
And in your view, she was the one responsible for taking the kids to and from school in the mornings. Is that correct?
Correct.
Mr. Pedron, we have your time card. It appears that you oftentimes started at Shipshape between 8:30 or 9 o'clock. Does that sound accurate?
Yes.
And do you agree that Hinton is about a 15-minute drive away from Shipshape Car Wash?
Yes.
You aware of what time Hinton allows parents to drop students off in the morning?
No.
At 7:45. You weren't aware of that?
Objection.
Let me rephrase. Were you aware, Mr. Pedron, that Hinton allows parents to drop students off as early as 7:45 a.m.?
Objection.
No.
Hearsay.
Sustain.
Mr. Pedron, you had every ability to drop the children off to school on your way to work and still make it to work by 8:30 or 9.
No.
You're saying that the drive from Hinton to Shipshape was so long that you would have been late for work if you had dropped the children off at 7:45?
I'm saying I didn't have a car to get them there.
Is it your testimony, sir, that you were walking back and forth from your home to Shipshape?
I have.
Every single day?
No, not every single day. I had a motorcycle.
Okay, so you had a motorcycle.
Yeah.
You said that you had a car in your garage as well, correct?
Yep.
And you've had a car that you've been driving around for quite some time. Is that correct?
Not then.
Not then? So, Mr. Pedron, the vehicle that was used belonged to Ted Colkind, as I understand it. Is that correct?
I don't recall.
You don't recall who the vehicle that Josie was using belonged to?
Objection. Vague. The time period here.
Sustain.
Did Josie ever own her own vehicle?
Yes.
What vehicle was that?
She owned a couple of them.
What vehicles were those?
She had a minivan, and I got her a Suburban.
Mr. Pedron, do you take any responsibility for, or did you take any responsibility for getting the children to or from school when you were living with Josie?
I didn't have a vehicle.
You didn't use Josie's vehicle?
Not really.
And did you take any responsibility for not communicating with the school about your children?
No.
Mr. Pedron, when Josie would ask you to help and take the kids to school, you would get upset and angry with her. Is that correct?
Wrong.
Your Honor, I'm going to object to this as hearsay.
It's a statement affecting the listener, and I think it's an exception.
Wait, say it again? The effect on the listener is what you're saying?
Asking if
Did he? No, this is hearsay. Sustain.
Pedron, did you ever tell Josie that, or did you ever get angry at Josie for, because she asked you to take the kids to school?
No.
How many times did you take the kids to school?
I didn't have a vehicle.
So, 0?
Correct.
Mr. Pedron, Josie would be the one who took care of the kids when they weren't feeling well.
Correct.
She would take the kids to the doctor when they needed to be seen.
Correct.
She was the one who was taking Alex to the dentist when he needed to be seen.
I don't recall that.
You recall that Alex needed basic fillings and dental caps?
Yes.
And Josie was the one who arranged to have the insurance transferred to your Badger Care. Is that correct?
She took care of that.
And Josie was the one that took her to the dentist, is that correct?
I don't recall her taking him to the dentist.
Well, clearly the dental work got done, correct?
I don't recall her taking him to the dentist.
Clearly you didn't take Alex to the dentist, correct?
Correct.
And clearly Alex didn't take himself to the dentist, correct?
Correct.
We infer then that Josie likely took Alex to the dentist.
I still don't recall her taking him.
You recall Alex losing one of his dental crowns shortly after he had that work done?
Yes.
And your reaction was to try shoving the cap back on his tooth, is that correct?
No.
You're saying that you didn't say this to the investigators who interviewed you on February 21st of 2023.
I don't recall.
Transcript, please.
No, not a question. I think they're waiting for a notepad.
Just
one or no? Yes,
If-
okay.
okay.
You have space?
Okay. Yeah, if you need a notepad, just ask him. Anybody need one right away? Okay, we'll get you a new one pretty quick here.
Chris?
Yeah.
Transcript of interview with Derek Hedren, February 2023 is marked as 202.
202. All right, so the transcript is 202, just so you know.
Yes. All right. Mr. Pedro, I'm going to come back to that. Your testimony on your direct examination was that, okay, my apologies, I had the wrong one. So, may I approach, Your Honor?
Yeah, go ahead.
Pedro, I'm showing you Exhibit 202. This is a transcript that's been prepared of your interview with the investigators. Why don't you read those first few lines to yourself?
Yep.
That appeared to be a comment that you made to investigators on February 21st of 2023 about Alex's dental crown falling off.
Appears to be.
And you appear to have said that, quote, and he was, right after we had the caps on, he was chewing a piece of gum one time, gum or taffy, it was either gum or taffy, but it yanked it out. So I was like, man, you can't be doing that. So I tried to put it back on, but I'm not a dentist. So we took him back in and had it recapped, end quote. Is that correct?
Correct.
You tried putting the cap back on, Alex, correct?
Correct.
And Josie took him to the dentist to get it refit, correct?
Correct.
Mr. Pedron, I gotta ask you, I was standing right next to you. Have you been drinking today?
No.
Not at all?
None.
You don't smell like alcohol right now?
No.
You're saying that you haven't used any drugs or alcohol at all today?
No.
Your testimony on direct examination was that Josie treated Alex, quote, significantly different. Is that correct?
Correct.
Do you recall what your answer was in response to that question when you were interviewed back on February 21st?
I do not.
Can I get the transcript back, please? Yeah, that's for a while. All right. Do you recall the investigators asking you, quote, before you said something about Josie being sometimes harsher to Alex than the other kids, talk to me a little bit about that. How was she harsher to Alex than the other kids?
And Your Honor, I'm just going to ask for a pause quick. If Attorney Zacher can let me know the citation from where he's pulling this, so I can follow along, I would appreciate it.
Page 20, line 8888. You there? Okay. Your response, Mr. Pedrin, was, it just seemed like so the kids would get like phones, like play on phones, scroll YouTube, fucking shit like that, and it just seemed like she wouldn't really let him do that type of shit, and I never understood why. So I'd sit there and let him watch YouTube or whatever, and then she'd flip out that I'm letting him watch YouTube, like, and then she'd turn it into all of the kids, like we're not supposed to be watching that. Like, I don't know, man, it was shit like that. Do you recall giving that response?
Correct.
So your concern back on February 21st, 10 days after Alex died, about Josie treating him differently, was that he didn't get as much screen time as the other kids.
It's not just that.
That's the only thing that you said in response to that question, right, Mr. Pedrin?
That's what it says.
You said nothing about your concern that Josie might be beating Alex, correct?
Correct.
You said nothing about your concern that Josie might be harming Alex, correct?
Correct.
You said nothing that Josie might be making Alex feel unsafe. Is that correct?
Correct.
Your concern was that he didn't get to watch enough YouTube.
That wasn't my concern.
That's what you said, right?
It says.
Now, Mr. Pedrin, I want to understand your testimony here on direct. Did you make the claim that Josie was restricting Jenna from being able to contact Alex?
Yes.
And as I understood your testimony on direct, you said that Josie stopped taking phone calls on her cell phone from Jenna. Is that correct?
False.
You recall a family court hearing in which Josie specifically asked to not have Jenna call her cell phone.
Her.
This is Tang.
Mr. Pedrin, Jen.
I'm going to ask that that be struck from the record.
Be struck from the record to be disregarded. Go ahead.
Mr. Pedrin, how was Jenna contacting you?
She would call my phone.
She would call your phone. So Josie was reaching over and turning your phone off when Jenna would call.
No.
Josie was taking the phone from your hands and preventing the children from talking to Jenna.
No.
Josie was able to take the cell phone away from you so that Jenna couldn't call.
No.
Your testimony is that there was a rule that the kids had to talk to Jenna outside when Jenna called.
Correct.
Asked. So, in your testimony, as I understood it, was that ended because Josie would come out and terminate the phone calls with Jenna.
She would get frustrated and start a big fight.
She would get frustrated and start a big fight when Alex is outside talking to Jenna.
Correct.
And at that point, did you stop accepting phone calls from Jenna?
Somehow a no contact got placed.
Did you stop accepting phone calls from Jenna?
I stopped receiving phone calls.
Jenna had your phone number, did she not?
Correct.
And Jenna was able to call you from the prison that she was in Missouri. Is that correct?
We had a no contact.
Mr. Pedrin, you're aware that we have dozens of hours of recorded phone calls between you and Jenna from that prison.
Up until we had a no contact place.
In fact, Mr. Pedrin, the person that made the decision to withhold Alex from Jenna's side of the family was you.
Correct.
You told that to multiple people that was your decision.
Correct.
You did it because you didn't like how Jenna's family interacted with Alex.
False.
You refused to let Jenna's family have visits with Alex.
Correct.
And you said that you did it for your own reasons, right?
Correct.
You said that you didn't like how they would take Alex places you didn't want him to go.
Correct.
In fact, you told your own daughter, Aubrey, that Josie had nothing to do with keeping Alex away from her side of the family.
I don't recall that.
You recall having that conversation with Aubrey?
No.
You don't recall your daughter saying that Josie was the reason she couldn't see Alex?
Objection, hearsay.
Back then, the listener, Judge.
Overruled, offered for that purpose only.
You don't recall that?
Do not.
We'll get to it in a second. In fact, Mr. Pedron, when Alex's family wanted to see him, at one point, at least, you demanded $300 from his grandmother, Cheryl Anderson.
No.
You're saying
that was for something else. It wasn't she wasn't paying me to see him.
You said that you told her that she wouldn't be allowed to see Alex until she got the $300
Objection,
that you.
hearsay.
But it's his remarks, Judge.
If it's his remark, it's not a hearsay. Go ahead.
You told her that she wouldn't be allowed to see Alex until she gave you $300 for a COVID tax credit.
That was money that was owed to me.
So you said that to her?
It wasn't to see Alex.
Mr. Pedron, did you or did you not?
I don't recall that.
You don't recall that?
No.
So almost immediately before you found out that Alex had died, you spoke with your cousin, Michael Pedron.
I did.
You did that on a recorded phone call from the La Crosse County Jail.
Correct.
And you told him that you made the decision to withhold Alex from Jenna's family.
Objection, hearsay. Still an out-of-court statement, Your Honor, offered for the truth of the matter. It doesn't matter if it's this witness statement or not.
Ask it in a different question. If he denies it, you can ask him, cross-examine him on it. Go ahead.
Mr. Pedron, did you say that?
I don't recall.
All right. With listening to a recording of that call, refresh your recollection. Would it refresh your recollection to hear that recording, Mr. Pedron?
Well, if I heard it.
All right. Your Honor, I'd like to, we'll be marking a flash drive and inserting some of these electronic exhibits on it. If we can get an exhibit marked, please.
Your Honor, I believe we have to refresh recollection outside the presence of the jury.
That's correct. Do you have a transcript?
Not of this one, Judge.
Okay. Is it being offered for to refresh his recollection?
It is.
Okay. All right. Can we? All right. Ladies and gentlemen, the process of this is a little bit complicated, so what I have to do is have you step out for a few minutes and then you come back in. Thank you. All right, everybody be seated, go ahead.
Judge, where are we at, 202? 203. We'll have a flash drive marked as 203. We'll put the recording on there. Judge,
Yeah, we're in the middle of testimony. Why is he being talked to?
Judge, there was a concern brought up about him drinking alcohol, so I wanted an independent witness to be able to check that issue out, because that was an accusation. It was not discussion of any testimony, not discussion of anything that took place, but that accusation was made in the record.
All right.
In front of the jury.
You can be tested at a later time if you want to check it out. Doing it in the middle of testimony is not acceptable, just so you know. Sorry about that, but there's misunderstanding. Please don't talk to him. That's considered coaching, by the way. We'll go on.
We're going to be starting this recording from 4 minutes and 13 seconds to approximately 4 minutes and 23 seconds. If we can get the audio up in the courtroom, please.
Is this a flash drive with multiple?
It will be. We have so many video exhibits, Judge, that we're just going to put them on the flash drive as we go along.
Is this the flash drive with all those videos then on it?
No, this will be the first video on that flash drive.
Okay, so there's other videos on it. So let's say
No, there are no videos on the flash drive yet. We're just going to put them on as we go along.
all right. So you have essentially I think it's 203.
Yeah.
Is a flash drive that as videos are used, you're going to add them to 203. I'm just trying to figure out what the mechanism
Yes,
is there.
there's so many there's so many audio and video files, Judge, that it fills up an external hard drive. So we're just have to put them on the flash drives as we go along.
You have any objection to that process?
I don't, Judge. I hesitate because I think it gets messy for the record, as
Yeah, well,
we need to be very careful about using file names. I'd also ask Attorney Zacher to give me the date and time of the call before he plays it, just so I can put that on my list as well.
All right, so we'll say this is going to be on flash 203, which is a flash drive exhibit or video 1 or whatever, and give us what video 1 is.
About that comment.
Objection, hearsay.
All right, go back to if you want to go ahead and ask your question.
All right. So, Mr. Pedrin, is your memory now refreshed?
Yes.
And did you, in fact, tell your cousin, Mike Pedrin, on February 11th that you weren't allowing Alex to to go to Jenna's family because they're assholes?
Yes.
Now, at no point during the investigation, up until your testimony here today, did you tell any law enforcement officer that Josie was trying to keep Alex from his family?
Correct.
And in fact, Josie would sometimes prompt you, as we saw in these videos, and say that Jenna is going to be involved in Alex's life again.
False.
Josie didn't tell you in those videos that we just saw this morning that when Jenna got out, you should go be with her.
Yes.
Now, after a while, Jenna's family started calling in welfare checks.
I don't know who was calling them.
Well, it wasn't you, right?
Obviously.
Wasn't Josie, right?
Correct.
Your impression was that it was Jenna's family.
I don't know who it was.
It got to the point where it was fairly frequent. Is that fair to say?
I wouldn't say fairly frequent.
Did you tell law enforcement that it was your understanding that Raven Holzer, Jenna's cousin, was calling in some of these welfare checks?
Few of them.
Now, I want to clear up another claim here and ask you, Mr. Pedrin, did you ever take Alex to a dog's birthday party?
A dog's birthday party?
A dog's birthday party.
No, that's insane.
So that never happened, correct?
No.
And you never told anyone that Alex was going to a dog's birthday party, correct?
A dog's?
Yes.
No.
All right. Now, do you recall having that conversation with members of Jenna's family when they confronted you?
No.
You don't recall being confronted by Cheryl Anderson about that comment?
Objection, hearsay.
Only on the effective.
Yeah.
Oh, if this is being offered for the effective listener, I'll allow it. Go ahead.
Yes. You don't recall that conversation?
I do not.
And Mr. Pedrin, just so we clarify this crystal clear, there was never a dog's birthday party, correct?
No. Who has a birthday party for a dog?
I agree. All right. Now, you're saying one person that you did say that you saw hurt Alex was Josie's son, Major.
I have.
In fact, you described Major as, quote, pretty violent to the police. Is that correct?
He was.
Said that he likes to hit people with things. Is that correct?
He does.
Likes to throw things like monster trucks and other toys.
Yeah, he's a kid.
In fact, you described a bruise to Alex's eye as originating from him, Major, throwing a monster truck at Alex.
That is what I was told it was from.
And what you described Major to law enforcement as on the 21st anyways was, quote, pretty fucking mean to him, end quote, meaning Alex.
Yes.
And Major would play rough with the kids sometimes.
Correct.
Boys will play rough at times, won't they?
Yes.
And sometimes you saw a Major hurt the other kids.
Yes.
You saw a Major kick the other kids.
Yes.
You saw a Major hit the other kids.
Objection, Your Honor, vague. I think we need a time period here for proposing this as another, or an alternative for injuries we're discussing.
Okay. Do you have a time period?
In the time frame that Major lived with you, Josie, and the rest of the children, you've seen him hit the other kids.
I think we're vague, again, Your Honor, that doesn't.
Judge, can we approach?
No, I'm going to let you ask the questions. Overruled. Go ahead.
You've seen him hit the other kids.
Correct.
You've seen Major injure the other kids with how rough he was playing.
Could.
And in fact, Major was in counseling to address these behaviors.
Objection, Your Honor.
Sustain.
Strike that question.
Be struck. Please disregard.
All right. Mr. Pedrin, you described the boys playing with each other as wrestling. Is that correct?
Correct.
Riding their bikes down a big hill.
Correct.
Jumping off of furniture.
I don't know about that.
Now, Mr. Pedrin, I want to talk about the femur injury. So your impression, at least what you told law enforcement, was that Alex Xavier injured his femur by falling down the stairway. Was that correct?
Yes, that is what I was told.
And you did, in fact, have two separate sets of stairways in that home on OS. Is that correct?
Correct. He fell down the basement ones is what I was told.
SB 204.
Exhibit 204, stairway, picture of stairway.
Pedrin, is this the stairway leading to the basement of the home on OS?
Yes.
Offer 204.
No objection.
Received.
No objection to publication either.
Received and can be published.
Swap to the Elmo, thanks.
Yeah. Oh, yeah. Okay.
All right, so I'm looking at what appears to be a top-down view of the staircase. Do you see that?
Yes.
Looks like the stairs are wooden planks.
Yes.
And looks like there's actually some laundry or clothing on the stairs as well. Is that correct?
Yes.
I don't see any safety railings on those stairs. Was there ever a safety railing there?
Not that I know of.
And it looks like there's an open section where there's no wall at all on the latter half of the staircase. Is that correct?
Correct.
And at the bottom is a concrete floor. Is that correct?
Correct.
And that was the condition of the staircase and the floor as you knew it in January, of 2023.
Correct.
Do you agree with me, Mr. Pedrin, that these stairs aren't particularly kid-safe?
Correct.
And what your impression of was that Alex fell down the stairs, correct?
Correct.
And in fact, Alex told you as much.
Objection, hearsay.
Sustain.
You obviously would have confronted Josie if you had been told that she had injured his leg, correct?
Correct.
And in your own private communications with Josie, you've acknowledged that the fall down the stairs was an accident. That's what you told her.
That is what I was told by her.
Well, and that's what you told her as well, correct?
I guess.
You also knew that Alex had slipped on the ice at some point before this stair fall. Is that correct?
That is what I got told.
Now, after Alex injured his leg, Josie was concerned about the fact that he wasn't getting better.
I don't know about that.
She expressed to you that she wanted to take Alex into a doctor.
Objection, hearsay.
Sustain.
Did you ever have a discussion about taking Alex into the doctor?
I'm the one that told her to take him. To take him.
You told her to take Alex into the doctor.
Yes.
Mr. Pedron, you didn't take Alex into the doctor yourself, correct?
Correct.
You didn't take Alex into the doctor for days. Is that correct?
Correct.
You didn't call 911 and ask for an ambulance, did you?
I wasn't home.
At any point after Alex injured his legs?
Correct.
You didn't call and arrange a ride to take Alex into the hospital. Is that correct?
Correct.
Your testimony is that you told Josie to take him to the doctor and you figured she would just take care of it.
Correct. I was working.
Now, Mr. Pedron, I want to talk about this birthday party afterwards. You recall going to this birthday party in Sparta at the home of Laura Lee Raines?
I do.
And you and Laura Lee Raines are now married. Is that correct?
Correct.
She was out there in the hallway with you earlier, correct?
No.
Laura Lee Raines wasn't sitting right next to you in the hallway just a few minutes before you came back in here and took the stand.
Correct.
And anybody who happened to see that?
Oh, she is out there. I said she is out there.
Okay.
Correct.
All right. So, Mr. Pedron, going to this party, Alex wasn't walking very well, was he?
No.
In fact, Josie had to carry him into the van.
I don't recall all that.
And if your concern was with getting Alex to the doctor, you had every opportunity at that moment to say, we're not going to the party, we're going to go to the doctor's office with Alex.
Correct.
You wanted to go to the party instead.
She wanted to. It was her friend.
Now, Mr. Pedron, do you recall, did you tell anybody at the party, sir, that that Alex was fine?
I don't recall that.
Are you saying that you don't recall or that you didn't say it at all?
I'm saying I don't recall saying that.
Do you recall saying that Alex was fine to your now wife, Laura Lee Raines?
I don't.
And if she were to testify that that's exactly what you told her, would that be the truth?
Objection, speculation, or call, Judge.
Sustained.
Did you tell Laura Lee Raines, Mr. Pedron, that you wanted to stay at the party and get drunk?
I don't recall.
Did you tell, you're saying that you don't recall whether or not you told Laura Lee Raines, your wife, whether or not you wanted to stay at the party and get drunk rather than bring Alex to the hospital?
Correct.
You're aware, Mr. Pedron, that that's what Ms. Raines has told law enforcement?
Objection, hearsay.
Sustained.
Now, you did get drunk at that party, right?
Say it again.
You got drunk at that party.
Yeah.
And in the course of getting drunk, you went outside and there was Josie's daughter, Jalen, on a toy rocking horse.
Correct.
And you threw Jalen off of that rocking horse.
False.
And anybody who witnessed that and said that you did exactly that would then be a liar. Is that
Yes.
your testimony? All of them.
I didn't throw her off no rocking chair.
And when Jalen came back in crying, hurt as a result of this, the other men at the party confronted you, correct?
Correct.
And they beat you up in the street, correct?
No.
There wasn't a fight?
I wouldn't call it a fight.
What would you call it?
I was sitting in the van and one of them hit me.
So you got hit by two men, is what you testified to on your direct. Is that correct?
I don't remember how many. There was a bunch of people out there.
You don't remember that night because of time, alcohol consumption, or something else?
Because of time and alcohol consumption. I remember that night. I don't remember how many people hit me.
Do you remember that your behavior reached the point where you were told to leave the party?
Yes, because of all of that.
And your impression at the time was that it was Josie who set you up to get beaten up.
Yes.
In fact, you were screaming and yelling at Josie that it was her fault that you had gotten assaulted.
I don't recall.
You don't recall that because of alcohol or because of time or something else, Mr. Pedron?
Time.
And during that, and after you were kicked out of the party, your testimony here in direct was that you walked most of the way back home.
I did.
Mr. Pedron, the way to Ms. Raines' home in Sparta, do you take exit 25 or 27?
I don't walk we don't take the interstate.
You agree that the difference or the distance between Sparta and Onalaska is approximately 20 miles.
I didn't walk the whole way. I got picked up closer to in between Sparta and Rockland by Josie.
Mr. Pedron, you're saying that Josie drove so slowly that you were able to walk most of the
She didn't leave at the same time I did.
You're saying that she didn't leave at the same time as you did?
Correct.
And anybody who saw that would be a liar?
Correct.
Mr. Pedron, your testimony then is that she picked you up around Rockland, correct?
In between Sparta and Rockland. Probably 2 miles out, a mile, 2 miles outside of Sparta on Highway 16.
And at that point, you were concerned that you could be arrested for consuming alcohol.
No, for walking down the highway.
You were walking down Highway 16 and you thought that would get you arrested?
I was drinking.
So you're concerned about being arrested for drinking alcohol?
No. I wasn't on bond or anything at that time, I don't think.
Mr. Pedron, you were on bond for the strangulation, domestic battery, and domestic disorderly conduct case that you...
Well then, yeah, I would be concerned about being arrested for consuming alcohol.
Okay, we got it. So you were concerned that if the police contacted you walking down the highway, that you might be arrested for violating your bond and consuming alcohol.
Correct.
And once you got into the car, you became violent with Josie.
I don't recall.
Meaning that you could become violent with Josie in a vehicle with your children and not recall it?
Correct.
Do you not recall it?
I recall we're arguing. I didn't get violent with her.
You're saying that you didn't punch Josie?
No.
You're saying that you didn't put your hand around her throat?
No.
You're saying that that never happened, Mr. Pedron?
Correct.
And why is it then, sir, that Ms. Dikeman had to stop and Google the Sparta Police Department during this exchange?
Because we were arguing and she called the cops on me all the time. She knew I was on bond and drinking.
Well, she didn't call the cops that time, did she?
I don't recall.
And
I didn't go to jail.
She didn't call the cops when she stopped again and Googled the Onalaska Police Department.
I don't recall that.
Is it your testimony, Mr. Pedron, that Liliana Suarez, if she were to testify that she saw you personally throw Jalen off of the toy rocking horse, would be lying?
Your Honor,
yes.
objection, it's hearsay. He's also asking to comment on another witness's testimony.
Sustain.
Now,
Your Honor, I'm going to move to strike that question as well.
Move to strike the question and the answer. Disregard, please.
So let's talk about the hospital once Josie took Alex into urgent care. She made that decision to take Alex into urgent care, correct?
Correct. She drove him there.
Well, you didn't come along at all when she brought him to urgent care.
I was at work.
So that's a no?
Correct.
And Josie was the one who decided that Alex needed to be seen.
Correct.
When Josie got home from that car ride from Sparta, do you admit or deny physically assaulting her on that night?
Deny.
Do you admit or deny physically assaulting Josie at any point, Mr. Pedron?
No.
You don't admit or deny?
No, I admit that I have before.
Now, the next day, you said that you literally ran from ShipShape over to urgent care once you heard that Alex was being seen by a doctor. Is that correct?
Correct.
That mischaracterizes the testimony. It wasn't the day after the party that he testified to. It was 2 days after.
Yeah, well, let's touch on that. I'll withdraw the question.
Okay.
All right. So, Mr. Pedron, there was a day in between the birthday party and the when Alex went into the hospital, correct?
Correct.
You did not take Alex into the hospital or to see a physician in that day between the two. Is that correct?
Correct.
Now, your testimony on direct was that when you learned that Alex was at urgent care, as soon as you heard that, you dropped what you were doing and you ran from ShipShape over to urgent care.
Correct.
You aware what time Alex was admitted to urgent care on that day?
I am not.
Approximately 2:30 in the afternoon. Is that correct?
Correct.
You aware what time you clocked out from ShipShape on that day?
No.
Can I get that exhibit, please?
Number 7. got it, okay.
Publishing Exhibit 7, Your Honor. It's been previously.
Yep.
All right, so Mr. Pedron, we're talking about the 16th, correct?
Correct.
Can you see what time you clocked out on the 16th?
4:04.
4:04 p.m. You testified that it was your decision to transfer Alex to Gunderson.
Yes.
And you knew that Alex needed a higher level of care at that point, is that correct?
Correct.
You knew that CPS was involved at this point, is that correct?
Correct.
Because CPS was there when you arrived at urgent care.
Correct.
And Josie was the one who wanted some continuity of care to take Alex to Mayo in Rochester.
Objection, hearsay.
He testified to that. And direct. I'll allow him to ask the question. Go ahead.
Okay. Josie was the one who wanted continuity of care to take him to Mayo Clinic in Rochester.
I don't know why she wanted to take him to Rochester.
One of the best hospitals in the world, right, Mr. Pedron?
I don't.
Now, Josie left the hospital at some point at Gunderson, is that correct?
Correct.
And she came back with McDonald's for Alex, is that correct?
I don't recall.
You don't recall Josie coming back with food for the kids?
I don't recall.
Mr. Pedron, at Gunderson, the two of you had an argument, is that correct?
Correct.
You were upset with the fact that Child Protective Services were involved.
False.
Completely false, Mr. Pedron?
Yes.
Did you tell Josie that to lie to Child Protective Services about your abuse of her?
No.
Did you lie to Child Protective Services about your abuse of Josie?
No.
Did you tell Child Protective Services, sir, that you never strangled or battered Josie?
No.
Objection, I believe what was said to Child Protection Services was just strangled, not battered. I know that conversation.
Okay. Want to re-ask?
Did you deny that to Child Protective Services that you had strangled Ms. Dikeman?
Correct.
But you, in fact, had strangled Ms. Dikeman.
What time?
Well, you
I
strangled
have
her
before.
You strangled her at many times, right, Mr. Pedron?
Correct.
And you lied and told them that you've never done that to her, correct?
Correct.
Objective vagueness, I don't know what incident they're talking about.
I don't know that we really need
Overruled.
to specify. Yeah.
Overruled. You're talking about statements made to the Child Protective Services. Go ahead.
So, at the hospital, Josie, at a period of time, locked herself in the bathroom in Alex's room. Is that correct?
I don't recall.
You don't recall having Josie in the bathroom for an extended period of time?
No.
Do you recall Mr. Pedron communicating with Josie via Facebook Messenger during that time frame?
I don't recall that.
Do you recall Ms. Dikeman crying during that incident?
No.
Do you recall Ms. Dikeman or telling Ms. Dikeman that it was her fault that Alex had been injured?
Correct.
Because in your mind, she should have been watching Alex more carefully and he wouldn't have been hurt. Is that correct?
Correct.
That it was her responsibility to watch all of the children at all times to ensure that they don't get hurt.
When I'm not there, that's correct.
And Josie was upset at that. Is that correct?
Could be.
She cried.
I don't recall that.
Is it fair to assume, Mr. Pedron, that both of you were concerned about the hospital assuming that this was an act of child abuse?
No.
You weren't concerned with that at all?
I was not.
And is there any reason then, Mr. Pedron, for you to lie to Child Protective Services about your own abusive past?
My abusive past is public record.
I'm asking whether or not there was any rationale for you to lie to Child Protective Services if you were unconcerned with what they thought.
No.
So you just lied to them.
That's what it says.
Now, Ms. Dikeman confronted you about the fact that you were abusive. at the hospital?
I was not abusive at the hospital. They have cameras everywhere.
Mr. Pedron, at the hospital, Ms. Dikeman confronted you about the fact that you were abusive to her.
I don't recall that.
You don't recall anything about this argument. Is that your testimony?
Yes.
Now, Ms. Dikeman texted you about the concern that you had lied to Child Protective Services. Is that correct?
I don't recall that.
You don't recall her sending you a text message saying that...
Objection, hearsay.
Sustained.
Did Ms. Dikeman ever confront you about the fact that you're never going to change unless you acknowledge that you have a problem and you need to admit what you did?
Objection, hearsay.
Sustained.
So, Mr. Pedron, I want to talk about Alex after the hospital. Josie was concerned about Alex and his well-being after he was released.
I don't think so.
You don't think so? She told you repeatedly that you needed to focus.
Hearsay.
Sustained.
Back on the listener, Judge.
Okay. So there's not being an offer for the truth of the matter, but only the effect on the listener?
Yes.
Okay, go ahead.
What's the effect on the listener, Judge? I don't know what the relevance of it is.
The relevance that she...
What was he going to do next?
Yeah.
What? All right.
I'm confused. Attorney Zacher, explain. I'm sorry, that was...
What's the effect on the listener?
The effect on the listener is that Mr. Pedron says that she wasn't concerned. I have evidence that contradicts that.
Then he's using it for the truth of the matter asserted.
Right.
And it's a prior inconsistent statement if he says that that wasn't the case. His responses to Ms. Dikeman's are prior inconsistent statements.
All right. Overruled then. Go ahead.
If that's what he's going to offer, I'd like to see that, Judge. Exhibit 205.
Pedron, did Josie express concern about the fact that Alex was not being safe and walking around at night on his broken leg?
Correct.
And I'm showing you what's been marked as Exhibit 205. Is that a Facebook exchange that you had with Josie on January 19th?
What was the question?
You recall that Facebook exchange?
I don't recall it.
And Mr. Pedron, do you agree that the author of the two parties in this exchange are Josie Marie and Derek Pedron?
Correct.
Josie Marie would be Josie Dikeman.
Correct.
Derek Pedron would be you.
Correct.
And you're saying that you don't recall this exchange at all?
No, I don't.
Judge, pursuant to the stipulation, this document's authentic. It's a Facebook record. I'd offer it and move to admit.
Any objection?
If Attorney Zacher could tell me what the relevant response of Mr. Pedron is?
That he denied Ms. Dikeman was concerned about Alex's well-being after being released from the
Which
hospital.
message, Attorney Zacher?
Well, all of them, but...
I thought it was his response.
You want to see him?
Because we're doing effect on listener.
Okay. So this was being omitted for prior inconsistent statement by Mr. Pedrin.
Yes.
And the fact that he was saying, so I'm going to overrule the objection. You can go ahead and.
Move to publish.
You can publish. Go ahead. It was received and you can publish.
So her statement is being offered as to show his prior inconsistent statement? I'm sorry, Judge, I'm just trying to understand.
He's acting as if he doesn't know what she said to him. So it's not the statement, it's what his knowledge was.
Thank you, Judge.
All right. So we've also stipulated, Your Honor, that converting UTC to Central Standard Time would be a subtraction of 6 hours in January of 2023. So we're talking about, rather than 8:38, we're talking about 2:38 p.m. on that day. Can we agree on that? Okay. So, Mr. Pedrin, Josie expressed her concern to you that she didn't want Alex to fall in that position. Is that correct?
Correct.
And she expressed to you that she was concerned about the fact that Alex was trying to get up without a parent there to help him. Is that correct?
Correct.
She was concerned about the fact that if he doesn't follow the doctor's orders, his leg might get worse and he would need an operation.
He would have.
She was concerned about that.
Correct.
And you were concerned as well that Alex shouldn't be getting up alone on his own after that injury. Is that correct?
Correct.
Josie's concern here was that Alex was trying to sneak. Is that correct?
Sneak what?
Said that he got into the car wax light and was playing with things on the shelf at 3 a.m. Is that correct?
Correct.
Said that.
Wait, just to pause for a second.
Sure.
Okay. The cameras cannot be on Mr. Pedrin. If I have to repeat this again, I will exclude you from the media box. We know that for a fact that they showed him. Sorry, ladies and gentlemen, we have to control the media and what they do. Go ahead.
So she said that Alex has got to know to follow the rules to do what's best for him, correct?
Correct.
And she expressed her concern that he's not being safe, which is going to fall back on CPS.
Correct.
Do you agree, Mr. Pedrin, that that's Ms. Dikeman expressing some concern with Alex's condition and his safety?
Correct.
Mr. Pedrin, almost immediately after Alex was released from the hospital, you went back to drinking and using drugs.
I don't do drugs.
Let's start with drinking. You went back to drinking. Is that correct?
Correct.
And you're denying that you do any sort of drugs.
Correct.
And did I hear your testimony correctly on your direct, Mr. Pedrin, that you said that alcohol used to be a problem for you?
Correct.
You're saying that it's not currently a problem.
No.
You don't drink at all?
I drink. Not as much.
And you're saying that drug use has never been a problem?
No.
You're denying ever using drugs, Mr. Pedrin?
I smoked weed.
Anything else?
No.
You deny telling Jenna Love that you used ecstasy?
When I was a teenager?
Do you deny telling her that?
No.
Do you deny telling Jenna Love that you used cocaine?
When I was a teenager?
Those are other drugs, right, Mr. Pedrin?
Correct.
Now, we're going to talk about Xanax in a bit, but Josie confronted you the day after Alex was released and said that you weren't in a condition.
Objection, hearsay.
I'm sorry, I was writing
Sure.
something else.
Let me rephrase this. At some point on January 19th of 2023, did you get into an argument with Josie about where you would be taking Alex?
I don't recall that.
And did Josie, at some point, did Josie express, let me ask, Were you drinking during that period of time?
I don't recall.
Were you using drugs during that period of time?
No.
And Mr. Pedron, Josie confronted you about the fact that you were trying to take Alex someplace that she didn't believe was safe.
Objection, hearsay.
Sustained.
Did you try taking Alex outside of the home that day?
He's my son. I can take him.
You can take him wherever you want, right?
Correct.
And did you try taking him someplace after his leg was broken under circumstances that might not be safe?
I don't recall that.
Did you take Alex someplace where let me back up. Were you drinking before taking Alex to the place that you were taking him on the 19th?
Your Honor, objective vagueness. Where was he taking him?
I'll back up here, Judge. Did you try to take Alex outside of the house on the 19th?
I don't recall.
And do you recall whether or not you would have been drinking or using drugs on the 19th?
I don't do drugs.
How about drinking, Mr. Pedron?
I don't recall if I was or not.
And Mr. Pedron, your claim here is that you're better now and you're not drinking significantly?
Correct.
Have you not been in alcohol-related trouble very recently?
Objection. Relevance, Judge. Violates the other acts ruling.
Ladies and gentlemen, I'm going to have you step out for a bit. It'll be at least 15 minutes. We'll take a little bit afternoon break. Thank you. Okay, just one thing I just want to put one thing on the record quickly so I understand what I just did a minute ago. My understanding was that we're monitoring the various channels that are live streaming, and we realized Channel 8 was live streaming Mr. Pedron. Dawned on me that I should ask Mr. Tobertson, did you say it was okay for them to do that? Or?
No, in fact, I told him the opposite. I told him that, Your Honor, that we identified him as a victim. I told them who all the victims are moving forward, him, the children, Miss Love, and specifically not to show their faces or testimony. The one thing that I didn't say to them, because I actually didn't talk to Mr. Pedron about it during the break, but was about the videos. And I said that he has constitutional rights, and I said I also, as a representative of the state, don't know, I'm not taking a position on it. It would be his ability to object or not object.
Okay.
So that's the conversation I had with him is very clear.
Just so you know, we've been trying to preserve that victim right issue best I can. I will talk to the media afterwards just to make sure everything is clear. Going back to the issue, this is the issue of the more recent event, which I've excluded as another act, the event with not Ms. Love.
I think we can just refer to it as like the November 2025 Act, Judge.
Yeah, the November 2025 Act. Thank you. That will be the best way to refer to it. Go ahead, Mr. Zacher, where were you intending to ask?
Judge, the testimony on direct is inconsistent with the facts that we have, that he no longer has a substance abuse problem, no longer has an alcohol problem. There's objective evidence that in November of 2025, he was arrested for domestic battery and blew a 187 PBT. I also intend to elicit testimony on the fact that he's been appearing at the home of one of his other children, intoxicated, asking to take the kids, very recently.
Counsel?
Judge, I think he was asked, about a very specific event previously, and I believe Attorney Zacher said something about it being alcohol-related trouble very recently, or I think that's the issue, is we're being vague with this. So when he's denying that, that's the issue. the question was, does he currently have a drinking problem? And he said, no, we're dealing with an event from 6 months ago. So I think we're skirting that other acts ruling in a way that we could probably do without if the question was a little bit more clear instead of using terms like very recently, which can obviously mean different things to different people.
Yeah, I agree. You can use the actual dates of the events or months of the year.
But is he allowed to ask about an alcohol-related issue in November of 2025, Judge? I mean, how is that relevant here? Mr. Pedron's not saying he's not drinking anymore. He's saying currently, right now, he doesn't have a drinking problem.
Okay.
So I think we're fishing for a way to get around that ruling.
The answer was he doesn't have a drinking problem. What does that mean? And the reality is that if drinking, and the way I look at it is that if substance use or either alcohol or other drugs create an event which potentially involves the police, it's gone from just being a simple occasional drink to becoming a problem. So I think that's a valid way to look at it. To act like there's no issues of alcohol that's happened since this event would be misleading to the jury. I don't want to get into the details. I agree. I have no desire to get into the details. But I think it's a legitimate question to make it more specific. What the court's going to allow us this is, was there an incident where the police were involved that you were drinking, and you can give that date. And if the answer is no, then that answer opens a huge door. So.
Can you just make sure we're instructing Mr. Pedron on that, Judge?
What that means, Mr. Pedron, is if you're asked about that specific event in November, I don't want to get into the details, but I am required that if you know, what you know, of course, is that you were, yes, and the police were involved, did have alcohol in your system. If you answer that in the affirmative, then we don't get into any other details. Does that make sense?
Right.
Okay. Just want to make sure. Is that?
I understand, Your Honor.
And
Okay.
Judge, I guess I'm also concerned Attorney Zacher brought up another event recently that he intends to cross-examine him about with alcohol use. I just don't want to get into the same problem.
Yeah, no, it's a different person, right?
Different person.
Right. Are you going to ask about that too?
That would be my intention, just to ask if he appeared intoxicated to take his son, and if he answers yes, I will offer no more impeachment. If he answers no, then it would be my intent to impeach.
Okay.
By bringing in the other person?
Yes.
This is not noticed as other acts, Judge.
I didn't know that Mr. Pedron was going to testify that he no longer has an alcohol problem.
Can I ask the detail? Who is it that this supposedly happened with?
I will share it with the court if we can do it by sidebar, and maybe not in the open media here.
Okay. All right.
Like that, Your Honor?
Well, you have to share that with both the state. Why don't you come forward? I'll allow you to ask the question.
Can we be specific about dates and times, though, Judge? I'm sorry.
The question will be a specific date and time when you ask it. I understand why you're holding off. And then if we need to take a break at a later time, so you have some opportunity, we'll take that break at a later time.
Thank you, Your
Where
Honor.
we're going right now, I'm not sure the cross is going to be done before we're done. Anyway, so let's bring the jury back in. Actually, I gave them 15 minutes. What time did I break?
That's a 1:45, Judge.
What?
1:45. Restart at 1:45.
Okay, let's restart at 1:45. Everybody needs a break anyway.
Thank you, Your Honor.
Step down.
What it was.
Andy.
Where do we bring him in? Ready to go.
I think he was going to give us a date and time.
April 5th.
April 5th of what?
April 5th of this year.
Okay. All right, let's bring the jury in then. Everybody may be seated. All right, continue with your questions then.
Mr. Pedrin, on November 11th of 2025, did you have an interaction with members of the La Crosse Police Department?
Yes.
And were you arrested on that day?
Yes.
Were you administered a preliminary breath test at the point of your arrest?
Yes.
And was that preliminary breath test a .187?
I don't know what it was.
You agree that you were drunk?
Yes.
Mr. Pedrin, on April 5th of this year, Easter Sunday, did you travel to the home of Misty Craig and her mother, Wanda Craig?
Yes.
And were you in fact intoxicated?
No.
And if they were to testify that you were too intoxicated to take the...
Objection, Your Honor.
I'll withdraw the question.
Okay.
Were you too intoxicated to take your son on that day?
I wasn't taking him.
Were you too intoxicated? Were you turned away from the home at that point?
No.
Did Wanda tell you to leave?
Objection, Your Honor.
Sustain.
You didn't stay, correct?
What's that?
You didn't stay there, correct?
Correct. I don't live there.
I want to go back to the previous exhibit here. Talk a little bit about some of the last one I had.
205.
Mr. Pedrin, one of the things that was concerning about Alex was that he would get up and sneak around at night. Do you agree with that?
Yes.
He would get into things at times?
Yes.
Ice cream sandwiches, I believe.
I don't recall what it was.
Candy?
It's what kids do.
Red Bull?
I don't know.
And it's something that you were keeping an eye on Alex for when he was up at night.
I was not.
You weren't keeping an eye on him?
I wasn't keeping an eye on him to stay out of snacks.
Mr. Pedrin, during a large portion of the time that before Alex's death, you were sleeping out in the living room area predominantly, is that correct?
Correct.
And certainly something, if Alex had gotten up in the night and was sneaking around, that's something that you would take note of, correct?
If I heard him.
And there's a reason that you wouldn't hear him?
Well, I'm sleeping.
Now, during that time frame, the two you talked, or you came up with a plan to make sure that Alex wasn't up walking around on his broken leg. Is that correct?
Correct.
You do agree that you're violent towards women?
Can be.
Yes or no?
Yes.
And you do agree that you've been physically violent with Josie many times?
Yes.
You've hit her?
Yes.
You have strangled her?
Yes.
You have slammed her head against walls or floors?
Yes.
You have left her bruised and injured?
Yes.
You have sometimes beat her to the point that she was unable to get off the floor and walk?
Yes.
And you would grab Josie hard by her arm to drag her around?
I don't recall that.
You don't recall doing that, or you deny doing that?
I don't recall doing that.
Do you recall doing that to anybody, Mr. Pedron?
Grabbing their arm?
Grabbing somebody by the arm and dragging them to where you want them to be.
Your Honor, I'm going to object to vagueness here. I don't know how it's relevant as well.
Overruled on relevancy and vagueness. I don't know if there's a specific time.
Well, at any point, do you deny doing that, Mr. Pedron?
Yeah, all right, it's vague.
Okay, overruled. Go ahead. These are general questions anyway. Go ahead.
No.
And that would leave bruises on the person that you're grabbing.
Can.
Now, Mr. Pedron, you were arrested many times because of your abuse of Josie.
Correct.
And you've been criminally prosecuted several times because of that abuse.
Correct.
You've been frequently told not to have contact with Josie at home.
Correct.
And is it fair to say that you've practically never complied with no contact restrictions?
Correct.
Josie even had to take out a restraining order against you at one point, correct?
Objection.
I don't recall that.
Sustain.
Your Honor, I'm going to move to strike both the question and the answer, please.
Okay. The question and the answer is struck. Please disregard. Go ahead.
You frequently violated no contact conditions of criminal bond.
Correct.
And when you get out of jail, frequently you would return directly home to where Josie was.
Sometimes.
Now, Mr. Pedron, you're aware that Josie was recording you at times when you were angry at her.
Correct.
And she did that quite frequently, is that correct?
Correct.
She did it when you became violent with her, is that correct?
Correct.
She did it when you became violent with the kids.
I wasn't violent with the kids.
You're saying that you were never once violent with the children?
Not in that manner.
No. You're aware that there were any number of videos that were recovered here, Mr. Pedron, correct?
Correct.
And the videos that when Josie would videotape you, you would get upset over the fact that she was recording you. Is that correct?
Correct.
And you didn't believe that any of these videos would ever be played in court. Is that correct?
I didn't think about it.
Well, you told her that her videos would be inadmissible in court. Is that correct?
I don't recall.
You told her that she'll look dumb as shit if she showed her videos of you abusing her to the court.
Correct.
And you told her that because you knew that some of these videos portrayed you in a very bad light.
Sure.
Do you think that you were portrayed positively in the videos that we've seen thus far?
No.
And these videos captured you physically assaulting Josie.
Correct.
These videos captured you physically assaulting children.
I didn't see that one.
You didn't see that one, Mr. Pedron. I'm asking you, do these videos capture you physically assaulting children?
The ones that I've seen today, no.
The ones that you've seen. I'm asking you, Mr. Pedron, have you ever been recorded physically assaulting a child?
Not that I'm aware of.
Not that you're aware of, meaning that it could have happened and you wouldn't have been aware of the fact that you were physically assaulting a child on video?
I don't harm children.
Now, Mr. Pedron, would you agree that when you're angry, you have very little ability to control yourself?
Correct.
And you would beat Josie regardless of the fact that she had a camera on you?
I don't recall that.
You don't recall the videos that we saw just this morning, Mr. Pedron?
Yeah, but I was arguing.
Was it arguing when you punched her?
I didn't punch her.
Was it arguing when you slapped her across the face?
I didn't slap her in the face.
Was it arguing when you came charging towards her and took the phone out of her hand?
In an argument.
So that was just arguing. That wasn't real abuse.
You can call it abuse.
Mr. Pedron, you would do that, you would engage in that sort of behavior in front of your children.
Correct.
You would engage in front of that sort of behavior in front of Alex.
Correct.
In fact, we saw Alex in one of those videos where you were attacking Josie.
Correct.
And that happened fairly frequently.
Correct.
Now, Mr. Pedron, I want to talk to you about, I want to go over some of these videos again. I'm not going to show all of them, but I do want to clarify some of your testimony on them. So I've got it labeled independently here. This is dark. And Madam Clerk, are we plugged into the surround system? Audio jack, Emily.
That's my charge.
Judge, perhaps after it's played, we can identify what state's exhibit number it was.
Oh,
Put that on the record. It's probably the easiest way to do it.
All right, that'd be,
Concerned if we don't do that, Judge, and he's cross-examined on a video, the record's not gonna.
do you have the same reference, like the 4-digit number reference?
No, it's, we labeled it completely different in our file, so, but we should be able to come to some consensus on which video it is once we, oh, we do, okay.
So why don't we do this, is why don't you use a reference to the 4 digits, 4-digit number, and then we'll match those 4 digits to the exhibit, sub-exhibit, I think it's exhibit 5, and then it has, we have a number of numbers, so.
Let's be 1361, Your Honor.
And what day and time?
1361.
There's that one, I thought there was one exhibit that shows all the numbers. And
November 22nd, 2021, Your Honor.
we do have that exhibit if you want to use that. It's the referential point.
February. Yeah, February 22nd.
That's not an option.
Oh, why don't we get just the opening frame and we can identify it? All right, that looks familiar.
We'll figure it out.
Yeah, we'll play from the start here. Ms. Sanchez, just give us 5 seconds.
Everything I'm asking you.
The judge is not going to ask me anything if I tell you I'm done.
He's gonna ask you why.
I'm going to turn the light back on. I don't think you have to kill all the lights. You can keep the lights on back there. It doesn't have to go completely dark.
Judge, we played this one. We can figure out the issue later. I don't want to take any more time.
Okay, that's okay. So, go ahead. Keep
All right.
those lights on back there.
So, Mr. Penner, we're going to replay this and we're going to ask you some questions about it, okay? And move to publish. It's previously admitted as State's Exhibit 5 with, we will find the file name.
Fuck, you can't be an adult and communicate.
At midnight when I'm asking you to get out when I'm trying to go to
during
sleep?
the day.
You're being crazy,
During
Derek.
the day, it's because kids are around.
Derek,
the kids are sleeping.
get out.
Now it's because what? What is the
want
reason
you to
now?
get out.
What is the reason
I
now?
want you to
that
get
you
out.
can't be an adult?
I don't need to be an adult, Derek.
Oh, you don't need to be an
Being
adult.
an adult right now
Oh, I'm
is
glad
going
you
to
have that
sleep.
on video.
Being
I'm
an adult.
glad you have that on video.
You know what? That is not what I meant.
Yeah, that is
Being an
what
adult
you
is
meant.
going to sleep.
That is what you meant. Good thing I have it on video. So even if you delete yours, I have it.
I'm not gonna.
You don't have to be an adult.
You're being.
That is what you just said.
Get the fuck out.
Right?
You're
Right?
being psycho. Your kids
I'm
are
being
sleeping.
psycho
Yes.
Because I'm trying to figure out.
Do you not look at yourself, Derek?
Do
This
you
is
not
a
look
bad
at
environment.
yourself?
I told you we're done. I'm not in love with you anymore. Get out.
Why is it only your side that
We're
gets
done.
told?
I don't have to stay with you.
Wait till a judge is involved.
What? A judge
My
is gonna
side
tell me I
will
have
get
to stay
told.
with you?
Nope.
Then what?
You don't have
What
to
is
stay
a
with
judge gonna tell me, Derek?
That you need to be a fucking adult.
And tell me
and
what?
talk.
What is a judge gonna tell me? What? That you get to hit me?
Fuck you, stupid
You just
ass
hit
fuck.
me.
I
And
hit you?
You just hit
Where,
me.
you stupid fuck?
Over a video.
Where
you
did
just
I hit
me.
you? Where did I hit you?
You just hit
Where?
me in the fucking video,
Where?
Derek. In
Where?
the face.
In the face?
Yes, in the face. Get the fuck out.
You just got hit in the face.
Get out.
You just got hit in
Get
the
out.
face?
Now. Or I'm calling the cops.
Call him.
Get
You're
out.
lying.
Get out.
Call him.
Get out.
Call him. Call him.
You are nuts, dude. You really need help. Me and the kids are out. We're out. You need help.
Do I?
You
Or do
really are
you?
psycho over me.
You think everybody
You need help.
is. You think everybody
You
psycho
are. You just
but
fucking hit me
you.
because I don't want to be with you because I don't want to talk to you.
Where's your marks?
Because I don't want to talk to you.
Where's your
You just
marks?
come flinging at me.
You said I hit you in
It
the
is
face.
midnight. I came
You're
in here to go to
supposedly
sleep.
recording.
My kids are sleeping.
Where's your marks?
You came in here, Derek. I am
Where
trying to go
is
to
your
sleep.
marks?
Go.
Where's your
It is
marks?
on video. Go.
Well, then they'll know I didn't hit you in the face.
Derek, go.
Where's your marks?
Derek, please get out.
Yeah, I'm sending all this to your
Derek, please get out.
and Mark.
Please get out.
Fuck you, man. I can't stand your ass. I'm helping Mark.
I don't care.
I'm helping Mark.
Yeah, me too, by getting rid of you.
Yeah.
And I'm helping Major by getting rid of you.
And I'm helping Major by getting rid of you.
He loves me.
Because you are the fucking crazy one.
He doesn't
Ever
like
since you got hit with that goddamn bat, you are a fucking nutcase.
Ever since I got with
Ever
you.
since. No, not. Ever since you got hit with that bat, you think you are like entitled to. I don't fucking know what you think you're entitled
I
to.
hope you know these are your last words to me.
And?
I'll be sending them back to yourself.
And what?
That's it.
I'll be sending everything I have to your lawyer.
I don't
To
care.
save Major from you.
Good. I'll send these to your... whatever.
To my what?
Jenna.
What?
When she gets out.
What?
To fight for...
Well, you have
for
no
kids.
contact with her, so that's kind of against the law,
Can
isn't
you get
it?
out, please?
Isn't it?
Just get out.
That's against the law.
Get out, please.
You can't send shit
I've
to
asked
her
you to
at
get
all.
out multiple times, and you're fucking...
Pounds,
I feel like
pounds.
you're
You can't
imprisoning me.
even speak.
Because you're
Because
scaring
you're drunk.
me. You're scaring me,
Or
Derek.
you're drunk.
You've beat me before. It's called entrapment.
I'm not beating
Get
you.
out. You just tried to
It's all
slap
on
me.
video.
Get out.
I didn't touch you.
Get out. I feel like I'm being trapped. Go. Get out.
There you go with your manipulating.
Derek, you're fucking trapping me in a room. I came in here to get away from you.
And I came in here to communicate about
And I
my
said
life.
no. When a woman says
Of course
no,
you
it means no. Go.
course
It
you
is midnight. Go away from me.
But the kids are sleeping.
I don't
right?
care. You don't own me. Go
Do you
away.
know how many videos that say
Derek, go away.
that
You
me
don't
and
own
you
me.
can
I said
talk
go.
when the kids are in
I
bed,
don't
right?
care. You do not own me.
Right.
Go away. Get away from me.
I have you proved as a
Get
liar.
away from me.
Right there.
Get away from me, please.
Liar.
Please get
You're a
away.
liar.
You're entrapping me, and
Am
I
I?
don't feel comfortable.
Am I?
Please go. I
Am
want to
I
get out of this
entrapping
room.
you?
I don't feel comfortable.
Oh, you're a
Please go.
fucking liar.
Please
you want
go.
to get out of
I
the
don't
room?
feel
you're
comfortable.
fucking
You're
locking
pushing me
yourself
away. Now you're pushing my phone. Go. Ow, you just hit me, dude.
Thank you. Do we have a file number on this one?
We're gonna have to look later.
Well, we'll look later and put it on the record. We can get the lights, please. Mr. Pedron, do you agree that you were completely out of control in that video?
Yes.
Do you agree that you behaved like that with Josie frequently?
Yep.
Do you agree that you behaved like that in front of your children frequently?
Used to.
Used to? Do you agree that, well, what you said on your direct was that you don't remember what you were fighting about, is that correct?
I don't recall what we were fighting about.
Is that due to alcohol or something else?
Time.
Time. You can hear the sound of the slap when you connect with Josie, right, Mr. Pedron?
Sure.
You heard that, right?
Yeah.
And your testimony on direct was that you never hit her.
I don't think I hit her then.
You don't think you hit her.
I think I hit her phone.
You just said that you didn't even remember what this argument was about.
I don't remember what the argument was about.
Is it your testimony that you didn't hit her at the end of the video?
I don't think I hit her at the end either. The door did.
The door hit her.
Yeah, I threw the door open.
You threw the door open, and that's what hit Ms. Dikeman.
Yes.
Despite the fact that she's crying out loud that you just hit her.
Yes.
She sounds scared, doesn't she?
You can say that.
You can say that? Do you disagree that she sounded scared in that video?
Do I disagree?
Yeah.
No.
Do you disagree that this sort of behavior is scary for your children?
Yes.
You do disagree?
No.
And Mr. Pedron, in this video, you said that you believed it happened in Brownsville. Is that correct?
It did.
Did you live in Brownsville in February of 2021?
I believe so.
Now, Mr. Pedron, at the end there, you talk about Josie being entitled. Do you recall that?
Yes.
And that was after she was struck by a baseball bat, correct?
Correct.
And you believe that was an example of Josie being entitled, correct?
I don't understand that question.
You thought she was being entitled in that video before you struck her?
Not in that video, just overall.
Well, that's what you said to her, right? That she was entitled?
Right.
And Mr. Pedron, Josie told you that she screams out loud that you just hit me because I didn't want to be with you. Did you hear that?
Correct.
Is that what the argument was about? She was trying to leave you?
I don't recall what the argument was about.
Now, Mr. Pedron, when you're in that state, do you agree that you have absolutely no ability to control your violence?
Correct.
And when Josie says that she wants to work with Jenna, that's referring to Jenna Love, correct?
Correct, but she can't and couldn't.
Because of a no contact order?
Yes, and she didn't talk to Jenna or want to be around Jenna.
Well, you told her that she couldn't reach out to Jenna to provide evidence of your abuse because Josie had a no contact order with her. Is that what your response was?
Correct.
In fact, Josie suggests in that video that she would help Jenna get custody of Alex once she was out.
I didn't hear that part.
To help Jenna fight for Alex.
The kids.
The kids? Yep, including Alex?
Correct.
Mr. Pedron, I am going to turn to another video here, and then we'll switch gears a little bit. But if we can get this will be State's Exhibit 59261.
Okay.
9269.
9269, excuse me.
Can you repeat the date and time?
Your dad. Yeah, excuse me, Your Honor. It's November 12th of 2022. Please, please. Thank you.
Dad, tonight.
You should not be involving him, and you are putting too
Oh,
much into his
really?
emotions.
Really?
He's sitting in a closet crying because you won't leave him alone and you're harassing him. You're abusive.
Why is my kid scared to
You know
move?
what? Maybe you can stay in the closet and cry.
Why is my kid scared to move in this house?
Don't look like it.
No, because I'm here now.
That's not what he does. He sits there and...
Why is he scared to come down and piss?
You guys...
Because you yell.
talk together. No, that ain't why.
Yeah, you yell at him.
Actually, I have that recorded. He likes to see himself. Everything's recorded with Alex.
But you're not able to record mine.
Yeah, I am. I do it to
Not
protect myself.
yours. So no, you're not. It's like Mark wasn't able to record you?
Yeah, he is. Only one person can record. They didn't like the video in court, so how about you learn your facts and get the fuck away from my son?
Wasn't he court ordered to not record you?
Okay, I'm not
Pretty sure
court
you
ordered
was.
to not record.
Not yet.
Here you go, baby. Now go away from this evil man. I mean, boy.
You feel good about yourself?
You have my son sitting in a closet.
I don't have him sitting.
Yeah, he's scared. He's sad because of you.
Why wouldn't he be? I'd be scared if I lived with you too.
That's not why he's upset. Don't put words in his mouth.
He's gonna blame me.
It is you. You had no right
when
to
I've
bring him
done
in the
nothing.
middle. No right. Grant, get out of here now. You don't need to be hiding in the closet next. He already has Alex talking to people who aren't there. You giving him drugs too, just like Aubrey?
Never gave my kid drugs.
Well, that's not what I read.
Then you read wrong.
Yeah, we'll see what the hospital says.
Don't care. We'll see what the hospital says about you and Ted.
Good. You wanna go?
Where's your fentanyl patch?
You're fucking high, dude.
Am
Are
I?
you that delusional?
I wish I was.
What are you on? What the fuck are you on?
What am
You
I
gotta
on?
abuse kids. You gotta abuse
Real
women.
life. That's what
You
I'm.
gotta abuse everybody.
How is this me?
You're gonna get away from my
How is
children.
this me?
Get the fuck away from my children.
How is this not you?
Dude, you're a psycho.
How? How?
Alex wants to leave. Don't you want to leave? Do you want to go to the hotel? See? He wants to go.
To get away from you.
So go. No, he wants to see his sister, right? You want to go see your sister?
That you won't allow here.
Do you? See? He wants to
And
go.
Aubrey wanted to come here.
Can you go?
And you won't allow her to.
You won't let Brian come stay the night with me.
An adult
We're
kid.
single. It doesn't matter.
Are you stupid?
We are over and done. Look at that anger. That shows the abuse I get daily. Go.
Why haven't I seen my kid in months? Because you don't allow her here.
Father.
Really?
You
But
want
she
to
wanted to come
when
here.
we're fighting like this so another kid can be hiding in a closet? No thanks. Why will you answer your child? You're just going to neglect him?
You think you're so fucking
You pass
perfect
out on
and
the floor
innocent.
for him. What else are you going to not do for him? He's calling your name.
I hear him.
You just don't care. You're too busy looking at me like a psychopath. You already threatened to kill me today. That video was sent to Laura Lee.
Don't care.
Well, good. She knows to call the police.
Good. Clean that truck your fucking self.
I already planned on it.
Good.
You fucking passed out drunk, dude. You're nothing.
You're fucking nothing.
Okay. Well,
What are you?
I'm everything to someone.
Me too.
What the fuck, dude? You're going. I'm done. I can't.
Thank you. Keep the lights, please. Thank you. So, Mr. Pedron, you recall saying that during your direct examination?
Yes.
Do you agree that you were completely out of control in that video as well?
I won't say out of control.
That wasn't out of control, sir?
I was talking.
You were talking until the point that you hit Josie.
Yeah, but I wasn't out of control.
What does out of control look like, Mr. Pedron, if that is in control?
If we were standing there talking,
Well, Mr. Pedron, the video starts with you screaming something about your dad. You're talking to Major at that point, correct?
I don't believe so.
Well, you're not talking about yourself in the third person, right?
I don't recall what that argument was about or why Major was in the closet even.
Well, there'd be no reason for you to refer to your dad unless you're talking to one of the children with a different father, correct?
Correct.
And the only child there in that video with a different father was Major, correct?
Correct.
And Major is cowering inside of that closet, is that correct?
Correct.
He appears to be crying, is that correct?
Correct.
Because of how you were behaving, is that correct?
I don't recall why he was crying.
Now,
It'd be by the way I was behaving, but I don't recall why.
at that point in time, you and Josie were broken up.
I don't recall that either.
You recall that? She's talking about inviting another man over to the house.
She did that when we were together.
And you stayed with her in that?
I lived there.
Mr. Pedron, you weren't sleeping in the same bedroom with Josie at that point in time, correct?
I wasn't sleeping in the same bedroom with her for like the last 2 years of our relationship.
And your testimony is, to you, that doesn't mean that you were broken up?
We weren't.
So you were still together at that point, is what you're saying?
I believe so.
Do you believe that Josie believes so?
I don't know what Josie
Objection, Your
was.
Honor. Objection.
Sustain.
Now, in that video, Josie references the fact that you had threatened to kill her on that day. Is that correct?
Correct.
That's something that you've threatened her with before. Is that correct?
Possibly.
Possibly? Mean to say, Mr. Pedron, that you possibly threatened to kill people and then forget about it?
I don't recall if I had said it more than once to her.
She sent that threat to Laura Lee Raines. Is that correct?
That's what she said.
And you didn't care at all, did you?
No.
Now, at the end of this video, we get a glimpse of Alex, right?
Correct.
Looks scared, doesn't he?
Looks sad.
You didn't think that your behavior was scaring Alex?
My son always wanted to be by me. He was by me when I was acting like that or not.
Is that what that looked like to you, Mr. Pedron, that he enjoyed being around that behavior?
No, but he was sitting there waiting for me.
Alex isn't even looking up in that video, is he?
No.
At the end of that video, Mr. Pedron, you pushed Josie, correct?
Correct.
Then you hit her, correct?
Correct.
And your explanation on direct examination was that Josie instigated you to that point. Is that correct?
Correct.
So she deserved to get hit.
She didn't deserve it, but she instigates.
And that's your excuse for continuing to beat, strangle, and abuse her?
No.
Now, this video was taken on November 12th of 2022, so almost exactly 3 months before Alex died. That's how you were behaving.
Correct.
Do you believe that this was a healthy thing for Alex to see?
It wasn't healthy for anybody.
But it's something that they saw time and time again, isn't it, Mr. Pedron?
Correct.
I want to talk about March 19th of 2019. You were arrested on that day as well.
I don't recall.
Well, that was the day that you beat and strangled Josie so badly that you gave her brain damage.
If that's what you say.
You don't recall that day, Mr. Pedron?
I recall.
And your testimony was that you put Josie's head through a wall several times. Is that correct?
Correct.
Do you admit or deny that you also struck her several times?
I admit.
You admit or deny that you also strangled her?
I admit it.
And do you admit or deny that you took Josie's head and banged it against the hard tiles of the bathroom floor until she passed out?
Wasn't the floor, it was the wall.
And do you admit or deny, Mr. Pedron, that Josie lost control of her bladder as you were doing this to her?
I don't recall that.
The person who called 911 was Laura Lee Raines, correct?
Correct.
Ms. Raines was in the home at that point, correct?
Correct.
And she was the one that called to get help for Josie at that point.
Correct.
Now, you ran from the scene, is that correct?
Correct.
And you initially lied to the police and told them that it was self-defense.
I don't recall that.
It wasn't self-defense, was it, Mr. Pedron?
No.
And eventually you were arrested and you were criminally charged, is that correct?
Correct.
Strangulation, correct?
Correct.
Domestic battery?
Correct.
Domestic disorderly conduct?
Correct.
And you blamed it on your alcohol use, is that correct?
That's why that happened?
Now, your explanation was that you didn't notice much of a change in Josie after that incident. Did I hear that correctly?
Correct.
You didn't notice that Josie was struggling with basic tasks like driving?
No.
You didn't notice that Josie was struggling with basic tasks like being able to hold your daughter, Araya.
No,
You didn't notice that Josie began having seizures.
she did not.
You're saying that, Mr. Penryn, you've admitted to Josie that you gave her brain damage during that incident.
I didn't say I gave her brain damage.
You're saying that you didn't admit to Josie in a Facebook message exchange that
I gave her a TBI.
And what does a TBI stand for, Mr. Pedron?
You can get a concussion as a TBI.
TBI stands for traumatic brain injury, does it not?
Yes, it does.
And in your opinion, that's not consistent with brain damage?
Like I said, though, a concussion can be considered a TBI.
And Mr. Pedron, you're aware that Josie receives full Social Security disability as a result of that incident?
Correct.
You deny that you did that damage to her where she receives full disability?
I don't believe she got her disability until after she got hit with the bat as well.
Exhibit 206.
Mr. Pedron, on February 6th of 2023, so 5 days before Alex died, do you recall having a Facebook exchange with Josie about how her brain damage occurred?
Your Honor, I'm going to object to this being hearsay. And I think it's inconsistent. The point Attorney Zacher is trying to make doesn't align with the dates of this conversation.
Can we approach? So, Mr. Pedron, I'm going to show you. Showing what's been marked as Exhibit 206, sir. Do you recognize this Facebook exchange?
Yes.
I'm only going to ask you about two of the entries here, Mr. Pedron. So, Josie, on February 6th, right, I guess it would be actually February 5th if we subtract 6 hours for UTC. So, about 9:44 p.m. says to you, yeah, and my brain is the brain of an old person's because it is damaged. And your response at the end is, it's okay, I get it, I did it. Did you send that Facebook message?
It's right there.
Yes?
Yes.
Will be received.
I want to move on and talk about Brownsville, Minnesota. Were you arrested on July 13th of 2020 by the Houston County, Minnesota Sheriff's Department for felony domestic assault?
I was.
And who was the victim of that felony domestic assault, Mr. Pedron?
There was no assault.
You're saying that Ms. Dikeman was not a victim.
She was why I got arrested, but there was no assault.
Mr. Pedron, you're aware that are you aware that officers noted injuries to Ms. Dikeman when they responded?
I wasn't even at the house when They got called. My
And
mother is the one that called the police. I was with my mother.
Mr. Pedron, your son Alex Xavier was there.
Yes, I know.
And
we left because me and her were arguing.
And you broke
So
up
I left and went to calm down, and then I got a call from her saying she was destroying my shit, so we went there.
Mr. Pedron, you left after you hit Ms. Dikeman.
I did not.
You didn't do this in front of Alex Xavier?
I did not hit her that day.
You didn't destroy her cell phone that day?
Did not.
You deny that entirely?
Yes.
And if the police officers who arrested you that day were to report otherwise?
Objection hearsay.
You deny any accounting from police officers who arrested you that they observed injuries consistent with being physically assaulted on Ms.
Objection
Dikeman?
hearsay.
Sustained.
Ms. Dikeman injured herself then that day?
I didn't do nothing to her that day.
The bruises just appeared on her face?
Objection speculation.
Sustained.
Let's move forward to July 13th of 2020 in Brownsville, Minnesota. Or excuse me, August 26th. Do you agree that you would have Ms. Dikeman lie to the police about your presence in the home when you were about to be arrested?
I don't recall that.
Do you agree that you would instruct Ms. Dikeman to lie to police about your abuse?
I don't recall that.
Now, do you recall the police, again, the Houston County, Minnesota Sheriff's Department, coming to your home on August 26th of 2020?
I don't recall that either.
You're telling me that you don't recall at all the fact that the Sheriff's Department showed up about 6 weeks after your last arrest?
Correct.
And Mr. Pedron, is it your testimony that you did or you did not strike Ms. Dikeman on that day?
I don't recall.
You don't recall? Is it your testimony that you did or did not instruct Ms. Dikeman that she needed to tell the police that your children had accidentally dialed 911 when they arrived?
I did not.
You deny that in the entirety?
Yes.
Now, going back to some of what we watched on that video, leading up to that incident on November 12th of 2022, you were supposed to be watching Alex at that point. Is that correct?
We were both there.
Well, you were the only adult with Alex at that point, right?
In Brownsville?
November 12th of 2022 on the house on OS.
No.
You weren't the only adult with Alex for a period of time that day?
I don't recall.
Do you recall whether or not Josie took the remaining children to a rummage sale that day?
I don't recall.
Mr. Pedron, do you recall do you recall having a plan to take Alex to a hotel to visit with his sister Aubrey?
Yes, that was the only way he was able to see her.
So you're planning to bring Alex to a hotel to visit with Aubrey. Was that the plan?
Yes.
That didn't happen because you got drunk and got high and passed out.
I didn't get high.
You got drunk?
Yes.
And you passed out?
I don't remember passing out.
You don't remember Ms. Dikeman finding you passed out on the floor next to Alex that day?
No.
Do you deny that that happened?
I'm not denying it. I don't recall it.
Mr. Pedron, this argument began when you became upset at Josie for cooking hamburger meat that you had purchased.
I don't recall.
You don't recall at all why you beat her and strangled her that day?
I don't recall what the arguments were about.
You recall telling her that you'd kill her?
No, I don't recall that, but I have.
Mr. Pedron, on that day, do you recall placing your hand around Alex Xavier's throat?
No.
You're saying that that didn't happen?
Yes.
And if Josie reported that out loud in an excited utterance over a 911 call, she was just making that up?
Yes.
Now, Mr. Pedron, you agree that Alex was there the entire time, correct?
Yes.
And you agree that you would take Josie and push her against the wall and hold her by her throat, correct?
I don't recall that.
You don't recall ever holding Josie by her throat against a wall?
I have.
And is it your testimony, Mr. Pedron, that you've never done the same thing to Alex?
I haven't.
And is it your testimony that you've never been recorded doing the same thing to Alex?
I don't know.
You don't know?
I've not touched my kids.
Now, Mr. Pedron, on February 6th of 2023, you were arrested again, is that correct?
Yes.
You were yelling and screaming at Josie?
Yes.
You got violent with her again?
I don't know.
You told her that you wanted her to die?
I don't recall that.
You did that in front of all of her children?
I don't recall.
And you ran into the woods when the police arrived because you were scared of going to jail?
Yes, I have ran from them into the woods.
This is how you were behaving 4 days before your son died?
Correct.
Josie was scared of you.
Objection, speculation.
Sustain.
Mr. Pedron, was it your impression that Josie was scared of you?
Wasn't my impression.
You thought that she was perfectly fine around you?
She was.
Mr. Pedron, did Josie not communicate with you that she was scared of even going to sleep with you in the house?
I don't recall that.
Would that concern you if Josie had told you that she was scared of you?
Yeah.
And you're saying that she never told you that?
I didn't say that. I said I don't recall that.
In fact, she said it many times over the course of those videos that she was scared of you, correct?
Sure.
And Mr. Pedron, do you recall whether or not Josie communicated that she was scared of you in the 10 days or so before Alex died?
I don't recall.
You don't recall. Now, we'll go back to that in a second. Do you admit or deny that you would occasionally control Josie's access to her cell phone?
I deny that.
You deny that you would tell Josie to delete videos of you behaving like that?
I deny that.
You deny accessing Josie's phone and deleting videos yourself?
I deny that.
You deny taking Josie's phone and preventing her from talking to people who could support her?
I deny that.
And you deny restricting Josie's ability to contact her then best friend, Laura Lee Raines?
Yes, I deny that.
And you deny that, would you deny that even if your now wife testified that you did just that?
Objection.
Sustain.
Mark, I need Exhibit 207.
Your Honor, I'm going to object to this being hearsay.
Come on up.
So, Mr. Pedron, you deny taking Josie's phone and monitoring it?
I do.
You deny ever doing that?
Yes.
Let's talk about abuse of the kids. Do you agree or disagree that you physically abused Alex?
Disagree.
Do you agree or disagree that you ever physically abused any of the children?
Disagree.
Choked any of the children?
Disagree.
Threatened to hit any of the children?
I've threatened to spank my kids.
In fact, you've threatened to beat their fucking asses, right?
Correct.
Something that you said out loud in front of multiple different people, correct?
Correct. It was recorded.
Not just recorded, you did it in instances other than what we saw.
I don't recall that.
You don't recall threatening to beat your fucking kids' asses?
It was just recorded. It was played.
Mr. Pedrin, you've hit the children in front of other people.
No.
You've hit the children in front of Josie.
No.
You hit Alex in front of Josie.
No.
You hit the children in front of Becky Ehlers,
No.
Josie's mother. You hit the children in front of Ted Colkind.
No.
You hit the children in front of Jalen Barnes.
No.
You hit the children in front of Zayden Ehlers.
No.
You hit the children in front of Major Hellrud.
No.
You're saying that that never happened in front
Yes.
of any of those witnesses. You've previously admitted that you spanked Alex as well.
I have.
And you're aware that, or Mr. Pedrin, have you hit Major Hellrud?
No.
Do you admit or deny that you slapped Major across the face?
Deny.
Do you admit or deny that you were ordered not to discipline Major by the family court commissioner?
Yes, but I...
Sustain.
Do you admit or deny that that was you, Mr. Pedrin, in the video with Major sobbing in the closet?
Admit.
Do you admit or deny that you've told Major that he belongs in foster care?
Deny.
That you threatened to have him taken away from the family?
Deny.
Mr. Pedrin, did that happen on the same day that you punched Josie in the throat so hard that she couldn't speak?
Did what happen?
A conversation with Major about foster care?
Deny.
Do you deny the incident about punching Josie so hard in the throat that she couldn't speak?
Objection to vagueness.
Can you give
I'll rephrase.
Go ahead.
Mr. Pedrin, do you admit or deny that you punched Josie in the throat?
Deny.
Do you admit or deny that you punched her in the throat so hard that she couldn't speak?
Deny.
And do you admit or deny that you spanked your daughter Aubrey so hard that you left welts on her buttocks?
Deny.
Well, no, video. Mr. Pedrin, you made quite a few calls with Jenna Lovell. She was incarcerated, correct?
Correct.
You understand that those calls were all recorded?
Correct.
You understand that the state... Yeah, okay. Yeah, you understand that Ms. Love herself was actually interviewed?
Yes.
And you deny ever hitting Aubrey then?
No.
You don't
I
deny...
have spanked her.
Do you deny spanking her so hard that you left welts on her buttocks?
I don't recall that.
You don't recall that?
No.
Meaning to say that you could spank a child that hard and not recall it?
I don't recall leaving welts on her.
Do you recall threatening to, quote, whoop Aubrey's ass for drinking?
Yes.
That's what you're telling your children. You're going to whoop their ass.
If she drinking?
You
I wouldn't actually do it. I threatened it.
Now, Mr. Pedrin, I want to talk about that video with Brantley. You saw Brantley at that point in the video where he said that you struck him on the head, correct?
Correct.
And both Brantley and Araya were running up to Josie saying that Dad hit me on the head like this.
Correct.
You're saying that your children were lying when they reported that you hit them on the head.
Correct.
Mr. Pedrin, do you deny scaring any of your children with your violent and aggressive behavior? Is that a no?
I mean, I'm sure they would be scared.
I'd like to, we're going to put this in exhibits, our flash drive here, but this is a video that wasn't played this morning here. It's internally labeled as media Exhibit 20 here, but, oh, wrong one. Okay, stop. All right. You saw yourself in that video at, before we reversed it to the beginning?
Correct.
All right, and does that appear to be you that you saw a second later?
Yes.
And Mr. Pedron, I want to,
Do we know what number this is?
that's IMG 8812,
8812.
but we're going to put it on the flash drive with the other one.
Okay.
And then we'll label it as such. Labeled 20-IMG 8812, excuse me. All right, let's go ahead and play.
Where's my shit?
Don't have it.
Record.
I am.
Good for you. You just hit me in the head with a glass jar. I am bleeding still.
You would not get off
I have
me.
blood all over.
You pushed me and my kids
didn't
into the
touch
wall. Yes, you did, and you were punching
I
me.
didn't touch you.
Yes, you were, Derek.
No. See, that's you. That's what you do. You make everybody else to
You're
out to
belligerent,
be
drunk. You were
these
abusing
bad
us.
people when
You
it
were
is you.
abusing me and my son.
Your son looks fine to me.
Yeah, you pushed us.
Your daughter looks
You
fine.
pushed me while I was holding him.
You know what you do to my son?
Not a damn thing.
Oh, not
You
a damn
coerced
thing.
him, and I already have that
You treat
recorded.
him like shit because his mom.
You want to get out
hurt
because
you.
you're abusing my kids right now by doing
How?
this in front of them. So how about you stop?
But you are forcing
Braylee's
my
already
son to
scared.
sleep out there.
Nope, I never forced him.
Yeah, you are.
Nope, I already said he could go to bed.
When did you come
So how
and
about
tell
you
him
get
that
up?
he could come in here
I
and
don't
say he
need
loved
to.
him?
I told you that.
You didn't.
Told you I don't
Never
need to
did.
give him special treatment. I told you he could go to bed.
No, only Major and Jalen get
All right, psycho. Good night.
And Zayden.
Good night.
Zayden gets to stay at grandma's.
All right, psycho. Go to bed.
You're not psycho.
You are psycho.
You stole all my
You're
shit.
drunk.
You stole my phone.
You lost your shit. Now go.
You stole my cigarettes.
You're crazy. Go to bed.
I'm crazy.
You are. If Alex wants to go to bed, he can. I don't need to give you a special invitation.
I'm crazy because
Go
you stole my
to
shit.
bed, crazy. No one took your stuff. You're drunk. I didn't steal your marijuana. You lost it.
No, you stole it all.
No, psycho. You lost it. You're drunk.
Nobody can steal your fentanyl because it's strapped to your fucking chest.
Honey, I don't have
Or
that.
under the fucking... What?
Oh, wow. You look really crazy right now.
Where's your fentanyl hidden?
What fentanyl?
What fentanyl?
Yeah, exactly.
Yeah, exactly.
You're scaring my children.
You like to hide it under your fucking file
scaring
cabinet,
my
inside of it,
children.
above.
Daddy, I'm trying to go to bed.
Sad.
You know what's sad is you just sit there and do fentanyl because
You
you get
won't
it
let
from
my
Tad.
kids go to bed. You'd rather sit there and scream.
I'm gonna bust Tad back too.
Okay, psycho. Good night.
All right. Mr. Pedron, do you recognize yourself in that recording?
Yes.
I'd offer the recording for the purposes used in the exhibit. I believe it's 202.
Can you just give us what date was that? Do we have a date on it?
Would have been a media created date timestamp of 10/1/2022 at 8:32 p.m., Your Honor.
Okay.
Thank you.
Thank you. Okay.
All right. So, Mr. Pedron, another example of you completely out of control.
I wouldn't say that was out of control. We were arguing.
You didn't think that was out of control, sir?
Me standing there talking to her? No.
That was talking?
Yeah, that's how it. I don't consider that out of control.
Did you consider it out of control when you pushed and then punched Josie immediately before that video?
I don't recall doing that.
Well, that's what she says to you right at the beginning of the video, correct?
Correct.
She had to hit you with a glass bottle to get her off of you.
No.
You're saying that didn't happen?
She did not hit me with a bottle to get me off of her.
And she sounds congested, right?
Yeah, she sounded like she was crying.
And she said that she was in that state because you had just punched her while she was holding your son.
I don't recall that.
Now, Mr. Pedron, one of the things about this video is that at least one of your children are present in it, correct?
Correct.
And that was Brantley, right?
Correct.
And Brantley was laying right next to Josie, wasn't he?
Correct.
It wasn't uncommon for Brantley to sleep with Josie in her bedroom, was it?
No.
It wasn't uncommon for any of the kids to sleep in Josie's bedroom.
No.
It wasn't uncommon for Alex to sleep in Josie's bedroom.
No.
And Alex had an invitation to stay in Josie's bedroom.
Is that a question?
Did he or did he not have an invitation to stay in Josie's
I
bedroom?
don't recall that.
Well, Alex didn't have his own bedroom, correct?
They had bedroom upstairs.
Alex typically slept with Josie downstairs.
Correct.
And in front of your 5-year-old son, you're behaving like that towards his mother, correct?
Correct.
And your 5-year-old son has to tell you that, Dad, I'm drunk, you're scaring me, just go to bed.
I don't think he was 5 at that time.
Well, 4 then. That's what he said to you, right?
Correct.
Mr. Pedron, did it concern you at all that your 4 or 5-year-old child was able to pinpoint the problem with how you're behaving like that?
Yes.
You frequently, Mr. Pedron, accuse Josie of things that you know to be untrue when she's taking these videos.
False.
Well, you just testified on direct that you admitted on direct that you lied when you claimed that you had peed into a cup for Josie, correct?
I didn't pee in a cup for her.
Yeah, but you said that on the video despite it not being true, correct?
Correct.
And that would be the definition of a lie, would it not?
Correct.
And Mr. Pedron, you admit that you lied when you said that she was wearing a fentanyl patch, correct?
No.
You spoke with law enforcement about this very issue, did you not?
I believe so.
And you told law enforcement that you had no idea what kind of patch Josie had on. It was just something that you were suspicious of.
It was a fentanyl patch.
Mr. Pedron, did you or did you not say that to investigators when asked about it?
I don't recall.
And Mr. Pedron, did you or did you not tell investigators that Josie had a nicotine patch?
No.
Mr. Pedron, you lied about Josie poisoning you in one of those prior videos, correct?
I don't know if that would be a lie.
Well, you said that you had COVID, correct?
COVID went through our house.
And you claim that it wasn't COVID at all, that you were poisoned by Josie, correct?
Correct.
You're saying that that's not a lie, Mr. Pedron.
I don't know what it was.
You're saying something out loud where you don't know the truth of the matter at all. Is that your testimony?
No, I'm saying I don't know what I was sick from.
And Mr. Pedron, as you recall, you told investigators that your concern with Alex being treated differently was that he didn't get enough screen time, correct?
Not just screen time. It was overall, but yes, that's what was said.
So you said on multiple occasions things on these videos that you know to be untrue, correct?
No.
We've been through this, Mr. Pedron. Did you or did you not lie when you said that you took a piss test for Josie?
Correct.
Did you or did you not lie when you said that she had a fentanyl patch, knowing that you had spoken with law enforcement and given them a different statement?
That's...
That mischaracterizes the testimony, Judge.
Here's the transcript. Pedro, do you recall speaking with Investigator Fritz Leinfelder on February 21st of 2022?
Correct.
And do you recall Investigator Leinfelder asking you about Josie's purported substance abuse?
Correct.
And do you recall talking to her, or talking to Investigator Leinfelder about what she would supposedly get from Ted?
Correct.
Mr. Pedron, I'd like to look through pages 17 and 18, just middle of the page to the middle of the page, and the next one, let me know when you're done. Recall having that conversation with Investigator Leinfelder?
Yes.
Did you call Investigator Leinfelder asking you what kind of, quote, shit she would get from Ted?
Yes.
And, bless you, your response was, I don't know what it is. And Investigator Leinfelder says, like the patches and stuff you're, yeah, referring to. Your response is, I have no idea what it is. Adam Frederick, Special Agent Frederick says, okay. And then you respond, I would ask, she wouldn't tell me, end quote. Did I read that correctly?
Correct.
That's what you told law enforcement.
If you also read a little further,
Veteran.
it says fentanyl and morphine.
That's what you told law enforcement about the patch, correct?
Correct.
You've described to Jenna Love how you feel being around your children.
What?
You've talked to Jenna Love how being around your children makes you feel.
Yeah, I love it.
Did you tell Jenna Love that being around your children fills you with, quote, anxiety, aggression, and anger?
I do not.
All right, let's get the... when you're ready. Mr. Pedron, I'm going to ask you a question here about this clip.
Refreshing recollection.
He said he did not, so this is impeaching.
He said I don't remember.
All right. Well, we can refresh recollection outside of the jury if that's what you would like. If you're saying you don't remember, Mr. Pedron.
I don't think it's what he would like, Judge. I think that's the
Okay.
procedure.
Did you?
Yeah. Sorry.
Ask the question again.
Yeah. Would viewing or would listening to a recording of you using this language help refresh your recollection?
No.
Hearing your own voice?
Well, yeah, it would.
All right. And
I don't recall saying that to her.
And if I were to play this recording to you, would that help refresh your recollection?
Yes.
All right, Your Honor.
All right. Ladies and gentlemen, we'll just have you step out for a bit, and we'll have you come right back in. Okay, just let's take a seat for a second. Before you play this.
What's that?
Before you play this, I don't know how often this is going to happen, partially probably because it's not predictable. We have to come up with a better system of doing this. I mean, if we can get transcripts of these things, then we can refresh recollections with transcripts. The other thing is, this is going to be it right now. We're going to end after we're done with this process. We'll just take a break for the day. I do want to talk to you both about both sides. I meant looking at two of you before we end up. Yeah.
Break for, you mean after this process is done, we're done with testimony for the day, or?
Yeah, we're going to be done with testimony for the day. I don't want to get too late. I think it's a long day for everybody, including Mr. Pedron. So why don't we do the refresh recollection? We'll bring the jury in. After we do that part, I'll probably excuse them for the day. Is that agreeable for the state?
It is, Your Honor.
Okay, defense?
Yes, Your Honor.
All right. I'll have to come back tomorrow, so. All right.
And Judge, before this is played, if we could get some indication of date and time of when the statement's from?
So the materials as we got them were completely undated. It was just a huge dump of phone calls from Ms. Love's incarceration. So I don't have a date and time, but I can give the file name. It's a very long file name. If we can. And this is a clip from that file. Most of these calls are quite long.
So this is the clip from the original file?
Yes. And we can give the original file.
Yeah, Judge, our problem is it's a 20-minute clip of a longer conversation, so we're not getting any context here for Mr. Pedron.
Yeah, it's 20 seconds, but I mean, my intention would be just to ask him if that's his voice, and if he, yeah, the full one is 30 minutes.
All right, so let's identify the overall clip by, is there just the first 5 or 6 digits? Can we just use that? There's
Probably the last digits are more unique.
Yeah, the last digits are BEE 34B900A3.
Okay. And was it recorded? Let me ask, do they just have one date for all of them because the user downloaded in the same day or something?
It came in just a huge format of all of the audio files, completely unorganized, completely unlabeled.
I assume the state has these.
Yeah, does it say the date and the time at the beginning of the call?
Judge, I think this would be my suggestion. If you're thinking about breaking after doing this, maybe we break for the day before doing this, because this is 20 seconds of a 30-minute call, and our response is going to be objecting because there's no context, the greater context of when these comments were made. I think he at least should have an opportunity to know what the context was for him making this.
That makes sense. So let's do this. What we'll do is we'll bring the jury back in. We'll have a break. We'll try to start up about here. Maybe you two can, the two sides can talk, figure out where this is, what context. Maybe we can do a better identification of where these are coming from. So let me bring the jury in. We'll just tell them we're done for the day, and then we'll come back tomorrow morning I'll tell them 8:30, but start up by 8:45.
My only other request is if the defense has any more small snippets of those large calls, I'd like to have those identified tonight so that we get context.
Yeah, I agree with you. We need some identification somehow, but let's get the jury out of here. Actually, Mr. Pedron, why don't I give you a break? You can step down right now. I'll just let them know we're going to take a break right now, okay? Go ahead and remember, don't talk about the case. All right, thank you.
8:45 tomorrow?
Yeah, just make sure, just
I'm
check.
sure you're at 8:30, Derek, just to.
Yeah. Okay, why don't we bring the jury in, we'll tell them what's going on. All right, everybody have a seat. So we realize we need to spend a little more time just identifying some stuff right now. So rather than make you sit around, I'm going to just have you, we're at 4 o'clock anyway. Today's a good time. This is a good time to break. One thing I'd like to remind you, please don't talk about the case. I know it's hard not to think about the case as you've been sitting here, but I'd ask you, read a book, do something else. Get your mind off of it. Enjoy a walk, anything. We just sort of need your fresh eyes tomorrow. If there's anything you need, let us know. Again, you're welcome to bring waters or whatever it is that you would like to drink. Otherwise, by the way, if you're sick of drinking water, you're welcome to bring something else. Hopefully not a pop can. But otherwise, I want to thank you for your diligence today. It's been a long day. We will see you tomorrow morning around 8:30. As soon as you're up and ready to go, we can probably get going. So have an enjoyable evening. Take care. All right. Everybody may be seated. Let me just, so I don't feel rushed about what we just talked about. If you could talk to each other about those phone calls, I guess, from the prison and how to identify them.
We can talk about it, Judge. I assume there are larger file names. Like my issue with it is that this is permissible in cross-examination. I don't want to necessarily disclose all of our pending impeachment cross, but I'd be happy to work on identifying what the videos are.
I think you have to know when you're taking a clip which phone calls you're going to be using. Wow, this is interesting because there was a case recently in the Supreme Court, I think, that came up on this issue about telling people, as defense attorneys, not to talk about the testimony. I think Attorney Rude knows this because it just came up recently in a case. I understand. The thing is, to make this work smoother, I need you. I don't know any way of doing this.
Judge, yeah, and I mean, like our plan is impeaching in response to certain statements, as Ms. Dikeman has a constitutional right to do, and doesn't have to disclose that to the state in advance. I'm happy to identify some of these larger files. I'll tell the court that there are probably thousands of them, and that there's just no way to transcribe them all. And
No, I understand. What I'm saying is that I can't imagine you are probably going to use only 3, 4, 5, 6 of them. If you can just identify the larger files.
I mean, we can take a look. It's obviously going to depend on Mr. Pedron's testimony.
Right. Are these files like go over multiple days or something? Or are these files like a day? Because you indicated, Mr. Torbertson, that like at the beginning of the file, it would identify the date and time.
I should say the date and the time of the phone call at the beginning of the call.
Yeah.
Almost always do.
Yeah, we might be able to identify that. I think some of them were more identifiable than others, but yeah, we just got. I think the state produced basically every phone call that she made while incarcerated, so that's the amount of data we're looking at here.
Yeah, I think if you gave the date and time, that gives at least the opportunity to start listening to it for context.
Judge, this is what I would say. If they send me the calls tonight, I'm not having a conversation with Mr. Pedron about those calls or playing them for them in advance. The reason why I want to be able to listen to them is because when you're playing a 20-second snippet of a 30-minute call, there's a lot of context to hit those statements that he's making, and I need to know those contexts to effectively address it in redirect examination. Otherwise, we lose that ability. So Mr. Pedron's not going to have any advance notice of these statements or what the recordings are. I barely have time to listen to them tonight. I mean, Ms. Rude and I are going to try and divide and conquer, but we're certainly not going to be meeting with him and playing the sequestration order in place. So they can provide the calls to us, and the right to confrontation still is wholly in place for Mr. Pedron because he's not going to know the nature or content of these calls.
Judge, yeah, we'll do our best to get file names, I guess, for the calls. We got the calls from the state, so they should have them, but we can give them file numbers. I can say that it's going to be way too large to email, but
File numbers is great.
Perfect.
Yeah, if you can give file numbers, that will do it.
probably it won't be until a little bit later tonight that we get a list.
Like midnight?
Not sure we'll go that late.
All right.
I'm not a real big fan of that Supreme Court ruling, by the way, but that's beside the point. Because I think it interferes with people's ability to talk to their witnesses and stuff. But I could do it, I guess.
Judge, do you know what the name of the case is? I remember seeing that.
I'll email it to you.
Yeah, yeah, I can't remember. But I know it within the last 2 months. Yeah. The other thing is, so 8:30 tomorrow morning. Anything else tonight? Since you were finishing up with your cross, how much longer in your cross?
It's quite a bit longer, Your Honor. I can't tell you how long, but it's going to be a while.
Okay. That's why we need at least an extra half a day. So anything further from the state?
Judge, I asked Attorney Zacher the exact same question. He said 2 or so hours. I don't want to speak for him directly, but with that information and redirect, I'm starting to think we may not have witnesses available until tomorrow afternoon, additional witnesses. I just want to put that on the record for timing purposes.
I think that's a fair guess. I mean,
I would estimate probably more than 2 hours, like, frankly.
Okay. Well, let's try to make it 2 hours. Anyway, to a certain degree, avoid the redundancy. At some point, things get very redundant, and everything's been said over and over again.
I understand that, Your Honor, but this is Ms. Dikeman's.
No, I understand her right to have cross-examination, and she does. She has a right to a full cross-examination, but at some point, it's asked and answered. So, anything else from the defense?
Oh, Your Honor.
Anything further from the state?
No, thank you.
But if we were to leave some of our materials, we don't need to look back in here. Can we just lock it in here?
We will be locking up the room. Nobody's going to be coming into this room between now and tomorrow except for security. That's it.
Okay. Thank you.
And ourselves. Thank you.
Have a good night.
Okay, everyone. That is it regarding the. So this was Derek's testimony in the trial of day 2 of the secret in-home trial, Wisconsin versus Josie Dikeman. So that, and tomorrow we'll see. There'll be, it'll be ending tomorrow, so there'll be closings tomorrow. We'll see how that goes. We'll be airing that tomorrow morning. And so at this point in time, the stream is over with because it is, this part is done. All right, so thank you everybody for tuning in and watching and hanging out with us. And Thank you, friends, having me. It's been saving grace. Thank you all the way, friends. I made it through. Made it through you. Oh, I appreciate it, Saul. We definitely are honored to have you with us. So thank you, everybody. And Murdaugh is going to have a retrial. I was told this morning by someone I know that is in the region. And then Moki and I are talking about it a little bit later. So that is some wild stuff. We're going to definitely air that trial. So, yeah, see you in the garden, Saul. And thank everybody for tuning in with us. It was a pleasure. And peace. Oh, yes, Lori, you have a great evening as well.